Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota, and StreamYard. StreamYard can catch on fire for all I care right now. Oh my gosh. What a disaster. What a disaster it was. I had to reboot my computer. It just decided to no longer accept the camera or the audio. Any camera or any audio. Just decided, no, we don't need those. We don't need those at all. What the fuck? So anyway, we got it working now, I guess. What is up? It's going to be one of those days. Do I have these in the wrong years? Yep, there we go. That explains it. Okay. Yeah. You can keep saying muted. Again, I can see when the volume is working. Okay. I have checked. There hasn't been anything yet as far as the hasn't started up yet. A second ago when I checked. Oh, and so then after I rebooted, it still wasn't accepting anything. So that was stupid. And then I closed the window and reopened it again, and it did again. And it worked. That's all. That's it. That's how it goes. That's how it goes. Milwaukee, it says there's a little school closings warning. Schools closed possibly due to bitter cold. It is freezing. Like it is dangerous levels of cold outside. We're all the way up to like -4. Oh, okay. So here it's dangerous levels of cold. In Milwaukee, they're probably getting what we had yesterday evening, which was -18. God, what a mess. Oh. Hell finally froze over. Yes. Yeah, that's correct. Correct. Okay. Let's see. So today we've got the final parts of Theodore Edgecomb. Closing arguments will happen after jury instructions. Oh my goodness. He is not up on this one. Let's see if he's up anywhere yet. I don't think so. Sure, Law and Crime has the courtroom stream going with the picture of the fucking, you know what I mean? Go away. With the picture of the flag up. Checking right now. They have the old man's portrait up. That means they're usually about to go. So again, I'm still looking for that sweet coverage, wherever it may be. Oh. Okay, we do have a couple super chats that came in. Let me read those. People were saying that I missed super chats yesterday. I thought I got all of them. I don't know how. If I missed yours, I do apologize. There's not like a check mark, a checkbox thing to knock them out as you go. It would be really helpful if there were, but that hasn't been implemented yet because Pretty much because YouTube and everybody else, none of them understand how super chats like work. I guess it's a weird thing to say. That none of them understand how super chats work, but they really don't. And so they don't build in the tools to maximize engagement between the creator. Because right, YouTube cares that a super chat comes in, and they state, that it doesn't mean anything. Basically, that it's just you sending a thing, and that's all that matters. So there's no like agreement or anything created. So they don't care what happens after the super chat comes in. But I do. I like to read them. I like to engage with them. I don't like to miss them. That makes me feel it makes me feel like someone sent money and then didn't get what they were looking for, which to me is dumb. So anyway, I like to try and read them. It would be great if YouTube would understand what gets people to actually engage with super chats and give us tools to help accomplish that feat. You could set up Streamlabs, couldn't you? The Streamlabs super chat tracker, I didn't actually personally like. I'll probably be playing with a full-on OBS setup soon because StreamYard has been pissing me off lately. And OBS has some ways to do what StreamYard does. It's just a little more complicated, but we'll see. We'll see what to do. I don't know yet. Nobody made the perfect streaming tool. Nobody's made it yet. Iker1096 says, question, he's scared of the two in the SUV. Didn't they get SUV number 2? Didn't they get there after the shots? Why didn't the state bring up race? All the name drops. Ray Alexa. He was scared of SUV. The red SUV got there after the shots. That is true. But the SUV I believe he was responding to was the Rod Trell. What's his last name? Carson or whatever. Rod Trell's car was right behind the immigration attorney's car. And I think he may have been there. I think he might have been there right around the time of the shooting. So he also could just be wrong. And remember, his narrative is that a posse of white men were coming to kill me. Jesus Christ. Okay, just a second, guys. I got this cat in my office. Here. See? I got a cat. This is Button. He's very sweet. He loves scratches on his face. But he's not supposed to be in here. Oh, it's okay. Okay, just a moment. Let me get my headphones back on. Whew. All right. The other, possibility is that he's just incorrect because he was lying, right? A mob of my recollection was a mob of people were going to murder me. Therefore, I needed to defend myself is a very convenient narrative. Especially when, if you don't have to match up those facts. So, oh gosh, how did Button get his name? Our kids named all our cats. We have Button, Ninja, and Lion. We also had mouse and panda. I mean, these cats got they got given away. There was a litter of 6. So it's mouse, panda, lion, button, ninja. God, there was one other one. I don't remember. I think the other one was named by Lady Rackets or something. All right, sorry about that. I can taste fried food, says Justice for Ashley. And also says late and acting to defend himself. Thank you. Automata says late, and could you repeat the question? Alex McCarmy says, or McCammy says, after watching the live stream last night, Alex Jones should have asked them to repeat each question 3 times, then assert the 5th. Yes, he should have. He should have done that. That would have been better. Come on. Okay, still no trial. Still no page. Again, Fox 6 and Wisconsin WISN, they are the worst about putting the stream page up ahead of time, which is, I don't know why they wait until literally the last possible second to put up their live coverage page. Doesn't make sense to me. I mean, I might start late, but the page is there the majority of the time, unless something really weird happens. Baffled Buffoon says, wish I could give more. Thanks for the daily laughs. Oh, hey, it's very appreciated. You don't have to ever wish to give more, but I appreciate it. Thank you. Mephisto's movie review says, just use restream.io like I do. You can check it out if you set a date with me on the movie podcast. I used Restream a long time ago before they had their own streaming thing. It was it would just use OBS and stream it to multiple places. I looked at Restream, I looked at Melon. They all seem to function the exact same. None of them are perfect. There's sacrifice everywhere. That's just how it goes. Skeleton says, Your Honor, at least my client, Miss Chandler, is not the worst Chandler out there, as their mother survived getting eaten like groceries and is here to testify today that the merge is real. There you go. Diz5 says, look into Sennheiser IE900, the best headphones. No. I've got in-ear monitors coming. I don't want big, like over-ear cans. I wear them too long. Brian Miller says -36 Saturday in Grand Forks, North Dakota. That's terrible. Justin P says Dinosaur Jr. is the most underrated band of all time. Next we got Kathy Zapp says, Nick, did you hear when Edgecomb slipped and said he left the scene of the murder? You guys were talking and he was looking to his attorney for what to say. The entire cross. Yeah, I think someone else sent that to me too. He was so overly cautious in referring to the scene of the crime. And someone yelled at me in email saying that if he had listened to us dummies, he would have admitted to murder. Theodore Edgecomb is admitting to the killing. He's admitting to the killing. That's part of the self-defense claim. It is not a mystery who shot Jason Cleereman. Did I not share the drink? I thought I shared the stream. That's why I was like, why isn't anybody joining me yet? That makes sense. Okay. Oh boy. I thought I did that yesterday. Here's that. Just trying to find the group on Civil. I see you there. Name this stupid group. There you go, Uncivil. My apologies for not sending that sooner. The only reason is because I thought I already sent it. Okay, here we go. Sending out this link like it's free. Oh my goodness. Hey, what's up, dude?
Hello.
Sorry about that. I'm like, I wonder when people are going to join. And then as it turns out,
Made it hard.
Yes. You were supposed to guess at the URL. That's what you're supposed to do. You were supposed to just guess
the 12 random letters and numbers. Yeah, that's gonna be tough.
The case sensitive 12 random letters and numbers of the URL. I don't. Where's your dedication? You weren't just putting them randomly in, looking for the one StreamYard link that you didn't even know if existed yet. It's perfect.
So you're getting some in-ear monitors. The ones the earphones you already have are quite nice. So why are you getting something different?
Well, I ordered custom ones. It turns out I have narrow ear canals. So I ordered ones that they mold actually to your ear canal, and they came recommended from a friend of mine who does who is a recording artist, right? And does this for a living. He says when you have them, you don't feel them at all. They're just in there, and they're wonderful. So that's why I ordered some of those.
I did that once. I think I still have them somewhere. I think they're Optromic Research. They're called. They make hearing aids as well, kind of high end stuff. And I got the custom ear molds. I'm not the earphones themselves are a little weird because their cord is like so heavy and stuff. It's a little weird to wear sometimes, but yeah, I got something like that.
Yeah. So that's why I did it.
Maybe I'll go dig those out of whatever pile there, and since I paid a pretty penny for them in the first place.
Yeah, I don't know. The ones, these are really nice quality.
Yeah.
The other one should be better quality.
Well, we'll see. You could get molds for those. Take out the yeah.
Well, I've already bought the other ones. I just need them to get made.
I also can't say how good it is, but I know that you can get, like, on Amazon, you can get the stuff to like custom make your own as well for earphones. I don't know how good that is because I've never used it, but there are options. And if you don't want those earphones anymore, let me know.
I can guarantee if I did them myself, I would ruin it.
Yeah, that sounds about right.
That's what I know. That's what I actually know.
Yeah.
Goodness gracious. I hate how long it takes them to get these damn pages set up. It's really, really frustrating actually. Just get the damn link going so I can make sure I'm there when the court starts. Where is this? What the hell is this? Okay. There we go. Hey, what's up, Andrew?
Hey guys, how's things going? Hey Nick, you got a stream for the court yet?
Not yet.
Yeah, okay.
I will send it as soon as I can find one that's up. Long Crime always has a stream up. Oh, here we go. It says 15 minutes ago, motherfuckers. This was not findable 15 minutes ago. Just there's nothing on it yet. But here we go. I'm tweeting it or twittering it to you now.
Okay.
Sorry for the late link to this show. I thought I had sent it out last night, and turns out I did not. So that's why it wasn't available. Thank God Kurt started to bully me in the chat.
No worries.
How you doing this morning?
I am awesome.
That's good. Here we go. So there's the eagle, the majestic flagpole eagle of Wisconsin flagpoles or whatever. It is there. I'm just reading through super chats. And I got an email from someone yelling at us that if maybe I should just find it and read it, but that if he had listened to us dummies, he would have admitted to murder at the hands of the evil prosecutor, which I found particularly interesting because he's admitting to the killing. Like that is what he's doing. That's the theory of his defense, is that he is the killer. However, he is justified in that killing. And
Yes.
so to be
you
yelled
can't
at
simultaneously argue, folks, that it wasn't you. You have an alibi, but you also shot the guy in self-defense. So the legal defense of self-defense is a defense of confession and avoidance. You confess to the underlying conduct. You seek to avoid criminal liability on the basis of justification. If you deny the underlying conduct, you can't justify conduct you're denying.
Yes. I'm trying to find it real quick. Of course, it could have been. Oh, if it might have been a DM instead of an email, which would have been. Let's see. And let's see. Yeah, I bet it was a DM, which means I'll never find it again. Because DMs disappear and go to die if you miss them too early. If you miss them, so that's unfortunate. But
I'm not sure.
Long and short,
unfortunate.
it's not that unfortunate. Yes. Okay. Yeah. Oh well, whatever. Anyway. So yeah, just waiting on the court to get started. I assume they're hashing out some pre-trial, or pre-hearing issues before they bring the jury in to read the instructions. I wish the cameras were on, when that happens. I think some interesting stuff has happened off camera in this case, but we are at the mercy of the courts. So
maybe the defense has some sonogram images of Edgecomb's children in utero that they'd like to present to the jury as relevant to this case.
Oh God, one would only hope. Your Honor, we've compiled what we did was we went on Google Photos and we compiled a playlist or a slideshow of Edgecomb's children to show all of the places that they went where they felt threatened by white people. Throughout their entire lives. And we would like to play that now to play into his state of mind over the entire course of time that he has had children.
Yeah. I was writing up the yesterday's proceedings this morning for the Law of Self-Defense members. And it's like, all right, so why did you punch this guy? Racism. Why did you flee the scene? Racism. Why did you shoot him in the face? Racism. Why did you think you were facing a deadly force threat? Racism. Why were you a fugitive for 6 months? Racism. Why did you lie to the Kentucky State Trooper? Racism. I mean, that's the whole defense.
Oh, it was a YouTube comment, and I misrepresented the point completely. Well, here we can go ahead. I can go ahead and I can find that. Response.
The jury will get the self-defense instruction, folks. The rest is just legal fantasy.
Do you know that for a fact?
No.
Or you just...
He's just confident.
He's just confident. Confidently wrong.
Okay, here we go. Here's the comment. Okay, I don't want to misrepresent things. It says Edgecomb was exactly right not to answer questions with false assumptions in the question. If you geniuses were up there and actually followed your own brain dead advice, you'd implicitly admit to murder 20 times in front of the jury. Quote, after the homicide, did you run? Yes. After you shot him in the head for no reason, did you run? Yes. Well, okay. First of all, he didn't say shot him in the head for no reason. I don't believe. But second of all, after the homicide, did you run? Yes, that was true.
That's a homicide, folks.
A homicide does not mean a murder. It does not admit to underlying facts or state of mind about it. The this idea that he looks good by evading questions about after the homicide, did you run? Do you honestly think he looked good doing that? He looked evasive. He looked untrustworthy. He looked uncredible.
Hey, how are we with book shipping, by the way? Oh,
hot Mike. We almost had him. But do you think he looked good doing that? To me, he did not. To me, I look at that guy and I say, I don't believe a word he's saying. They know he ran. Everybody knows he ran. So asking him, did you run after you shot the guy? Yes. Did you pick up your bike and go down the steps after you shot the guy? It's on the video that he picked up the bike and went down the steps after he shot the guy. What benefit is it to him to say, could you repeat I don't understand. Could you repeat the question 50 times? He did that 0 times with his own counsel. It's amazing. His hearing issues, his comprehension issues, all resolved when he was with his own counsel. He looked evasive. He looked bad. And admitting that he picked up the bike and went downstairs after he shot a guy. His whole thing is that he shot a guy, or it's that he didn't shoot a guy, which could tank his self-defense case. Because even if he gets the instruction, the state is going to argue in the state of Wisconsin, you must find intent, the intent to self-defend. You cannot accidentally defend yourself from a deadly force threat. That is not justification. That is something else entirely. Mr. Edgecomb did not intend to defend himself by his own words, which means he shot this man. I mean,
yeah. I think there was one state question where Prosecutor Huebner built the word murder into the question, but Edgecomb, hesitated, and Huebner immediately withdrew the question and rephrased it. So, and I would not have recommended Edgecomb answer a question with murder embedded in the question. That would be
right. And his defense team should have objected. Called for a legal conclusion. Murder's a legal conclusion.
I don't think it even came to that because it was retracted and corrected so quickly.
Right. So anyway, but I did not mean to misrepresent your comment. I don't think I actually did misrepresent your comment, frankly. But if you think I did, it was not intentional. I was going off of my memory. But thank you for telling me where it was so I could get the accurate and exact comment. Uh-oh, here we go. We're on the record, baby.
Grand shooter for the state.
Warrior Honor, Untitled on behalf of Theodore Edgecomb.
Lamar on behalf of Theodore Edgecomb.
Mandy said, bring back button.
As we argue, grab the microphone, use it, please.
Anikamad, that's a name you can say quickly.
Let me crank up the volume here.
Versus Theodore Edgecomb, 20 CF 3535.
Appearance just after 9 o'clock.
Grand shooter for the state.
Warrior Honor, Untitled on behalf of Theodore Edgecomb.
Lamar on behalf of Theodore Edgecomb.
Mr. Huebner, so it doesn't get ugly as we argue, grab the microphone, use it, please.
Oh, sorry, I put it up on the. Trying to be proactive. I apologize.
All right, it's just after 9 o'clock. The jury's back. There's possibly 1 or 2 things to discuss. Then I'm going to instruct the jury. Both sides will make closing arguments. I think the state suggested an hour. The defense suggested an hour and a half. I'll allow up to an hour and a half maximum. That's a hard stop at an hour and a half. Again, both sides hopefully are aware that you don't necessarily have to use the hour and a half, and sometimes, if not most times, not spending too long.
It's not the LSATs, folks.
Closing is advisable. We discussed yesterday the instructions that the state submitted. I don't know if either side has anything to add on that. I believe it was the defense that drafted a proposed additional instruction. Is that correct?
That's correct, Your Honor. I made some additional edits after speaking with Attorney Huebner. I'm about to email our final draft of that to the court and to Attorney Huebner. I don't believe
Now
there's
he's emailing it?
on
About to email it now?
Well, I guess I need to see the final draft, but Mr. Huebner?
Your Honor, I don't necessarily have an objection to it. I just raised the concern that the defense counsel's version had the court explicitly telling the jury about the tragedy in Waukesha, which I thought was potentially.
Is no way going to happen. I don't need our argument from either side. No way on God's earth am I going to allow a sentence that says, finally, evidence was received that the defendant was on bail at the time of the charged offense. Any recent events in the neighboring county of Waukesha shall not affect your deliberations in any way, and you are to decide this case solely based on the law and facts presented to you during the trial. Mentioning that situation in Waukesha, I presume, obviously, that's a reference to the Brooks case, arguably one of the biggest tragedies and worst crimes this city, or I should say state, has seen in the last decade. I mean, no way. It's hyperbole. It's inflammatory. It has nothing to do with this case. It would potentially distract the jury. Not a chance.
Not a
As long as
chance.
that's out. Let's get me the revised version, please.
Your Honor, can we get a jury instruction on social justice?
Your Honor, we want to go ahead and put in there a reference to the lynch mobs of the 1850s. We think that would be beneficial to talk about how the southern states would have northern states hire posses to round up African Americans who had fled from the plantation and often would just kill them and return them a monetary value rather than the person themselves. Your Honor, that's what we want in there. Is that an okay instruction for the jury to have when they're considering? What are you talking about?
As far as the special instruction, the second paragraph that's proposed and the third paragraph, I don't particularly have a problem with. I think they accurately portray the situation and accurately state the law. I want to hear the state's position on the first paragraph. The first paragraph reads, evidence was received in this case that the defendant had other open cases at the time the offense was committed. You are not to allow this fact to affect your deliberations on the defendant's guilt or innocence as to the charged offense in any way. The state want to comment on that? You know, my concern is the defendant discussed some of those open cases because, as I said yesterday, he clearly opened the door. I think the defendant feigned ignorance on his multiple criminal cases. The parameters were drawn multiple times by this court in pretrial motions and in conversations off the record. And the defendant on multiple occasions, I think, feigned ignorance or was making a speech to the jury saying he knows nothing about the fact that he had two criminal cases with two separate criminal defense attorneys. So it goes to veracity. So saying that that's not a factor, I don't know.
Maybe, Your Honor, then the best way to do it is to leave the first sentence as is, and the second sentence should just state that evidence was received only as it applies to the defendant's credibility, and it should not be used for any other purpose.
I think that's better. It's a credibility determination, Mr. Ahmad. Your client put that in issue. His credibility was put in issue by his repeated denials and repeated conflicting testimony. It is an issue. It affects his credibility. So if you want to modify that sentence, fine. I want the jury in here. I want to instruct them. I want closings done. Say that again, Mr. Huebner, please.
Say it again.
That evidence was allowed only as it pertains to the defendant's credibility, and it should not be used for any other purpose.
I think with that modification and the other modification to the last line, it's acceptable, and I'll give the instruction being requested by the defense with those two modifications.
Now there's a proposed instruction from the state that just says he's guilty and you know it.
Other issues, Judge.
If he's guilty and you know it, clap your
Closing
hands.
Instructions.
I have the brief.
Number one, we are requesting, based on the case law, an instruction for negligent homicide.
How do you have negligent
That's under
homicide and
1175,
self-defense?
homicide by negligent handling of a dangerous weapon.
Presumably they mean
Testimony or
reckless.
the basis
really.
for that is the During cross-examination, I believe there was some clarification questions asked by Attorney Hubner about how the gun had just gone off, and then
Counsel, I apologize for interrupting. Then arguably we take self-defense off the table, and I won't instruct on self-defense.
There's the trade.
so Judge,
Then it's just an up or down, guilty or not guilty on the counts. Because your client, I mean, arguably, as I thought about the testimony yesterday, there were statements made by your client that could lead a jury to at least consider and possibly believe the self-defense claim. But as you know, he repeatedly insisted on direct and cross that yes, the gun just went off, acting like it was somehow an accident. So I'll hear from both sides, but I don't see how negligent homicide
If you want to lose the self-defense instruction, this is how you do it.
fits
Withdraw
With-
the request right now.
Yep.
self-defense.
You might win. You might win your argument that negligent comes in.
Well, I think Mr. Ahmad wants to finish his argument, and then I'll respond, Judge, if that's okay.
Okay, go ahead.
Judge State v. Carroll Watkins, 244,
Oh,
Wisconsin, second 205. It's a 2002 Wisconsin Supreme Court case.
It's a
It was
bold
a review of
strategy.
a decision of the Court of Appeals, and basically the Wisconsin Supreme Court said those two concepts are not.
They want their
mutually
cake and
exclusive,
to eat it
which
too.
is specifically self-defense and then negligent homicide. If there was some facts in that case where the court found that there was a basis for both, and that's just an issue for the
Everyone
trier
should
of fact.
replace the word negligence
That was
here
a
with
court
recklessness.
trial in the original case, but essentially it's no different. It's a jury question as to how they want to resolve all of these charges. They're already going to be receiving the lesser includeds, so they're going to have already 4 different homicide degrees to consider. There is some evidence under the some evidence standard also if they decide to resolve the case for an accident, according to the defendant's testimony, which is testimony that was developed further by the state, then I think that's also been put into issue. I think the state's argument, Judge, is going to be that, well, in the Watkins case, there was first some assertion of the threat of force, and followed by then an accident occurring perhaps from a struggle between the parties. In this case, the facts that would support that would be there was some testimony about Mr. Edgecomb telling Mr. Cleereman to stop, and then he approached, and then Mr. Cleereman had his fists up, and we saw the video, and we've seen that many, many times in this case.
But he's not charged
There's a
with
lunge,
brandishing
and then
or
there was a
aggravated
very
assault with a
quick
firearm.
discharge of the weapon. I think there was some evidence that there was a showing of the threat of force, and obviously it's not the same exact case, but there is a basis to have the jury also.
It's not
look
close
that
at all
charge and
to a struggle
consider
over a
it in
gun.
Nope.
deliberations.
First of all, Your Honor, I don't believe if you are to go to accept what defense counsel is stating regarding the Supreme Court case, it's not the same. In that case, what happened was the individual pointed the firearm in a deliberate show of force. This defendant, according to what the defendant all of a sudden came up with at the 11th hour, was that he didn't. He says stop, but he never shows the gun. He never points the gun. He supposedly has it down at his side. And then he doesn't even necessarily say, defense counsel, I think, was trying to get him to say that he aimed it. Never necessarily even said that. He says he backs up and it goes off as the victim is supposedly lunging or trying to spear him to get the gun. I also do not agree that the video shows a lunge. The video shows the victim literally collapsing.
I do not see a lunge on any of the videos. I did not see anything that was close to a lunge. The jury's the finder of fact, but I did not see a lunge.
I mean, it's up to the jury. But based on these facts, Judge,
The judge is the
Though
finder
they-
of
in
Law.
that
some
case,
level
they're
of
not
fact
mutually
for
exclusive.
jury
In
instructions.
this case,
More
they
than
are.
zero.
There is not a situation in which what the defendant testified to is consistent or even comes remotely close to the intentional use of force or even show of force. According to him, he didn't do anything. So they are mutually exclusive, even under the case that defense counsel said.
Don't say it, counselor. Don't say
So-
didn't do nothing.
self-defense would not apply if you have this negligent homicide. I would just also note that in order for a jury to acquit on second-degree reckless, which is they'd have to get all the way down to second-degree reckless, no utter disregard for human life, no intent, they get down to second-degree reckless. In order to get from second-degree reckless to homicide by negligent use of a dangerous weapon, the only difference between those two is reckless requires, and just so we have it 100%, that the defendant in that situation was aware that his conduct created unreasonable and substantial risk of death or great bodily harm. In negligent, it's just that he should have been aware. Well, he admits to having weapons training. He admits to knowing that there's going to, about the weapons.
Read that distinction again, please.
Sure, Your Honor. I pulled up let me just pull up the actual jury instruction that separates the two of them. Because if
there's
we're
negligence with a gun, which is really recklessness.
Difference between criminal reckless and criminal negligence.
Disregard.
This is from the jury instructions. Both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal reckless requires that the person engaging in the conduct be aware of that risk, while criminal negligence requires that the person engaging in that conduct should have been aware of that risk. In this case, I don't think there's anything that puts that portion of it at play. As to the difference of whether or not the defendant did or should have known. He states he has weapons training, and I don't necessarily know that's in play. I would just note, if defense counsel was going to do this, the least thing they could have done is draft it for us. If the court wants to add it, I'm working on it now.
I agree with the state. I don't think under that case, I don't think it's the same. I don't think it applies. I don't think it applies based on the facts and the testimony. The state makes a salient point somewhere out of nowhere on redirect to defense questioning. Somehow, I think it was a surprise to everyone, the defendant says he has weapons training. That's a very salient point. I'm not giving negligence. If the defense has given or modified that last sentence or two on the special instruction, email it to my clerk, e-file the final version. I guess you can e-file the other versions just for the record. But then I want to bring the jury in and give them the instructions, which will take a bit, and proceed to closings. Did the defense modify that special instruction, please?
Yeah, I did, Your Honor, and I did e-file that and submit that.
I added the words "not guilty."
Hang on a second.
I'd like a
If you
not
read
guilty
this
jury
sentence
instruction.
without catching it, then he's not guilty automatically. Gotcha. Oh my gosh.
I did e-file it.
He asked you to e-file and email it. Okay. Koi 540 says, I'm struggling with an idea. Due to the level of destructive power social media companies can and do wield against people, should the U.S. throttle internet traffic to all partially or fully foreign-owned social media companies? No. No. That's I don't see why we would do that personally.
The answer is simple to social media. Either make them public utilities, so they're not responsible for any, they don't exert editorial control over their content, or make them legally responsible for exerting editorial control over their content.
Yeah, one of those two is certainly the way to go.
And or make them pay for the use of private data.
Yeah, or something akin to a common carrier type restriction. The Thomas, Justice Thomas, Clarence Thomas. Oh my gosh, Clarence Thomas approach. We do this in where we give them immunity from liability for certain things on exchange that they then host the content with. You know, that's the whole.
My clerk's printing.
But none of those will happen because these they're already too powerful for any politician to go against them. If you go against the social media companies and you're running for re-election, your opponent is allowed to post on social media and you're not.
And why would they support this? They already have the immunity without the restriction. And if someone were to run on a platform of reining in social media companies, I'd be surprised to see if their social media profiles survived the election campaign.
I mean, they kicked off of social media as sitting U.S. president. So who won't they kick off if they want to? They'll find an excuse for anybody.
They won't kick off Kurt. Though they'll try. But he is too powerful. Hey, I was watching your video about my law and crime situation. Thank you. It was very good. I will make sure and share it out today.
I had a lot of fun with that one.
Yeah,
Andrew, did it blow up in your ears?
A little bit.
Yep, me too. It was.
I've got these earbuds that sit deep inside my ears.
You know, this once again, this stream is brought to you courtesy of StreamYards for all your real-time streaming needs.
For folks who ask, by the way, these earbuds are indeed almost touching inside my head. These are the ones I wear on the motorcycle, so they have to fit under a helmet. So they sit deep within the ear.
They're deep.
Yeah,
earbuds.
But I my personal favorite observation on that stream was that your own chat proves how transformative your work is and how you are not, in fact, a substitute for law and crime, because your own chat is constantly bitching at all of us to shut the fuck up because they want to hear the underlying trial. You're so distracting. We want to hear the trial. This sucks. We want to hear the trial. Well, I think that shows it's transformative and you're not just a substitute. So I thought that was pretty good. Your chat may come to the rescue yet, Nick. How great.
I just can't believe the court law. What is it? Law and crime. I just can't believe they wouldn't just offer you money to add value to their platform. I mean, that would be the simplest, the most obvious thing to do.
Well, they disagree vehemently with some of my political perspectives.
Oh, I could believe that easily. Yeah.
Yeah. So that would be
But I mean, they're in New York. All they have to do is walk outside and throw some rocks and get together a panel of degenerate lawyers, and they can have their own bourbon drinking show. And they can with the women and the poker or whatever. It'll be great.
White Alec, I would love to see them do it. It would bring me so much joy to watch them do it.
You'd have a whole nother show just lampooning them.
White Alakazam says Winnie the Pooh LA with y'all, Nicky Pooh, honey but whiskey and fat. Oh wait, what? Winnie the Pooh LA with y'all. Nick is Pooh, honey but whiskey and fat. Uncivil Eeyore with black pills. Legal mindset as Tigger. Bites as Kanga because motherly, Joe as Roo because he doesn't drive, Runkle as Piglet because of ears, and Bronca as the owl.
It's not the worst. That's not bad.
I can work with that.
JK Wynn says super chat last night about the phrase "my truth," arguing with lefty friend about media SJW lies, reg lefty logic mistakes on facts, and my point after hour plus argument. He said, I'm like talking to a wall because of his truth. Me, GTFO, F, my truth, BS, short bus, AF. Okay, yeah. Yes, my truth. I'll say this again. I've said it before. It's been a while. My truth has value in places like therapy and personal growth for understanding your own perspectives on things and for realizing where you can work on those perspectives or work from those perspectives towards some sort of healing or better constructive future. My truth crumbles immediately when it confronts someone else's truth, and most importantly, the objective truth for anything outside of personal development. The moment you get into a situation where your truth is in conflict with anything else and somebody else's rights or understanding is on the line, it's no longer of value. So yeah, they're borrowing the language of psychology and counseling to try and impose restrictions on people based on someone else's perception of events. And that's not how we do things, or not how we should do things.
And then you run into questions like, what if my perception conflicts with your perception? My truth disagrees with your truth. So who wins?
Right. And that's why it's of no value in those situations. And that's the interesting thing. In court, you give, I guess, some level of your truth, but the ultimate fact, the finder of fact, is the jury or the judge, depending on how you have it set up, and they determine what the truth is, and they don't really care what your truth is at that point. So, oh, and by the way, I have followed up with my YouTube partner to try and figure out how they determined that people from my chat, when I didn't bring it up, were allegedly harassing Law and Crime. Trying to figure out how that came up with my YouTube partner manager, since they dropped that on me unsolicited. And so I have a feeling that Law and Crime is bitching to YouTube. And one of the reasons I have a feeling about it, and I think this is harassing, I don't know about you guys, but I have had 4 videos over the past 2-year time frame, age restricted in the past week. And it's kind of interesting what the time frame of those age restrictions are, or when they started happening. I have had no content age restricted in a very long time. The one that happened most recently was easily overturned. It was overturned within an hour of me filing an appeal.
I think this is a common tactic, not just a Law and Crime, but I said something critical of, I won't name them, but a popular media figure some months ago. And within a day, I suddenly had 4 strikes on my videos, one of which was the video that was negative about this popular figure. The other 3 were videos like from 2015 that had nothing to do with anything. So somebody just dug back in my video library long enough until they found something that probably at the time was not offensive to YouTube, but since then the rules have morphed and it's become strikeable. And I don't get strikes on my content. I mean, it just doesn't happen. All I do is legal analysis, except when I made this one guy mad, and I guess he put his staff on it to find some way to punish me for having been less than completely adoring of him.
It's interesting that YouTube's okay with stuff like that. To me, that's an organized harassment campaign, because what I imagine is it's everybody, it's a whole bunch of people going back and just flagging every video that you do, report it for inappropriate content or whatever, and then they, something will stick. And YouTube's justification is, well, if it violates though, then that's the thing. It's not harassment, it's just using the report tool. It's like, well, but it didn't violate for 2 years. Like no one actually thinks it violates. They probably can't even articulate the part which would violate it because they're just clicking the flag button mindlessly. So I'm baiting the hook for my YouTube manager to tell me about it, and then I'll drop that on there. Waiting for a response on it.
I won't say who I was talking about, except I'll provide a hint. It's a well-known cartoonist.
Oh, okay. Now I know who it is.
Probably.
Did you give the wrong answer to the balls, no balls question? Is that the problem?
I was critical of his reasoning powers.
How recent was this?
When he presents as someone who's supposed to be exceptionally smart and insightful. Oh, I don't know, a year ago, maybe. Who knows? Still got me blocked on Twitter, of course.
Peter says odds on self-defense being off the table. Well, now 0 are the odds. And really that was the kind of predicted outcome. The judge teased a little bit that he might be willing to take it off.
The fence tried to force it.
Yeah. As Andrew said, if you've got more than nothing, you're basically going to include the self-defense instruction. And the reason is if they don't, and you're convicted, you've got an automatic appeal. Hey, we raised self-defense here, and here. You go back through the record and find any place where self-defense is raised. And to say that this isn't a self-defense case, the entire thing is predicated on self-defense as a narrative. However, they did try to get it undone by including the negligent homicide, which doesn't make sense.
So when the judge is considering the instruction, the test for him is there more than 0 evidence to support this instruction? If there's 0.1% evidence to support the instruction, even if the evidence is from unreliable sources or is contested or whatever, that's up to the jury to decide. Once there's any evidence, it's up to the finder of fact. The judge gets to decide if there is any evidence. If there's no evidence, then there's no instruction. But if there's any evidence, then you get the instruction. And there is evidence here. It's contested. It's incredible. It's lots of negative things, but it exists.
I thought that the defendant repeatedly saying accident would be more of a problem, I guess, than you did, because it's like you can't really have it both ways at the same time. It can't be I did it for the purposes of saving my life because I was in imminent fear subjectively of death or grievous bodily harm, and also it was an accident. Those seem like those mutually incompatible things. So I thought that'd be a bigger deal.
Intellectually, yes, but for one, you're generally allowed to make inconsistent legal arguments. That it's up to the jury to decide what they want to accept. And let's face it, this defendant's not a rocket scientist, so it's not surprising that he would say self-contradictory things, even if the evidence in favor of self-defense is contradicted by other evidence from the defendant. It's more than zero evidence, and the instruction should be given.
He's not a rocket scientist, but is he a posthumous aerospace engineer? No, I was thinking, I was hoping it would be more of a problem. I think it'd be funnier. But the appeal risk is very, very big on that one. Without reading the case that they were citing, I'm going to guess, based on the arguments, here's how the case is distinguished and how you could actually get to non-mutually incompatible negligent homicide versus self-defense, is that the self-defensive act of the other case was the actual pointing of the gun at the person. That is a deadly force threat. That has to have justification. And in that case, the person did have sufficient basis raised for the instruction of self-defense for that aspect of it. And if they found proper self-defense on the raising of the gun, then what happens afterwards is no longer the responsibility of the party. And what happens afterwards is a struggle ensues over the gun. The gun goes off unintentionally at that point.
Right.
And so what they're saying is if you don't find the self-defense of the pointing and shooting, you can find a negligent homicide that happens subsequent to that. And I think that's the difference in this case versus that case. You could
find both, right? So for in theory, the person, when they pointed the gun, that's aggravated assault with a firearm, unless it can be justified as self-defense. So you raise the legal defense of self-defense to that criminal charge. You can be acquitted on that criminal charge, but maybe you didn't have the justification to actually shoot the person. That shooting might arguably have been reckless during a struggle over the gun, in which case you might raise the defense of accident with respect to the actual discharge.
There you go. Let's see. $19.99. Oh, wait, no, it just doesn't say who sent it. There's no name. He sent in a super chat. Wait, he wrote into chat with a profile with no name. Never mind. Fuck it. He lied so much, I don't even believe he got chicken satay. Well, he never got it. He just has a receipt that says he paid for it. But allegedly never received it. Marie D says, "Hey, Nick, just finishing a grueling 16-hour hospital shift. Here's $20 of my blood, sweat, and tears. Thank you and panel for the much needed sarcasm, humor, and intelligent discussion. Any medical lawsuits that pique your interest?" I don't know. It's always, to me, it's kind of interesting. People are like, well, what lawsuit or what trial are you going to cover next?
Like medical malpractice suits? I mean,
I don't know. There is a doctor who's he's going on trial for like 27 homicides or something. It's 27 murders. Something like that for fentanyl administration.
Oh, well, could be.
That's a potentially interesting medical case, but I don't have like a running list of cases. Really, there's not like an easy database of these trials or these cases are starting up.
So I don't have any legal expertise in those kinds of cases, but I will say over the last 2-3 years, I've managed to break bones a number of times and or otherwise injure myself. And it's amazing how quick they are to give you those opioids. When you get to the urgent care center or the ER or whatever, it seems like every visit I went, they gave me a prescription for opioids, and I never filled them because I didn't feel I needed it, but I had it. They made sure I had it.
A wonderful secondary market opportunity, man.
The only opioid I've had, I think, is codeine an opioid.
I believe so.
Yeah. So like I've had Tylenol with codeine. When I had knee surgery, I took one and felt like I hate the feeling that that gave me. I do not like the sort of swimmy out there experience of that side effect. So for me, it's never been appealing at all. And the second knee surgery, I just had Tylenol and Advil. Like I didn't need anything stronger. Thank goodness. Cause I don't like that. It makes me nauseous. And I don't do well with it, but yeah, they try and they give you prescriptions for various levels of opioid relief right away. And I never fill them either because I don't like it.
And by the way, folks, if you need it, I'm not telling you not to take it. I mean, you judge your pain medication needs for yourself. I'm just saying it was notable to me how I had imagined that these things would be difficult to get. You'd have to argue with your doctor to get the prescription, and it was quite the opposite.
So, yeah. But I know people who have not had addiction problems with it and have gotten good results. Just for me, it's, and I'm thankful that I have not needed it because I don't want to risk that struggle that some people have with it. It's I've seen it up close and it's nasty. None Your Business says, if this case shows nothing else, it's that trial by surprise does nothing for you except piss off the judge. James says, I loved Uncivil Laws chat on Ricada Law. Everyone go watch when you get a chance. Oh, and he sent a smiley face with a hat on. You did have the hat on for the video. That was nice.
I did have the hat on.
I appreciated that.
Oh, we have hats. I should be grifting my hats. I got to find one.
Only if you wear it sideways and if it's a flat bill.
Okay. No, it's not a flat bill.
I hate picking names for this damn account. Says that blonde behind the defense is looking thicker than a Snicker. That's A1 single mom material right there. A fuzzy creature says, when's the Michael Malice plus Andrew Bronca conversation? I don't know. I don't know if they'd want to have that, but they'd be welcome to have it on my channel. That would be exciting. Razor 390 says, if Edgecomb was more stereotypical deadbeat dad, he wouldn't have had a daddy-daughter date route that put him in the path tonight. Also, who wants to guess Ruby's rental car bill after he took it for 6 months? Might as well just be the whole car at that point. Right? Kurt, you're a math.
Yeah, I mean, some things. Yeah, it depends if you're looking at it from purely dollar number perspective, I suppose. But yeah,
it's got to be. God, it's expensive. I have no idea. Nick rolls in with knee surgery with a bottle of whiskey for painkillers. Actually, I think during my first knee surgery, I didn't drink whiskey at all. Like I, as a person, had not been drinking whiskey at all. And barely drank ever.
I'm glad I didn't know you then.
Rude. my second knee surgery. I'm trying to figure out if I was a whiskey drinker. There we go. Mullen Labe 1371 says the issue with medical doctors giving pain meds often is because if you don't treat the pain, you get complaints to insurance and medical board, or if you overtreat, then you have addiction issues. Damned if you do, damned if you don't. I can see it. Like I said,
but then I've also heard people with chronic issues who go into hospitals and can't get pain meds for their life. And are in real pain. People with, serious diseases that cause serious problems, and they're acted like drug seekers. So I don't know that there's some doctors prescribe them like candy, and other doctors seem to harass the ones who need it the most. It's a bizarre system we have.
That's why you need medical weed, man. Actually, lots of people report that's a way that they avoided opiates and opioids or whatever is that medicinal marijuana. I shouldn't say medical marijuana is the legal determination, but medicinal marijuana is just the use of it homeopathically. Is that it? That's not a word. I mean, it is a word, but that's not the word I'm looking for. Medicinally, whatever. As a pain med. as a pain med. I just think weed should be legal anyway. That
I agree. Whatever reasons there were to make it illegal in the first place, it doesn't make any sense anymore. Assuming it never did.
People are mentioning kratom. Look, I know people who took and take kratom. I'm actually not a supporter of that. I think it should be legal. I think basically at the end of the day, I think just about every substance should be legal. That's just my personal opinion on it. But I think people oversell kratom and undersell the addictive quality that it has. I've seen that kind of mess with people's lives because it's an opiate substitute and it acts in a very similar way. You use more and more and more. It's not as dangerous to overdosing and stuff like that, but it also is definitely addictive, physically addictive in the physical definition of it. Creates withdrawal symptoms and everything. And watching people go through that is messy too. They're nasty and irritating for a while. So,
Yep.
But yeah, come on, Judge, come on back. We've got some closing arguments to do. What the hell is going on? Med 8 says, doctor literally just told me that I have to get off of marijuana so that I can be able to be prescribed narcotics for my back pain. I don't see how they're related, but I'm not a doctor. So that's interesting. Justin P. 2012 Jameson says your computer has been named Law and Crime. Yes. That was a beautiful thing. So I did a stream last night and got this stream set up for today. And when I got downstairs this morning to turn on my virtual camera, nothing happened on StreamYard. And then I tried switching to different camera sources. Nothing happened. It wouldn't work. Wouldn't do anything. So I restarted the computer and it still wouldn't work. And then I closed StreamYard and reopened it again. And suddenly it did. It's a great system. Truly tremendous, wonderful, really good people over at StreamYard. Some of them anyway. Run the Cushion says, do you think Edgecomb shenanigans yesterday will hurt him with the jury? I mean,
Yeah.
I would hope so.
I
Of course
think
it will.
so.
The jury takes more than 20 minutes, you know?
I did get a couple of comments and things like that of people saying that we don't understand the jury. We're underestimating the jury's whatever. And I don't think we've estimated the jury's response to anything other than I think that testimony made him look worse before the jury. Whether or not they're going to convict is still a different question. And we can't know. We're not in the courtroom. We're not looking at the jury's reactions and stuff. But I think if that testimony doesn't somehow make him look worse to whatever jury, then nothing would at all. I mean, that's where you could shoot a man in the street because he did. So yeah, but the testimony yesterday was a disaster for him. JMac.E says -14 with a -31 wind chill in Wright County, Minnesota. Kids waited for a late school bus. Grow a pair, Milwaukee. The Dragon's Treasure says, Toye, I don't recall versus Edgecomb. Can you repeat that? Which would make this judge take justice into his own hands faster? Toye is less likable than Theodore Edgecomb, the killer. Ron Toye is a less likable individual than a killer. I just want to put that out there. Carson 93 says, what's your plan after this trial? Waiting for this case to end so I can go ice fishing. My plan is I'm going to do some Twitch shows at night for a change and not be up as early in the morning and take care of some stuff around the old compound before the next trial starts.
I mean, do we need to get out a doll and you can show us where the Ron Toya touched you that hurt you so? Is that the problem?
Oh no, there's no hurt here. He's just a less likable person. He's a little weaselly guy, and he engages in. I don't like that he is a harasser of people. I mean, and he has demonstrated this ability or this behavior over and over again. Like for whatever you say, he for example will go after people on Twitter to the point where he will find out their information, call their parents and their friends. I mean,
that's pretty dick. That's very dick move.
That's harassing and awful behavior that is condemned widely, except when it comes to people that Ron Toye does it to. Then the weird little like Ron Toye orbiters are like, you're justified in this, Ron. That person called Monica fat in a tweet. Therefore, you can do this. Like, oh my God, you people are insane. So, yeah, not a big fan of him. Not applicable says volume plugin and pure OBS. So chat was right. No, chat's never right. You got to get that out there. I wouldn't need the volume plugin with pure OBS. It has its own independent gain monitors that you can just increase the gain through OBS itself.
Yeah. You capturing OBS is fine because it actually has audio tools where you can see the audio, and you have compression tools that you can actually put plugins and so forth and so on. StreamYard just sucks ass. It doesn't have any of those things.
Yeah, long and short.
So I'm not sure how free OBS is going to solve any of our problems, unfortunately.
Well, there's this thing. There's a program called OBS Ninja. It's free, and it basically creates these chat rooms.
Ooh.
But I don't know how well it functions with easily and quickly sharing video with the group. That's what StreamYard does really, really well. Here's the video. Here's the sharing of the video in this nice, handy way. You're not manually adjusting all of the tiles that you have. You don't have to manually input people into the system. It does that really, really well. The rest of it, the audio balancing, if they fix the audio balancing, this would actually be a really great tool. I mean, that's all they need to do. Is just add a equalizer, not an equalizer, but
next time I run a stream, I'll try this Ninja thing and see how that works.
Do you want me to direct you to some videos on it?
Sure, why not?
Yeah. It's the guy who made it. He has some they're very basic, but yeah, you basically create a lobby room and then it starts doing most of the work. But
Excellent.
Mad8 says, I had to take a urinalysis. After the urinalysis, they said I am positive for marijuana, so I can't have narcotics because marijuana is worse.
It technically is.
I've got a jury waiting, gentlemen. Mr. Hubner.
I'm willing to allow the negligent, although self-defense wouldn't apply to it under the theory that the defense is trying to get it in this situation. So it has been modified that way.
What a nice
Then
prosecutor.
after I did that,
Use the mic. So can I characterize it as reluctantly stipulating to the instruction on negligent homicide? Fine, because as I said off the record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide. Now I think we've reached a point where literally the jury can consider every form of homicide that exists in the Wisconsin statute. Correct? Am I missing one?
felony murder, you're missing felony murder. I'm not.
Because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions.
That was a good.
Mott, I hope we're done
It
discussing.
was a good line. It was a good line.
Last issue, placing on the record, states objecting, but I think if we're doing the negligent, then the accident 772 should be given. I know this.
Are you pushing your luck?
772 instruction should be given based on.
Okay, we withdraw our stipulation. Fuck you.
I know the state's objecting to that.
Mr. Hubner.
Your Honor, accident is him trying to state, the defendant trying to allege that he did not have the mental state in order to commit the negligent. If their whole point is that it was criminal negligence.
I'm not clear what the point is at this point. It'd be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
It applies with this fact pattern. it applied in that other, in the case the defense is referring to. It doesn't apply to this. The defendant is not disavowing the mental state. In fact, he's in fact stating he had the mental state, especially based on his weapons training. So therefore, sorry, I'm trying to get to
I don't blame the state. By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday. It's frustrating when the defense adds all these additional requests on the morning I'm going to instruct the jury. I told the jury to be here between 8:45 and 9. They were all here by 8:45. It is now 10 o'clock. It benefits no one, and it is not fair to a jury to have them sit in the jury room hour upon hour. Instruction 772, accident does not apply, and I'm not giving it. That request is denied. So,
I mean, I would not want this done in my self-defense trial. All these alternative theories of the case. I mean, the jury is inclined then to not believe any of them.
Versions or 3 or 4 versions of the instruction.
I think they were already inclined just based on the defendant's words, but yeah. I understand your point.
What now? He's going to ask for an alibi instruction?
That'd be good. Yeah, I wasn't.
Yeah,
there.
that would be. Oh yeah, he didn't even do it.
I liked also the Shaggy. It wasn't me.
That would be great if the defense gets up and argues. Now the state didn't actually tell you how they know that it was Mr. Edgecomb, did they? Did they prove to you? It's just a guy on a video. That's just
state, all black men look the same. It's racism. You can't make out our client in those videos.
Wow.
We want to do the big reveal, jury. The actual shooter was B. Ivory Lamar.
Put him back on the witness stand. He could say, hey, the only reason, I was lying about actually being there and shooting him, but I felt compelled to do that because of racism.
Oh my gosh. Let's see. Assy K says, let the cat stream. No, he's a jerk. He's mean to the chat. Brian Alleman says, for Biscuit Kibble Fund, thank you. Amanda M, welcome to Paralegal. The Dolly Bird UK, welcome to Paralegal. Cheese Curd Havoc says, what in in-ear monitors did you get? Thoughts? Well, I haven't gotten them yet, but they're 64 audio A18S ear monitors. Came highly recommended, so we'll see how they do. 2012 Jameson says, this trial shows, yes, and before you go look them up and then come bitch at me, yes, they're way more than what I need. I know. I got it.
His wife told him already.
2012 Jameson says, this trial shows why diversity and equity in law schools are bad, not the best thing to choose a lawyer based on race. Diz5 says, they're the best in ears. David says, did he admit to killing or just take responsibility for his nebulous and unspecified actions? Galen Smith says, no, he had, oh yeah, I take responsibility. Let's see. Galen Smith says, Edgecomb lied about thinking of Ahmaud Arbery when he was being chased. Arbery was killed the day after Edgecomb killed Cleereman.
Brought in.
Oh, that's it. That's interesting.
Everybody can remain seated and silent, not just when the instructions are being read, but during closing arguments and the like, please.
I thought Arbery was killed in February.
Oh, yeah. So, and this was September, right?
Yeah.
Okay, so that's not correct then.
Now, the video of the shooting might have been released just before. I don't recall exactly, but I thought that was a couple of months after February. February 23rd, Arbery was killed. 2020.
Elliot says, I'm an audio engineer that works with artists using in-ear monitors. You're going to love your custom molds. What'd you buy? Just mentioned 64 audio A18Ss. Preston Barnhill says, Edgecomb's testimony felt very reminiscent of a certain
How are
soy
you spending
boy's
this much
deposition.
money on earphones? That's what I want to know. Do you need that level of quality?
No, I don't need that level of quality. I need the tax deduction. I bought them before December 31st. Or the write-off, the income tax write-off or whatever.
For people in the comments asking me why I'm not at SHOT Show, I've been at SHOT Show many times. I'm not that big a fan of Vegas generally, and I don't have a compelling need to go to SHOT again.
Fine, the jury's coming in.
Let's see. Abe Eckstein says, I'm starting to respect Mark Richards a lot more after watching the quality of Wisconsin attorneys.
Nick, if you need a tax deduction, I will just start billing you for my time. That will help you get that. I'll give you all the tax deduction you need. I'll charge you $100 an hour. Write me a check.
How much are
a
they,
business
Nick?
expense.
What? How much are the headphones?
Yeah,
It's $3,000.
that's up there.
Yeah, that's what I'm
Mhm.
saying. Nick spends $3,000 on earphones, gives me nothing. I'm feeling cheated and cheap over here. Jeez Lord.
Well, when you get in my ears, we'll see what
Welcome
happens.
back, ladies and gentlemen. I'm sure over the course of the last week plus, at times you must think, geez, Borowski cannot tell time, because I said you'd been around 9 and it's more like 10. We've been discussing a few things, discussing the jury instructions. I'm going to
There
read
you
you
go.
the jury
There
instructions.
you go. Now the chat's bitching at me.
The jury instructions are frankly rather lengthy. They're somewhat, if not complicated, at least involved. So I don't expect you to memorize them. You don't have your notepads. You don't need your notepads. There's no way you can memorize them. Rain Man couldn't memorize them. Okay. So you will get a copy of the instructions when you deliberate after the instructions and the closing arguments. Ladies and gentlemen, members of the jury, as I've said, I will now instruct you on the principles of law, which you are obligated to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law that I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and judgment, reach your verdict. If any member of the jury, if any of you has an impression of my opinion as to whether the defendant is guilty or not guilty, you are to disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges of the facts. The court is the judge of the law only. Evidence. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits the court received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside of court is not evidence. You're to decide this case.
These are the instructions you hear in every criminal trial,
evidence
folks.
offered and received during the trial. As you know, in this case, the information charges first-degree intentional homicide, use of a dangerous weapon. It's alleged that on or about September 22nd of 2020 at 1750 North Holton Street in Milwaukee, Milwaukee County, the defendant did cause the death of Jason Cleereman, another human being, with the intent to kill that person, contrary to the Wisconsin statutes. To this charge, the defendant has pled not guilty, which means the state must prove every element of the charged offense beyond a reasonable doubt. Crimes to consider. first-degree intentional homicide, self-defense, second-degree intentional homicide, first-degree reckless homicide, and second-degree reckless homicide. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide or second-degree reckless homicide, or finally, homicide by negligent use of a weapon, all of which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crimes referred to as first and second degree intentional homicide and first and second degree reckless homicide and homicide by negligent use of a dangerous weapon are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant cause the death of the victim. First and second degree intentional homicide require that the state prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Homicide by negligent handling of a dangerous weapon requires that the defendant cause the death of the victim by criminally negligent conduct in the operation or handling of a dangerous weapon. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense. The criminal code in Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use force. Let me back up. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. Provocation. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack,
The provocation
and
instruction.
who does provoke an attack, is not allowed to use or
Yeah, I thought they
threaten
might add it.
force in self-defense against that attack. However, if the attack which
Regaining
follows
innocence.
causes the person reasonably to believe that he or she is in imminent
This is
death-
escalation.
strike that,
Regaining innocence under
imminent danger
circumstances of
death
escalation.
or great bodily harm, he or she may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm.
We should have fought against this
The
provocation
person who
instruction.
provokes an attack may regain the right to use or threaten force
The defense?
if
Yeah.
the person in
Well, they
good
want this
faith
regaining language. I mean,
withdraws
the
from the
punch
fight
is incontestable,
and
right?
gives
So
adequate notice of the withdrawal to his assailant.
they want to say, sure, he punched him, but he withdrew.
Person who provokes an
Or
attack,
later he was facing a threat
whether
of
by
death.
lawful or unlawful conduct, with the intent to use such an attack as an excuse to cause death or great bodily harm to another person, is not entitled to use or threaten force in self-defense. Retreat. In determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. As applied to this case, the effect of the law of self-defense is as follows. The defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent an imminent death or great bodily harm to himself. Continuing, strike that. The defendant is guilty of second-degree intentional homicide if the defendant caused the death of Jason Cleereman with the intent to kill and actually believed the force was necessary to prevent imminent death or great bodily harm, but the belief or the amount of force used was unreasonable.
Often called imperfect self-defense. Essentially mitigates murder to manslaughter, or what they call here second-degree murder.
The defendant is guilty of first-degree intentional homicide if the defendant caused the death of Jason Cleereman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of Jason Cleereman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. The defendant is guilty of second-degree reckless homicide if the defendant caused the death of Jason Cleereman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty of first or second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed.
You don't need a theory of motive. Motive is not an element of the crime. Intent is an element. That's different.
Gentlemen.
Uh-oh. Found something in the instructions he doesn't like.
Oh, sidebar.
Just a little one. Not even in the not even actually in chambers, so.
Huddle. 3, 2, 1, team.
I don't know if I can do a poll with all of the murder options that they have on the table.
I just discussed something with the attorneys, obviously, just to clarify it. Let me reread that last sentence and then continue. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will then be instructed to consider the last offense of negligent homicide. The facts necessary to constitute each crime will now be defined for you, explained in greater detail.
All right. This is
First
riveting.
degree intentional homicide, as defined in the criminal code, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The burden of proof. Before you may find the defendant guilty of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing the death. Two, the defendant acted with the intent to kill Jason Cleereman. And three, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the action. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act.
Yeah, premeditated murder does
Intent.
not mean you sat and
You
planned
cannot
it.
look into a
It
person's
just means you
mind to find
decided
intent.
you wanted to kill them.
Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances, in this case, bearing upon intent.
The poll literally only gives me 4 options, so I
Intent
honestly
and
can't
motive.
even do all of the different murders.
Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While a motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict.
Told you.
Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either.
You think if he's convicted, we'll have a
defendant
free
did not
Agoo
actually
campaign on
believe
social media?
imminent danger
Free
of death
Agoo,
or
Newman.
great bodily harm, or 2, that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be considered only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide.
Folks, there are a
If
lot of people who'd like to
satisfied
see this
beyond a
as self-defense
reasonable
because
doubt
there's a lot of people in the gun
defendant
community who
caused the
want the
death
privilege to shoot someone in the
Jason
face
Cleereman
if they're faced with a
the
raised
intent to
fist.
kill,
Common
and the
sentiment.
defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide.
Radio Ruin
If you're
said,
not so satisfied,
he said the N-word, that's
must
deadly
find the
force,
defendant
perfect
or
self-defense,
must not find
guilty.
the defendant guilty of first-degree intentional homicide.
At the end of all
You
these
must-
40 pages of instructions,
Then consider
Theodore Edgecomb should raise
whether
his
the
hand and
defendant
ask the
is
judge,
guilty of
can you
second-degree
repeat that, Your Honor?
homicide as defined in the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on that charge, on the charge of first-degree intentional homicide, you then should and must consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Cleereman. Two, the defendant acted with the intent to kill Jason Cleereman. And three, the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself.
I'm the judge.
You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. One, that a reasonable person in the circumstances of the defendant would not have believed he was preventing or terminating an unlawful interference with his person. Or two, that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm. Or three, that a reasonable person in the circumstances of the
Let's sit
defendant
and listen to this and absorb it all.
would not have believed that the amount of force necessary,
Going to be made worse when the defense gives an incoherent closing
amount
argument
of force used was
Oh,
necessary
ye of
without a
little faith.
single, cohesive narrative of what they claim happened.
I
Hey, if
think
you don't
the
believe
obvious-
this,
that the
you can go
amount
for
of
that. Or if
force
you don't believe
used
that, you can go for the
necessary
next
to
one. Or if you don't
prevent
believe that one, you can go for the
imminent
other
death or
one.
great bodily harm to
I
himself.
believe B. Ivory is going to be
The
concise and
reasonableness
flawless.
of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts or actions, and not from the viewpoint of you, the jury, now. The standard is
It
what a
wasn't even
person of
sushi.
ordinary
It wasn't
intelligence and
sushi.
prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. Your
Squizgar
decision,
says he keeps saying
if you're
he. Did
satisfied
anyone
beyond a
ask
reasonable
Theodore what his
doubt
pronouns
that the
are?
defendant
Grounds for
caused
appeal?
the death of Jason Cleereman with the intent to kill and did not reasonably believe that he was preventing or terminating.
You want to set up a
unlawful
drinking game for how many times B. Ivory says
or did
Ahmaud
not
Arbery,
reasonably
George
believe
Floyd,
the force
Oh
used
my
was
God.
necessary
racism.
to prevent imminent death.
Set
or
up
great
you got a
bodily
bell
harm.
there?
You should
Bing,
find the
bing,
defendant
bing.
guilty of second-degree
Be
intentional
broken in the
homicide.
first 12 minutes.
If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide. And you then must consider whether the defendant is guilty of first-degree reckless homicide as defined in the Wisconsin Criminal Code. This homicide is also a lesser included offense of first-degree intentional homicide. You should and must make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide
Man, if they made
or
getting married
pursuing
this
the
hard, there'd be a
offense
lot fewer divorces.
of first-degree reckless homicide.
I don't
However,
wanna go through
if
this
after
again.
a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on the charge of second-degree intentional homicide, you should and must then consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing
I don't even
the
know
death.
what count we're on anymore.
Two, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person. And the risk of death of great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all evidence in this case that the risk was unreasonable. And three, the third element is that the circumstances of the defendant's conduct showed utter disregard for human life.
Jesus
Okay,
Christ,
so
get
we're
him a
on
tissue.
some
In
reckless
determining
homicide
whether
here.
the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and other facts and circumstances relating to the conduct.
The commenter asking about my
You
earbuds,
should
they're
consider the evidence relating
S-plugged
to
from
self-defense in deciding
plugup.com.
whether the circumstances
Plugup.com.
of the defendant's conduct showed utter disregard for human life. Again, the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after
So
the
we still
death
have 2 more
to the
counts
extent
after
that it
this.
helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. The jury's decision, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminally reckless conduct and the circumstances showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should and must then consider whether the defendant is guilty of second-degree reckless homicide in violation of the Criminal Code of Wisconsin. Second-degree reckless homicide is a lesser included offense of first-degree reckless homicide. Again, you should
Even
and
he's getting annoyed.
should and must make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However,
reason
if
this might
after a full and
take a
complete
while is
consideration
because
of the evidence,
It won't do
you
what he
conclude
just
that
told
further
them.
deliberations would not
So
result
consider all the
in
other
unanimous
ones
agreement on the charge of
as
first
equal
degree
to the
reckless
first degree.
homicide.
It won't
You
disregard the
should then
first degree
consider
first.
whether the defendant is guilty
In
of
my opinion.
second-degree reckless homicide. Second-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by a person who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide. The difference between those two homicides is that first-degree reckless homicide offense requires the proof of one additional element. That is, that the circumstances of the defendant's conduct showed utter disregard for human life. If you're satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring the circumstances of the conduct showing
You
utter
could do a poll on
disregard
whether if
for life,
Edgecomb's acquitted
you
here,
should
he's in
find the
prison on a
defendant
different felony
guilty
charge within the next 12
second-degree
months.
reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminally reckless conduct, you should find the defendant guilty of second-degree reckless
I want to
homicide.
know where Ashley is. Free Ashley.
Yeah, they fought so hard to
If
get her
you're
back,
not
and she
so
never showed
satisfied,
back up.
You must not find the defendant guilty of
I
second-degree
think they got her back in and told her, and she was like, screw this.
Then
Should have put a
you
ring on it.
Must consider whether the defendant is guilty of homicide by negligent
Maybe
handling
she had to
of
stay in the
a
gallery
dangerous
or
weapon
something.
in violation of the Wisconsin Criminal Code. That offense is a lesser included offense of first and second-degree reckless homicide. Just as with the other offenses, you should and must make every reasonable effort to agree unanimously on the charge of second-degree reckless homicide before considering the offense of homicide by negligent handling of a dangerous weapon. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of second-degree
Yeah, I forgot. He
reckless
actually
homicide,
pled to a felony, didn't he?
you
Felony
should
bail
and
jumping.
must consider
Yeah.
whether the defendant is guilty of homicide by the negligent handling of a dangerous weapon. Homicide by negligent handling of a dangerous weapon is committed by one who causes the death of another human being by the
I
negligent
can't believe how many
operation
foreign
and
currency
handling
super
of a
chats you get.
dangerous weapon.
Like people in other countries are watching the crazy American legal system.
Burden of proof.
Well, it is
Before
a
you may find the
disaster.
defendant guilty of this offense,
buddy.
the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant operated or handled a dangerous weapon. Two, the defendant operated or handled a dangerous weapon in a manner constituting criminal negligence. Three, the defendant's operation or handling of a dangerous weapon in a manner constituting criminal negligence caused the death of Jason Cleereman.
I almost hope he
Cause,
was gonna get off on self-defense,
again,
but
means the
gets the
defendant's
negligent
act was a
homicide
substantial
instead
factor
because they
in producing the
ended up
death.
bringing that fact about.
Dangerous weapon. Dangerous weapon means a firearm, whether loaded or unloaded. A firearm is a weapon that acts with the force of gunpowder. Criminal negligence.
Overpowered
Criminal
pneumatic
negligence
rifles are fine.
means a defendant's operation or handling of a dangerous weapon created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable and substantial. And the defendant should have been aware that his operation or handling of a dangerous weapon created the unreasonable and substantial risk of death or great bodily harm. The difference between criminal recklessness and criminal negligence. Criminal recklessness and criminal negligence both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal recklessness requires that the person engaging in that
When the judge
conduct
started these
is
instructions,
aware
the Packers
of
were
that
still in the
risk,
playoffs.
while criminal negligence requires that the person engaging in the conduct should have been aware of that risk.
Damn it. Okay, that's all of them. That's all the charges.
The jury's decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminal negligence in the operation or handling of a dangerous weapon, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty.
There is more to the instructions, but
You're
we'll
not
be done with the counts in just a minute.
These are all important, but this is important. You are not in any event to find the defendant guilty of more than one of those offenses. Use or possession of a dangerous weapon. The information, the charges in this case allege not only that the defendant committed the crime of either first or second degree intentional or first or second degree reckless homicide, but also that the defendant did so while using a
You forgot the criminally negligent, dude.
If you find the defendant guilty of any of those foregoing offenses, you must answer the following question. Did the defendant commit the crime of first or second degree intentional or first or second degree reckless homicide while using a dangerous weapon? Dangerous weapon means a firearm, whether loaded or unloaded. Before you may answer the second question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer that question, no.
I mean, I don't know how you get
Told
any
you
of
guys
those
long.
without a dangerous weapon. You shot Cleereman in the face.
In reaching your verdict, examine the evidence with care and
I
caution.
wasn't trying to shoot Cleereman in the
Act
face.
with
It just
judgment,
happened.
reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless during your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of proof, the burden of establishing every fact necessary to constitute guilt is on the state. Before you can return a guilty verdict, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty.
Think he's going to give him 10 minutes between the
Reasonable
instructions
doubt.
and the close?
Reasonable doubt means a doubt based on
Well, I would hope
reason
so.
and common sense.
It's got to wake him up.
Doubt for which a
Get him
They
some
go
coffee.
bleach
can be
their eyes
given
with coffee.
arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause, or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt based on guesswork or speculation. A doubt which arises merely from sympathy or from the fear of returning a guilty verdict is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Information, the information which I read from earlier, is nothing more than a written, formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Improper questions. You are to disregard entirely any question that I, as the court, did not allow to be answered. You are not to guess at what a witness's answer may have been. If a question itself suggested certain information might be true, ignore the suggestion and do not consider that as evidence. Objections. The lawyers for both sides have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over an objection of an attorney, I, as the court, am not indicating any opinion about the evidence. You, the jury, you jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Expert opinion. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and credibility of any expert, the facts upon which any opinion is based, and the reasons for any opinion. Opinion evidence was received in this case to help you reach a conclusion. However, you are not bound by any expert's opinion. Circumstantial evidence. It is not necessary that every fact be proven directly by a witness or an exhibit. A fact can be proven indirectly by circumstantial evidence. Circumstantial evidence is evidence from which you, the jury, may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact.
Someone says, I wish we
Whether
had done a
evidence
bench
is
trial.
direct or circumstantial,
He would have
it
been
must
guilty
satisfy you beyond a
a
reasonable
week
doubt
ago.
that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you, the jury, to decide. Exhibits. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Police reports. During the course of the trial, the lawyers may have referred to or used police reports with witnesses. In most cases, these reports will not be provided to you. If you are not provided a police report, you need to use your collective memory regarding any reference to such report.
You're muted
The
on
weight
your
of the
hardware
evidence.
end.
The weight of the evidence does not depend on the number of witnesses on either side. You may find the testimony of one witness is entitled
Just
to greater
autographing a
weight
bunch of
than that
hardcover
of
books
another
for the Get
witness,
Hard crowd
or even of
while we're,
several
while
other
we're
witnesses.
enduring this instruction process.
The jury's knowledge,
It is
weighing the evidence,
brutal.
you, as the jury
I take this opportunity to run to
may
the
take
bathroom.
into
I'll be right
account
back.
matters
Since
Okay.
there's
of
nothing
common
to
knowledge
really say.
and your observations.
So
and
for those who are interested in the
experiences,
law of self-defense,
the affairs of
hardcover
life.
book, our best-selling book, I autograph every one of them, folks. I'm autographing
Credibility.
several boxes of them right now as we're enduring these jury
It's your
instructions.
duty of the
You
jury
can
to
get this
scrutinize and
best-selling
weigh
book
the
at
testimony of the
Amazon if you
witnesses,
care to read reviews,
determine the effect of the
or
evidence
you can
as
get
a
it at
whole.
lawofselfdefense.com. Get
sole
hard.
judges
If
of
you
the
get it from
credibility.
Amazon, they're not
That
autographed.
is the
The autographed
believability
ones have
of
to
the
come directly
witnesses,
from us. I never see
weight
the
to be
books
given
that
to
are
their
sold through
testimony.
Amazon.
If you
So
believe
if I don't
that
see them, I
any
can't sign them.
of the parties or the court has an opinion as to the credibility of a certain witness, disregard and do not consider that, as you are the sole judges of the credibility of the witnesses. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the trial, the witness's conduct, appearance, and demeanor on the stand,
Including the defendant.
clearness or lack of clearness of a witness's recollection,
Including the defendant.
the opportunity the witness had for observing and knowing matters testified about, the reasonableness of a witness's testimony, the apparent intelligence of a witness, any bias or prejudice, if any possible motives to falsify testimony.
Folks, I'm
and
told that we're
all other
within a
facts
week
and
of being caught
circumstances
up on all
during
our
the
book
trial
orders from the holiday
that
season and such.
support
If you have a problem
or
with your book
discredit
order, just contact
testimony.
support at lawofselfdefense.com.
Then give to the testimony of each witness the weight you believe it should receive.
And we do ship stuff internationally. I'm not sure
And
why you'd
note
want it
when it has
internationally. I mean, we
testified in
only
this
do
case,
U.S. law,
and you should not discredit the
but we
testimony
do. I don't know what the
just
shipping
because
is. You'll
the
have to
defendant is charged
go
with
through that
a
process.
crime. You should use the same factors to determine the credibility.
Closing
weight
statements have not
of the
happened yet,
defendant's
folks.
testimony that you would
The
use
closing
to
statements have
evaluate
to happen after
testimony
the instruction so the
any
jury
other-
knows what to listen for. And then there'll be a few
not
administrative
the magic
instructions
way
after
for
the
you to
closing.
evaluate testimony. Instead, you need to use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you, and you should do the same thing here. Any remarks or comments by the attorneys are not evidence. If a remark or a comment suggested certain facts not in evidence, you're to disregard that suggestion.
There's going to be a lot of that,
Was
folks. A lot of
received in this case
defense attorney talk in
defendant
closing that's
had
not
other
actually in
open
evidence.
cases at the
You should
time
expect that.
charged offense was committed. That evidence was allowed only as it pertains to the defendant's credibility and should not be used for any other purpose. Furthermore, evidence was received that the defendant was temporarily restricted from possessing a firearm at the time of the
I
charged
didn't
offense.
succeed. I didn't stay
While
away long
one
enough.
may be temporarily restricted from possessing a firearm due to court orders, this shall have no bearing on whether the defendant was privileged to act in self-defense. Under the law, the defendant still had the right to act in self-defense at the time of the offense, and you are to decide only whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Finally, evidence was also received that the defendant was on bail at the time of the charged offense. This fact shall also have no effect on your deliberations as to his guilt or innocence as to the charged offense. You are to decide this case solely and only based on the law and facts presented to you during the trial.
Oh boy.
In just a minute, both sides will make closing arguments. You are to consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. You're to draw your own conclusions from the evidence and decide upon and reach your verdict according to the evidence and under the instructions given to you by the court. At this time, I'm going to ask both sides to make closing statements. I have told both sides that they have a maximum of
No
an hour
break.
and a half total
Wow.
each, an hour and a half each for closing arguments. I've encouraged both sides to recognize
He got a break before an hour and a half of
they're an
closing.
hour and a half, and they may
Yeah,
be
because you can.
shorter.
I'd
They
be
will certainly
shocked
no
if
longer
B.
than an
Ivory
hour and a
doesn't
half.
pull a
It's
full
hard
hour and a
stop
half.
from this court for both sides. We'll certainly start and proceed with the closing from the state. Mr. Hubner.
Well, that's
Okay, straight into it. Real quick, C4 Own says, for all the stupid games the defense is playing, Edgecomb is getting the book for pissing the judge off. Brielle Marie says, I signed up to support you on locals. I'm new to the app, just downloading it now.
Can everyone hear me?
Does it
Okay,
include
good.
support being
I
a
see
member
that.
of your YouTube?
Ladies and gentlemen, first of
No,
all, I
it's
want to
separate
thank
from
you
YouTube.
for your time and your patience.
Uh,
This has taken longer than what you were told it would. You've listened to over 20 witnesses. You've heard over 100 exhibits. You've watched a video. You've seen me drink about 30 Diet Cokes. You've been here for a long time.
So it'll be state closing, defense closing,
You've been
state
patient.
rebuttal, folks, will be the sequence.
yeah.
We're here about something that almost boggles the mind on how tragic what happened is. On September 22nd of 2020, two different men were heading out. The victim was with his wife. They went to a bar, they went to the happy hour, and then, because he'd been drinking, he asks his wife to drive. They decide, because it's a nice night, to drive down Brady, and he has his window open. Now, ladies and gentlemen, as you've heard, the defendant, well, he left home. And he left home with that firearm he wasn't supposed to have. He left with that firearm, and he's on his bike. And he's walking originally. Now, ladies and gentlemen, there is an incident that occurs. Ms. Cleereman testified and told you about how, out of nowhere, in between two cars on the north side of the street, the defendant just kind of juts out. Keep in mind, ladies and gentlemen, that all the security video that we have, that we are able to find, shows him walking his bike on the north side of the street. Everything. Now, there has been a lot of discussion from the defense of, well, there's missing video that would have shown him flying up on a hood of a car and all of this, and the bike gets hit. Ladies and gentlemen, he's able to ride that bike for miles afterwards. There's no damage to the bike. You've seen the bike. There's no anything, any evidence to support that there was ever any hit between the car and the bike, anything. Nothing on the bike, no
Correct.
evidence whatsoever. And defense counsel started this trial by telling you how highly suspicious it was that 745 on Casablanca, which would have captured that, is somehow missing. Except, as the evidence shows, that's not true. You heard from Officer Howard, who watched that period. Nothing was there. The Zanya's Pizza, which covers that same area, doesn't happen. So all of a sudden now, we're moving to Glorioso's. Now that's the missing part. And then the defendant takes the stand and says, not even there, further east. Ladies and gentlemen, the police looked for where that incident occurred. They didn't find it.
Racist, please.
But regardless of it, ladies and gentlemen, all it was a situation in which Mr. Cleereman yelled, possibly swore, and he hurt the defendant's feelings. He wasn't hit. He wasn't injured. There's no damage to the bike. There's no injury to him. And what does the defendant do? I can't let them get away. He gets on his bike.
That's what he testified to. Bad testimony.
He follows them. He goes.
You can see
right
how the
past
prosecutor's doing a good job of closing with those
dynamite
building
bricks.
blocks of evidence collected over the
Doesn't
course of the
care about
trial.
this special night anymore. He had
Sewing
one
them
thing
all
on his
together.
mind. He was irate and he wanted to catch up, and he sure did.
I predict the
Ladies and
defense
gentlemen,
closing will be largely
no
evidence-free.
words to tell you that this whole thing about him flying up on a car is a lie. Because he says, were you talking to me? He testified, well, he just wanted to see if they were going to admit to hitting him. But that never comes up. What he says is, I want to know if you were talking to me. And then he punches him. He punches the victim straight in the face. He punches the victim, causes his glasses to fly, causes blood to flow. And he gets on his bike, or stays on his bike, and just continues right around that corner. Now, ladies and gentlemen, yes, the victim put his hand on the car door and opened it and then closed it.
From the state, we get angry
yes,
white man. From the
he tells
defense,
his
we'll get
wife
angry black
to
man.
turn.
We'll see
And
who
yes,
wins.
they pull
Underdog.
around and she stops the car. And he, the defendant, is now up on the sidewalk. And he continues to bike towards those stairs are. And then he stops. And ladies and gentlemen, you saw, yes, the victim starts off with that purposeful walk that several witnesses saw. And then, yes, even though some of them don't remember it, he got into that little bit of a jog. And he gets there and he squares up with the defendant. He's there, ladies and gentlemen. As Jose Perez and Jeff Parr told you, it looked like he was going to confront them. His wife even said to the police at the time, yes, she said he was going to talk to him. She told the police he was going to confront him. Confronting could mean yelling at him, asking him a question, could be meaning to fight him, could be doing exactly what Rod Trell Cameron said he was going to do, which was get in that boxer stance.
He's doing well incorporating the
Punched
bad
man,
facts.
according to Rod Trell Cameron, that had punched him. The defendant threw a punch, and then when that person was getting ready to punch back, according to Rod Trell Cameron and Jeffrey Parr and Jose Perez and the victim's wife, he pulls a gun, aims it at the victim's head, and pulls the trigger. Victim drops. So cold-blooded. Rod Trell Cameron is on 911 saying, you've got to get here. He's still here. When he talks to the police, dude's got to go. That was too cold-blooded. Now, ladies and gentlemen.
And this is the witness the state dragged in shackles.
Gets there. He has nothing in his hand. Nothing. No weapon. There's no evidence under any circumstances, under any view of anything that has been brought into this case to believe that he had a weapon in his hand. Defense counsel made a very big point over the fact that they were going to have a witness that came in and said that somehow the wife was going through his pockets and they were insinuating as though she was somehow putting the knife in. That also came for what seemed like one of the weirdest sidetracks where the defense was attempting to debate whether or not she even loved her husband. Remember that? A wife that purported to love his husband? Oh my God, she asks, is he right? She's so calm. We're spending all this time when the video that everybody knows about shows her in the back of the squad when the shock begins to fall off and the tears start coming and she goes, oh my God, my love. No one will love you like me, my love. She is heartbroken. She held it together as long as she could. Maybe you wouldn't have reacted that way. Maybe defense counsel wouldn't have reacted that way. But to question whether or not a woman who saw her husband's brains blown out of his head in front of her even loves her husband because of some tone is disgusting.
Yeah, I think that was a big misstep by the
And then
defense,
we get
personally.
this thing
I'd be
of,
Ivory.
yes, she's somehow trying to secret the knife. That makes no sense. First of all, ladies and gentlemen, she told you she went there.
It sounds
she wanted
like a
something
good line when you're being interviewed on The View, but it doesn't work in front of normal human beings.
Yep.
She goes to the cops. I've got his wallet. We know what she was doing. She grabbed his wallet. Does it make sense? I don't know what I would do if my wife's brains were blown out in front of me. No one knows.
The defense is a big misstep, says Lackluster.
It makes it seem like somehow she's trying to take this knife and put it in his pocket. Ladies and gentlemen, in order for that to be true, Miss Cleereman, at that moment in time, would have had to realize, I got to take this knife out of his hand. You know what? Instead of throwing it over the wall or putting it in the car or putting it in my purse, I'm going to put it in his pocket. And then, in order for someone to realize, because there's people around, maybe they see me going to his pocket, I'm going to take his wallet. so that I've got a ready excuse. That's the amount of thinking that they're expecting Ms. Cleereman to have. And they're forgetting one thing, ladies and gentlemen. When he got punched, Mr. Cleereman puts his hand up, remember? And he says to his wife, I'm bleeding. That hand, that right hand, it's got blood all in the palm.
No blood in the
That right
pocket.
hand, that when he touches,
Yep.
mere touches the car door in order to open and close it.
This is
leaves
good. I didn't even
blood
think about this.
on the hand,
Yeah,
on
and there's a picture of the
wall,
jeans,
on
the
door,
pockets
and on
pulled
the
out, they're
window.
white.
So much blood, ladies and gentlemen, that it's literally visible on the car.
Good thing
That
they didn't have a
bloody
red car.
hand, in order for defense counsel's point to make any sense, would have had to go into this pristine pocket
Yep.
by these pants, leaving no blood on the knife or on the pocket or anywhere. Didn't happen. Didn't happen. Mr. Cleereman, according to Rotrell Cameron, gets into a boxing stance, and Rotrell said, I just would have boxed him. But the defendant pulls his firearm, he aims it, he puts one right above his eyes, right above the eyebrow, into the victim's brain, which causes him to drop, a fatal wound. And keep in mind, ladies and gentlemen, what the ME told you about that. Slightly upward. Slightly upward. Front to back, no left to right deviation. It's a straight on shot, just like all four witnesses described. Raising his hand with a gun in the hand, because when someone's got a weapon in their hand, you know what it is. You see it.
Told him to speak up a little.
You see that weapon.
Too much drama.
Could you make this
Four
point
people
harder, counselor?
Saw that gun in his hand. Not because it's down by the side and there's a lot item or they saw the gun because that was the threat and that was the weapon. And Mr. Cleereman takes that bullet into the brain. And what does the defendant do after that, ladies and gentlemen? He runs. He takes off. Instead of taking the direct street there, he ends up taking a bike path in which police would not be able to be driving down. He takes the most obscure way to get to his house where he can't be found or seen by individuals. He gets into the house and he ditches. What does he ditch? The bike. The first thing, the main thing that everyone's saying about who he is the bicyclist. He gets rid of the bike and then he walks and he goes. And all we know is he never comes back. The gun that he used, according to him, he just throws it out the window because he, doesn't want someone to shoot him with it. Something that meant that he kept onto it, held onto this murder weapon for weeks through 2 states until all of a sudden he hits the cornfields of Indiana as though some voice comes out and says, if you ditch it, they won't find you. No, ladies and gentlemen, he's getting rid of the gun.
Field of Dreams
2
reference.
states away because he's trying to avoid getting caught.
Not very well done.
That's why he dyes his hair. That's why he goes on the run. That's why he says he's from the Bahamas and tries every last ditch he can to not be held responsible. And when they come down, he plays dumb in the hopes that we won't be able to put it together on him. And then, ladies and gentlemen, it's all, the victim must have had a knife. And when that falls apart because their witness doesn't see anything in the wife's hand and there's no evidence to support he had anything, not one single witness supports that, all of a sudden, at the 11th hour, we go from, yep, I was defending myself, to it's an accident. He tried to get away. He tried to lie. He tried to play dumb. He tried
We need
to
a This
say
Is
the
Agu
victim was
country
doing
shout.
something. And now it's just
Oh.
an accident.
The hell was that?
Is that me?
I
Now,
don't know
ladies
what
and
that
gentlemen,
was. Might have been the court.
those are the facts.
If it came through to you and me, that was the court.
And now you need to consider them in terms of the law. The first count you consider, ladies and gentlemen, is first-degree intentional homicide. The counts and elements are fairly simple. First, did he cause the death of the victim? Clearly he did. He shot him
I
in the
love
head.
the
He
big
falls down
notepad.
almost
Way more than a
immediately.
fucking
It's a mortal
slideshow.
injury.
Yeah.
It's a
Should have
substantial
been bigger
death.
though.
The defendant, under all circumstances, is the cause of the victim's death. Did he act with intent to kill? He raises his arm, according to 4 people, and shoots the victim in the face. The gunshot, front to back, slightly upward. That's not consistent with anything the defendant testified to, but it is consistent with 4 witnesses and video that show him with his arm, and the victim goes down. And intent to kill means this, and this is very important. Practically certain to cause death. That the defendant knew that when he shot the victim, it was practically certain to cause death. He told you he's got weapons training with all his maritime security. He's gone to the range. He's been taught on how to hit what he shoots at. Well, he did.
Whoops.
And when you shoot and aim at someone's head, that is practically certain. He knew that. That is intent to kill, ladies and gentlemen. That is intent to kill. And now we get to how self-defense factors in. The third element of intentional homicide is that the defendant did not actually believe that the force was necessary. Did not actually believe. But this only comes into play if you don't believe he provoked the attack. A person who engages in conduct likely to provoke an attack and who provokes an attack is not allowed to use force against the attack. However, as defense counsel will tell you, and as law says, if he withdraws and he makes it abundantly clear, he can regain that ability. But keep that in mind about actually believing the force was necessary. He is confronted with a man that he punched in the face. That man has no weapon. He has a gun. He withdraws it and he shoots him in the head. He started a fist fight and then he brought a gun to it. He started a fist fight and he brought a gun to it. That's what happened. And that's what he did. He did not actually believe he had to shoot the victim in the face. When the victim said words, he punched him. When the victim gets ready for a fight, he kills him. Every escalation of the violence in this case has come from the defendant. Every time. There is no weapon.
Keep in mind, folks, I think he's doing a fine job,
Now,
but you
ladies
don't
and
really know the quality of
if,
closing
for
until you
whatever
hear the other
reason, you believe
closing.
that the defendant
Yep.
did
I don't
actually
expect
believe
much from the
force
defense
was
closing, but
necessary, and
worth keeping
did
in mind.
actually believe that he was acting in self-defense and that there was a threat of unlawful interference, and there's no evidence to support other than his incredible testimony, then, ladies and gentlemen, you go to the next question, which is second-degree intentional. Again, he caused the death, intent to kill. There's no doubt about that. But then we get to do not, whether or not the defendant did not reasonably believe that the force was necessary. And if any one of these three apply, any one of them apply, then the defendant is guilty of second-degree intentional. A reasonable person would not believe he was preventing or terminating unlawful interference. He punches the victim and then shoots him. Keep in mind, this is someone who said he just couldn't let the victim get away. The next one is a reasonable person would not believe he was in danger of imminent death or great bodily harm. When he is looking at the victim, there is no visible weapon. As Ruttrell Cameron told you, he just pulls it.
Ruttrell.
In the head. Remember that. On the 911 call and to the police officer, he just shot him in the head. He just shot him in the head.
Cold-blooded.
Please. And the last, ladies and gentlemen, is that a reasonable person would not have believed that the amount of force used was necessary.
Breyer just announced his retirement.
Brought a gun to a fist fight he started. That's not reasonable. If, for whatever reason, you do not believe that there is intent to kill, and you should, because under the law, as we've talked about, it's practically certain to cause death. His training, he knew it. He's been trained. He knows how to hit what he shoots at, and he did well. Unfortunately, in this case, you get to reckless. again, caused the death. We know about that. But then we get into criminally reckless conduct. Did he create a risk of death or great bodily harm? He shot him in the face.
I love the bottom of his note.
Was that
Guilty.
unreasonable? Did he know it was unreasonable and substantial? At a close range, when that individual, the victim, according to Mr. Cameron, according to other people, are just going to confront him, no weapons, no punches, no nothing. He pulls a gun and he shoots him. That is unreasonable. He knows what he's doing. He's been trained. And in this situation, ladies and gentlemen, when you get
prosecution's getting a lot of mileage
homicide,
at weapons
the
training
actual
remarks.
and reasonable belief portions of self-defense apply. It's not like an intentional where if, he actually believes, but it's unreasonable, it's second-degree intentional. In first-degree and second-degree reckless, if you find it to be unreasonable what he did and you should, then he's guilty of either one of those, depending on how you view the last. And this is important. The last element of reckless conduct, utter disregard for human life. And in this situation, ladies and gentlemen, you are told you consider the defendant's conduct after the incident. You shot a man in the face. That's utter disregard for human life. And the last one, ladies and gentlemen, homicide by negligence, this thing that comes out of nowhere. After days of talking about how the defendant was forced out of self-defense to raise the gun and fire it, all of a sudden, after every other thing that has been tried has failed, we now get the gun was pointing down. All of a sudden, the guy is spearing him, and it goes off. Except the ME and the witnesses show that that's not what happened. He doesn't get slightly upward, front to back, no left to right deviation, except for in the way in which 4 people said it. Pulls the gun without warning, without anything, and he just shot him in the head. Ladies and gentlemen,
Hey, Joe.
in the beginning, defense counsel came up and he said, you see my hand? You see everything? You see everything about my hand? Well, someone did see all portions of a hand. The defendant saw the victim's hands. There was nothing in them. And he shot him. No weapon. Just a man who's confronting the defendant after the defendant punched him in the face. For that reason, ladies and gentlemen, he's guilty.
Wow.
Okay, hang on one second.
Guilty. Break.
Well, that was quick.
Didn't need much time. I'm glad he didn't belabor it.
I'm glad I didn't miss B. Ivory standing up for this.
I mean, that was 20 minutes, roughly. I think he started around 11:55 or 10:55.
All right, we'll take a short break. 5 minutes. Everybody can stretch your legs, get a glass of water. Can my bailiffs follow the jury out? Everybody in the gallery, silence, seated until the jury comes out, please.
Well, I mean, that was a very straightforward and I thought a very good closing statement. He hammered home on some of the points that the defense counsel has been trying to raise, that B. Ivory raised, this weird maritime training that should have never come in. I mean, the idea that I don't know what the defense was thinking bringing that in.
Jury's
Redirect.
out, short 10-minute recess, off the record.
I don't think the state had any idea. I mean,
No.
it only came up on redirect, right?
Yeah, only on redirect when they were trying to rehab his, it was a complete accident thing. I guess I still don't even know why it would be brought up in the first place. It had no relevance to this case until they made it relevant. I mean, they gave it relevance by that's one interesting thing, guys. If the prosecution had tried to raise the maritime training on his own, it might not have really ever come in. I don't know. I mean, I guess there would have been objections to it. Either way, it wouldn't be objection, Your Honor. What relevance does this have? He was a security guard years ago. That's not what he's doing at the time, anything like that. They would have had to argue over it. The defense bringing it in, though, puts it right in the it just puts it right in the lane. You don't have to worry about it at that point. Then you get to make it as relevant as you want. And with this, I mean, he's arguing that he had guns, he had weapons training. He shot him in the face. He didn't shoot him center mass or wing him in the shoulder first or fire 3 rounds. One shot, one bullet right in the brain. Game over, lights out. And surely that could only be done by someone with the extensive training of a security guard, dock worker, or whatever it is that they're claiming, right? But it doesn't matter because it sounds good now. And then that other line that he really focused on that I like that he did was, I couldn't let them get away. And the way he says it, it sounds so much more menacing than when Edgecomb said it, right? I just gotten hit. I couldn't let him get away with that, or I couldn't let him get away, or whatever it was. Like he wanted to go see what, follow him and make sure justice was served. It turns out that sounds a lot more like murder when the state's saying it than when you say it. So pretty interesting strategy. Any thoughts, Andrew? And I guess I'll welcome Joe to the stream.
I mean, I think it was fine. It was nice and concise. I think it hit all the key points. And of course, he's going to have an opportunity for rebuttals. So it's not like he has to, slam every nail down into the wood in finish fashion.
Right.
So part of it is there's still some, you're not sure what you really need to drive home for the jury until you hear the defense closing, which he'll do now. So, which I expect will be a lot of racism and word throwing around and shouting, and we'll see.
Yeah, I think that's what we can expect.
Daddy-daughter night, a lot of daddy-daughter night.
Right. How he's a great father, has special bonds with all of his children. He's engaged to be married to Ruby. His life's just getting started. It's interrupted by this evil attorney and his drunk wife trying to run him off the road and kill him, and then. And then
I expect Ivory to take the whole hour and a half. I mean, that's been this defense pattern. Every time they have a chance to redirect, they redirect, or recross, they recross. They always pretty much go the extra step, with rare exception.
Yeah, and it's going to be, the bingo card will be if we hear Ahmaud Arbery, George Floyd, Freddie Gray, if we hear maybe even Trayvon Martin. That'll be Sandra Bland. If we hear the bingo card of racism dog whistles, that'll be that's what I'm looking for. I want to see how far B. Ivory's willing to take activism, potentially to the detriment of his client. So what's up, Joe? Welcome to the stream, buddy.
Thank you very much. It's a first time visitor, long time listener. Yeah, I expect Ivory's going to use every minute that they allow him. I think it's an interesting thought in the concept of the prison justice of the prison system. There's 2 reasons to put someone in jail. One is to punish them for past crimes. Another is to keep the public safe for them in the future. And painting that, I couldn't let them get away for these people who had slighted me is not just justice for the past. Like that it was a wrongful vendetta that he was on, but it makes him sound menacing for the future. It's like someone else is going to bump up against him, or he thinks he hears the N-word from someone. Let's say, let's give him the benefit of the doubt. He thought they said the N-word, even if they didn't. And that happens sometimes. No one actually considers that possibility. Now, whatever words came out of his mouth, let's assume he didn't use the N-word, but this guy heard the N-word, and that's how it registered with him. Is that someone that's really safe to go running around on the streets? That it's like, this guy called me the N-word, I can't let them get away, I'm going to go over there and punch him in the face, and if this escalates, I'll draw my weapon on him. Like that makes it okay? That's not okay by any normal person's yardstick. So in that sense, I happen to like making that sort of a theme. So yeah, but I do think the closing is the moment that B. Ivory Lamar was waiting for when he first was retained. I think that this is what he's been salivating over since the day he first heard the name Theodore Edgecomb. The concept of giving the closing argument here.
This closing, along with the post-trial interviews, I mean, This is a guy who has been on stage with Ben Crump. He's been interviewed on multiple news outlets. He was interviewed for his astute, learned opinion on the Kyle Rittenhouse verdict. He talked about how racist it was and all of that stuff. I mean, this is a guy who is he is primed for this. This is where he will make his bread. It won't be in the trials.
Nope.
It'll be in everything else that he does. The subsequent trials. Remember, this is a quote unquote civil rights attorney and personal injury lawyer, which means he's trying to follow the business model of Ben Crump. And if he does that, his real bread will be buttered when he negotiates multi-million-dollar settlements for families of victims of quote unquote racial violence.
Mm-hmm. And he's in a win-win position, because if he wins, great. If he loses, well, that's just more proof that black people are victims of the system.
Well,
so,
in reality, he won't even have to fight, right? Like Ben Crump isn't showing up in court.
Right.
Ben Crump is negotiating these things out. The city, they push their insurance to the limit on what they've got. They get any slush fund money they can contribute in. They come up with some obscene number for the death of someone. And I say obscene number in the way that we calculate the value of a human life in a wrongful death type situation. It's typically calculated on economic value. So not to sound like a rude prick or anything, but if anybody thought that George Floyd's economic value was going to be $27 million, I mean, I just don't understand where it's going to come from. This guy is not the CEO of a Fortune 500 company. So those calculations are thrown out the window in negotiation, where a city has other people's money to spend and political pressure from one side and political expedience on the other side. They can eliminate this problem by spending someone else's money. They're prone to do it. It's a great racket that he's trying to break into, and doing cases like Edgecomb, win or lose, will get him into that based on how he handles his post-judgment interview.
Well, you can look at it two different ways. One is you could say, okay, what's this person's value? And so if you look at this person's value or expected value over the balance of his life, tack on a little bit for pain and suffering, and move on, in which case the number would be considerably lower.
That's the normal way.
That is the normal way. But on the flip side, to be fair to the city, and I'm not saying this because I agree with the city, I'm saying that, you sort of need to look at both sides of the coin if we're going to assess things, fairly. If they did go to jury, you don't think it's possible the jury would literally say, we award George Floyd $1 gajillion? Like they'll make up a new number?
But I don't think the government who's paying the money cares about that. It's still not their money. They just care about the political heat
100%.
going away as quickly as possible.
100%.
But those
I'm just saying, if you're an attorney, if they did care about money, do you not think it's possible that a jury in the George Floyd case would literally say $500 million?
And that could happen in any jury. I mean, that's why there's such a powerful incentive
it's
to
George
settle.
Floyd. It's George Floyd. It launched 500 protests.
But even so, okay, so those make the headlines, but then what follows is when the appeals court comes in and pairs it down with reality. And they do this all the time on the settlements or on those jury awards. So they go, okay, yeah, this is an unreasonable calculation of economic value, because you can't calculate the other stuff, and the court can't remedy things like hurt and loss in many states, Minnesota being one of them. So yeah, that is certainly possible. I mean, you raise a good point, but but my whole thing is, this is why B. Ivory Lamar is here and waiting for this, is for whatever happens here in closing argument, followed by the post probably conviction interviews, where he gets to reference his Kyle Rittenhouse discussion about how the system is racist. Never before has a black man gotten this kind of treatment. Only this white boy, blah, 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 blah. And then now he's going to say, see, this is what I was talking about. We have a real problem. There's an injustice. There's disparity between how Rittenhouse and my client, who are the exact same, were treated. I mean, I remember that time where Rittenhouse rode up on his bike and punched some guy in the face. That definitely happened. And so he's gonna go ahead and point out how they're the exact same. the exact same defenses. They even use the same video expert and some of the
Yes.
same tactics that the Rittenhouse team used, and they just got different treatment. And it's all because of the systemic racism of Wisconsin. He's
And that's
primed
why I
for it.
said this is a win-win situation. There's no possible loss here for him personally, because
Right.
these are his stripes. He's earning his stripes here. And if he gets a win, it only shows what a phenomenal attorney he is and why everyone needs to retain him. And if he gets his loss, he's like, hey, I watched firsthand about the injustice of our judicial system. So
and keep in mind, if he gets to Ben Crump status, he'll never have to go to trial again. I mean,
course
Benjamin
not.
Crump doesn't go to trial. So the fact that B. Ivory's not, by all appearances in this case at least, not a very good lawyer at all, won't hurt him in the long run, because he won't be going into trial.
yeah, that's probably good. That's probably the best thing for his clients anyway. So if you think about it. So, I mean, who would ever want to be represented by him ever again after watching this?
All he'll need to do is apply media and political pressure to people who are scared of media and political pressure and can spend other people's money, which is not all that difficult to do.
No.
So that'll be good. Yes. Supreme Court Justice Stephen Breyer has announced his retirement. I don't know the details of it. I'll probably be talking about that at least in part tonight. But Breyer is going to retire. And if that doesn't indicate to you just how scared the left is of losing the Senate at the upcoming elections, I mean, that should be the thing right there. Because if they lose the Senate, in theory, the Republicans could stonewall them on appointing a 9th justice through the 2024 election. I mean, I think that'd be ballsy. I don't know that they would actually have the fortitude to do that, but they're afraid of losing the Senate because of that possibility. Breyer's indicated over and over that he was not really ready to retire. He wasn't going to retire from political pressure and all that stuff. And then boom, he does it now, 9.5 months before election day. Very, very interesting, but I'll be talking about that later on the nighttime show. I think it'll be an interesting discussion.
And with any luck, we can get another Justice Sotomayor. That'll be awesome.
Oh God. Yes. Oh, that'd be great.
That's exactly what they're going to be looking for.
Sure.
Maybe someone who's less of a health risk during a COVID crisis, but yeah, that's exactly what they're going to be looking for. Is trans maybe per judge. They're going to be looking for, or
here's Joe's agenda.
Look, I'm going to put it out there just in case. It's the one
available.
condition.
I'm
It's the
available.
one condition I have where I would stop doing the Ricada Law YouTube show is put me in the Supreme Court.
Get appointed. You can keep doing the show. How are they going to stop you?
Don't tell them. Don't tell them.
That's the way to silence Nick Ricada. The way we
Go ahead and
silence
get
him
me
is
in
we put him on SCOTUS.
I'll take it. Okay, we've got a couple super chats to read before we get back. Briella was asking, how do you also support on YouTube? There's a membership button. If you want to do it, it's purely there for people to join if they choose, and there's access to some small amount of extra really rare content. I do not encourage or promote it. I prefer, you've already done the thing I prefer. You've signed up on Locals, and I thank you for that. But it is there since you asked. The problem I have with YouTube memberships is very simple. If you get a strike from YouTube, then that makes a minimum of 1 week, if not 2 weeks, that you cannot talk to your paying members. And I think that is basically theft. And I hate that. I think that's ridiculous. I get that they don't want you to upload, but not being able to talk to your paying community and then not refunding them for the portion of the month that they lose is even at my expense, because that's what I would prefer, like prorate their monthly payment, but whatever. So that's why I do not encourage people to sign up.
I will let the defense do their closing. I would encourage the defense to take the advice the state did and not use the entire hour and a half. It's really not necessary. And 1.5 hours is an absolute hard stop. I'm going to go through lunch. I'm going to tell
Talking to you, B. Ivory.
I've ordered them lunch. Let's bring them in.
Sean CHYT says Norwegian money from Norway. Hey, thank you. Briella says, did my other super chat about how to become a member on YouTube go through? Yes. YouTube closed the app right after I sent it. It took me a couple minutes to get back in here. Thank you. It did. And I know exactly what you're talking about. It's done that to me before on several occasions, which is super annoying. Dad, It's Only Plastic says, hey, Nikki Rackets and fellow attorneys, love the stream. Gets me through the slog of work. Attorney Bronca, I ordered your book through the website and looking forward to reading it. Cheers, fellas.
Thank you.
Nice.
Rball 716 says the frustrating thing is I can see a valid self-defense argument based on the actual evidence. He threw that away in the 6 months after the event, and the defense attorneys in his testimony buried it in the Mariana Trench. Yeah, it's overcoming that 6-month fleeing is that's a Herculean task. You know, if they happen to win this.
Remember when Kyle Rittenhouse fled for 6 months?
Same case. Lancelot 652 says, objection. I don't think he was playing
All right,
dumb.
Jerry's coming in. Silence in the gallery.
That's just a fact and evidence. Synapse says, once we get into deliberations, could you compare his call for self-defense to Rittenhouse's? I can see glaring differences, but there's been odd ones out in the chat the whole day. Oh, yeah, sure. Well, we can talk about that a little bit more during deliberation. Jackson Kai says, they must not think a Democrat will hold office for 2 decades if they talk Justice Breyer into retirement. Got to get it in before that midterm finally sinks the flooding ship. Darren Haviland.
Back for the jury. We're going to work into lunch. The defense is going to do their closing. The state will have an opportunity to do rebuttal. I've ordered lunch. Lunch will be waiting for you. So we're going to work into lunch, get the closings done, and get the case to 12 of you to deliberate. Defense can proceed.
Darren Haviland says, that was a great point about the pocket and the blood. How long does prosecution get for rebuttal? Up to their hour and a half.
Robert Kennedy once said,
All right.
Here we
"Order
go.
of justice
He
and the
watched American
majesty
History
of law
X. Start with a
are
quote.
created not just by the Constitution, not by the courts, nor by the officers of the law,
He's giving
Nor by
them
the
weird
lawyers.
parallel universe law.
but by the men and women who constitute our society, who are the protectors
I guarantee
of the law,
he's going to try and come up with a
as they are
catchy phrase.
themselves
Like
protected.
if the glove don't fit,
by
you
the
must
law.
quit or hocus pocus. I guarantee he's going to try
Members
something.
of the jury, it's been
That's my
over a
gut
week
is
now.
saying. I'll be
And
really disappointed if it
as
doesn't.
the state has pointed out, you know, I've seen you very active and engaged in this case. You've been taking notes, and this is a traumatic situation, you know, for both parties that's involved in this case. This case has been filled with emotions on both sides of this case, and you know, we really just thank you for just, you know, keeping an open mind as we go through the process. Now, the state just talked about, when we talked about the other side of the story. Remember that? The defense in this case has established everything that we said we would show you on the other side. The state didn't come up and talk about a wallet. You never heard about a wallet in this case.
This is it.
We
What?
told you that the
This is it.
crime scene was contaminated. We told you
The
that
wife said,
seconds afterwards, there was tampering of evidence in this case. We promised that we would show it to you. That promise did not come back void. Now we're talking about a wallet all of a sudden. Now, 1.5 years later, there's an explanation for a wallet. Now, the truth of the matter is,
from the start.
no party here knows exactly what took place on September 22nd of 2020, because the state has not satisfied and filled their burden. They haven't proved anything beyond a reasonable doubt. What they've shown is theories. They haven't proved anything beyond a reasonable doubt. They just came up and said, oh, he didn't have a weapon. And then, oh yeah, okay, it was a weapon in his pocket. Then they talk about, oh, well, it was a folded knife in the right pocket. Oh, no big deal. As if it takes so long for a folded knife to become a threat. Here's the knife. It's folded. Could go in a pocket very easily. Here the knife is extended. How long does it take for the knife to go from being extended to being folded? Let's find out. less than a second. Now exploded. Now, just at the onset here, I want to discuss a couple things with you. You know, you've heard a lot of testimony in this case, and this is a case that, as you can see, just with the coverage of this case, it evokes a lot of passion. You know, this case it's a precedent-setting case. Nope. You know, this is a rare case that has been presented to you, where this time there's an African-American man now using self-defense against a Caucasian man.
Happens all the time.
You don't see that every day.
Yes, you do.
And he's not just anybody. The evidence is so he's not just anybody. He's somebody that's well respected in this community and has been referred to by many as a prominent immigration lawyer.
By who? Who in this case?
So,
he said the evidence will show. It's still an opening.
Those circumstances. Now, I want to be the first to tell you, we put Mr. Edgecomb on the stand yesterday.
We didn't have to do
Now,
that.
we thought about not putting him up for a couple reasons. Number one is because the state hadn't given their burden to begin with. Mr. Edgecomb insisted, I want to tell my story. We promised you in the opening that we would have him up to tell his story. But Mr. Edgecomb was scared. The same fear that he had after he's been hunted down by these two individuals. That same fear where he described
the Filipino wife.
Ahmaud Arbery.
Oh, there we go. Drink.
Same fear he had with turning himself into law enforcement and wondering if he could be taken into custody safely, as he described what he recalled from Sandra Bland.
Drink.
That same fear he exhibited on this stand yesterday.
Arbery and Bland so far.
Now the state would say, "Oh, we can't trust this testimony." Well, let's talk about his testimony. Mr. Edgecomb, we felt it necessary to get out all the bad facts right away. We told you in opening, we're gonna talk about the good, the bad, and the ugly. I told you at the very beginning of the opening statement, there's three things. Mr. Edgecomb was not supposed to have a gun. He temporarily, not supposed to be in possession of a firearm at the time. We told you that. He's taking responsibility for that. You heard about Bill jumping charges in this case. He's taking responsibility. We also told you.
How do you take responsibility for the gun?
Did in fact punch Mr. Cleereman. He never disputed it. You heard him come on the stand and take responsibility for it. You heard him come on this stand and say, if I could do this over.
On rebuttal, I would definitely hit this take responsibility. He wants to take responsibility. Let's help him do that.
Chance to do this,
yep.
I would simply accept being hit by a vehicle, thrown into another, and being called a nigger.
Oh, there we go. Drink.
Okay.
That's the first one, right? I'm going to keep a count.
What else did he admit on direct examination? See, it's not easy. This is the first time that Mr. Edgecomb ever been sat in a witness box before. This is the first time he ever been charged with murder. These are serious charges.
Hey, it's his first murder charge. Come on, he's not used to it.
Especially in the city of Milwaukee, where you have amongst the largest incarceration rate for African-American men.
Drink.
Of course, he had every right to be afraid. Now, you might say, well, why was his demeanor a little bit different with me than he was with the state? Let's talk about that. Well, first, I will tell you, when I first met Mr. Edgecomb, he was a little bit guarded even with me.
Objection, Your Honor. As to defense counsel testifying.
Sustained.
Yep.
Jury.
Sustained.
This is insane.
Watch shots of hyperbole.
Mr. Edgecomb has had fears. He going before a government.
It's about to violate his attorney-client privilege too.
Use that type of force against another race. Mr. Edgecomb,
Drink.
He was afraid of being tripped up. Now with me, he's a little bit more comfortable. He's got a chance to know myself, an attorney of mine, over the pendency of this case. It's a little bit different. But he understood that one wrong answer could potentially get him convicted of murder.
This is not a very credible explanation for his demeanor.
One
on
wrong
cross.
answer
We
could
talked
get him
about before
convicted
that
of murder, is what you're going with? I would
he
hit
has
on
a
that real
diagnosis
hard.
of attention deficit disorder. We don't want to play that up. He's a very intelligent person. But
Is
it's
that in
real.
evidence?
Objection.
And
Assumes facts,
sometimes
not in
the
evidence.
effects of that
The ADD is,
show
yeah.
itself when you're in a very highly stressful situation.
The intelligence, not so much.
Attorney Hubner, great attorney. There's times that both of us have had to exert a certain amount of aggression or a certain amount of assertiveness to get the evidence in this.
Assert a certain amount of assertiveness.
Evidence, it doesn't just present itself.
This guy's no
Sometimes
Ben
you have to
Crump.
dig, you have to keep going. And there were times in this case, if you recall, Mr.
To be fair,
Edgecomb,
do we know that Ben Crump is any good at all?
I've heard him
You know,
speak a lot.
trying to
He doesn't
complete
speak like
sentence.
this.
it was not allowed to. He wanted a simple yes or no. Well, every answer does not result in a yes or no answer, but that's the position he was in yesterday. Now, Mr. Edgecomb testified. You heard him say. Now, Mr. Edgecomb had, if you recall on cross-examination, he talked about, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecomb believes that he's already made it clear that he shot Mr. Cleereman. He intended to shoot Mr. Cleereman to stop a threat.
Objection.
He did not, however, intend to kill someone.
Objection. That's not in evidence
There's
at
a big
all.
difference. So every question that discussed
That's literally incredible. You
homicide
can't
or
shoot
murder
someone in the head
or
and
blowing
not be
someone's
intending to
brains
cause
out,
them fatal injury, deadly force.
of course, Mr. Edgecomb was taken back by that and did not want to answer a question in a certain way. So he kept resorting to, my actions were in self-defense. I acted in self-defense.
He was asked. He said that
And
also when he was asked, "Did you run away?" I acted in self-defense.
Did you carry the bicycle down the stairs?
Is to
I acted in
consider
self-defense.
the reasonableness of his actions. We all know he shot Mr. Cleereman. We established that in opening statements. The question for you, though, is the reasonableness of those actions. Part of determining the reasonableness of Mr. Edgecomb's actions is when did he decide to shoot Mr. Cleereman? At what point did he decide to shoot Mr. Cleereman? That's the question. That goes to reasonableness. So Mr. Edgecomb
State closing was 23
kept
minutes.
reiterating the shot went off at the time that he lunged at me. He's trying to explain to you the reasonableness of what he felt was at the time that he shot. He's not trying to imply that, oh, this was just an accident. He's only trying to discuss the time frame. The shot went off after he lunged at me. Now, Mr. Edgecomb's no lawyer, not a doctor. He was on his way. I mean, he had just a few credits away from a
It's on his
psychology
way.
degree. He had a bright future. But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use.
Yeah, I would use the correct word.
So we don't discredit Mr. Edgecomb based off of wordplay. So when he says,
Wordplay.
oh, the gunshot goes off after he lunged at me. And he
16
followed by
times. It's
a very good aggressive question by the state that says, oh, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute.
He says yes.
Can you answer that in a yes or no?
Yeah.
He said
yeah.
yes. He just, that's what he ultimately said.
Oh, what
He doesn't
did
wanna
it mean
say,
though? Say it.
I intentionally killed Mr. Cleereman. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat.
It's not what he said. He never actually asserted that.
Techniques
Kyle
used
asserted
by
that about
the
50
prosecutor.
times.
Please don't hope that against Mr. Edgecomb. Go back to your notes.
Please don't
See
hold
what
his own
Mr.
testimony
Edgecomb
against him.
testified to on direct examination. On direct examination,
Only listen to our version of the
Mr.
narrative.
Edgecomb not tell you, I went down the stairs.
This is classic.
No,
Believe
no,
what I
no.
tell you, not what
I
you've
put the
seen.
gun there. Go to your notes. Did Mr. Edgecomb not tell you when I asked him? I was right here, and I asked Mr. Edgecomb, did you give the police your ID at the time you were apprehended in Kentucky? Mr. Edgecomb said, what on direct examination? No. On direct examination, I asked him, did you give them a fake name? Did you give the Kentucky Police Department a fake name? What did Mr. Edgecomb say? Yes.
He told the truth about lying.
I asked him direct. Why did you do so? Go to your notes. He explained it. He explained it.
Racism.
Then on direct examination, I also asked Mr. Edgecomb, did the Milwaukee Police Department detectives come down and when they asked you about something happening in Milwaukee, did you say, what happened in Milwaukee? Mr. Edgecomb said, yes, I said that. Members of the jury, there was a follow-up question to that. Why did you say that? When Mr. Edgecomb was comfortable, he answered the questions. When he's comfortable, he did not hesitate to not answer one question.
Did not hesitate to not
Fear
answer.
is real. Attention deficit disorder is a disability. It's real. Anxiety is real. Being charged with murder are real feelings.
That's a feeling.
Every other witness that stepped up here,
What's it feel like to catch a bullet in the
they had
head?
a bad day on the stand.
Is that real?
We got some information out, or they answered a question the way that they might not have wanted to. You know what happens to them?
Man, when you're spending your
They go
closing
home.
explaining away your own
They have
client's
dinner,
testimony,
They
that's
get up
rough.
to the next day, and that's it. Not when you're the defendant in a murder case. That answer could determine whether you're convicted or not. That's the reality.
I hope the prosecutor
That's
gets up
why
and says,
before he feels like he's
these
getting
answers weren't a
tripped up on
gotcha. We're not
something,
pulling
he-
one answer out
he
of his
answered the-
entire
he asked the
testimony.
question again.
It was his entire testimony. This guy just spent an hour telling you about how bad his client's testimony was and how one wrong answer would get him convicted of murder. Pretty
Now-
sure you can find more than one.
We talked a lot about, the fear. We talked a lot about, what happened on the stand, and these are red herrings. It's a red herring. It's a distraction.
Why are you talking so
So
much
now
about
let's
it?
talk about the state's burden of proof. Let's discuss it. They have the burden. As the court has appropriately indicated,
Well, this
the
is
defense
fair.
doesn't have to prove anything. Though
Fair.
everything we came up and talked about, we showed you. In opening, we told you. We've shown that. So let's talk about the burden of proof.
Well, not prove anything is a bit strong. They have to raise a reasonable doubt as to self-defense.
Oh, here we go with this little chart you got here.
This is right out of the George Zimmerman trial, and it's a smart move. I would encourage all defense lawyers in
Now-
self-defense cases to do this.
As you see, the state has that burden. There's a lot of different thoughts that you might have. When you get different parts of evidence, it might.
Zimmerman
favor
was
that.
smarter, his counsel. They did this in voir dire.
So
it set the
important to
tone from the
understand
beginning.
that It's only the state that has the burden of proving something beyond a reasonable doubt. It can't be probably, it can't be maybe. So let's go through what the state's witnesses showed us. In fact, we actually like the state's witnesses.
Sure you
In fact,
do.
we would have, there's a couple of people that was noticed on the state's list that we thought were great witnesses, and we called them ourselves. A lot of
Like Kelly?
reasonable doubt can be established just off the state's witnesses. For example, let's go to the first slide. So we discussed reasonable doubt. Again, it's not probably guilty. It's not guilt likely. None of that. All that will result in not guilty. If it's not beyond a reasonable doubt, it's not guilty. And at the end of this presentation, we're going to ask that you find Mr. Edgecomb guilty on all counts. We started
What?
with first degree.
Wait, what?
intentional. You're
They
gonna
asked
see
us to
some
find
lower-
Mr.
some lower
guilty.
charges that have been added. We're going
Just
to
go
ask
with it.
that
Just go
all
with it.
charges
It's good. It's all good.
that you find Mr. Edgecomb not
I wonder if
guilty.
it's available if I ever needed.
Mr. Rotrell Cameron. Now, this is probably one of the most memorable witnesses.
It was
in
so
this case.
favorable to the state, and they brought
He's
him
the
in in
only
shackles.
witness that was brought in with the orange jumpsuit. Mr. Rotrell Cameron, let's go over his
This is nice of them to remind the jury of all the good facts.
Cold-blooded. He stated that the shooting appeared to be cold-blooded.
Let me tell you what
That's why
a
the
black
state
person means
liked
by cold-blooded.
his testimony. That's what he was brought in for. Mr. Cameron testified that he was going to pick up his subpoena.
All right, we need a break.
Council back to your table. We need a break.
No, someone's got to
Uh-oh.
pee.
Clear out. I need the gallery cleared right now.
Uh-oh. Something bad
Out.
happened? Was that, did
Quietly
the
and professionally.
state jump up and object?
Is there something on that slide?
Doesn't look like there's anything.
Well, if it says the Cleeremans were driving aggressively, but only one of them was driving. That
It
doesn't
can't
seem
be just
important
that.
enough. That doesn't seem enough. I want to hear
Oh.
the judge use the F word.
He just ran and grabbed a garbage can. Someone's about to throw up. Or someone did throw up, maybe.
Or maybe that's a defense case going into the garbage.
Someone ate the
Uh-oh.
fish.
Well, I guess the courtroom cafeteria relay.
Wow.
The camera did show the backs of the jury for just a second of some of the jurors, but not for long. Someone collapsed in the jury box, possibly. Yeah, someone could have passed out.
I agree with your vomit theory with that garbage can.
Well, if someone's passing out, they might have grabbed a garbage can too. Good thing they got an alternate.
Yeah, can you imagine if they end up with like only 11 folks?
I think it's actually.
They only have one alternate left. They got rid of one person left because of the death in the family.
Right.
You can go down lower than 12 in some states.
Yeah.
On a
As long
murder?
as long as it's not like, as long as they panel the amount of jurors and there's like, appropriate circumstances for it. It
Is
still
that
has to
right?
be unanimous. I think so.
So there were two states, I think it was Oregon and Louisiana, where you could have a super majority of 12.
Well, no, but
to convict.
I'm saying, if you have a unanimous jury, but it's less than 12 because of, unforeseen circumstances.
That's interesting.
I'm pretty sure. God, I'm trying to think what that one is, but well, so far, I mean, I'm not overly impressed. I should show this on stream. Someone sent me this. It was Ken. Ken sent me this. Hold on. This is something. I wish I could have handed these out to the class before this started, but here we go. Come on. The Edgecomb defense closing bingo. We have systemic racism, Sandra Bland, racist
Check.
police, systemic racism again, Kyle Rittenhouse, MLK and Malcolm X mentioned, Eric Gardner, slavery throwback, Trayvon Martin, the first incident, white cop / prosecutor mention. We have that one. Kyle Rittenhouse again, free N-word space, N-word used. We got that one. Nonprofit mentioned. That's probably coming. Accidentally went off. George Floyd. Why is that George Floyd?
It must be or
accidentally-
George Floyd.
Yeah. And accidentally went off. I think, they were supposed to be separated. But we do have the accidentally went off. First incident again. Uses all 90 minutes.
Senator Bland's a twofer.
Previous attack mentioned racist police and Trayvon Martin. So there you go. So far, we've checked a surprising amount of those boxes, and we're barely even started. So that's good. That's good stuff. I'm not impressed so far with this opening. Like you said, it's bad when you have to spend a big chunk of your opening explaining away.
Was it 15, 20 minutes? It was a long time.
Yeah, it was quite a while.
I do like that beyond a reasonable doubt chart. I'm a big fan of those to really make it. But I would have done it at the very beginning. The Mark O'Mara and Don West in the Zimmerman trial used a chart like that in voir dire to emphasize to the jury that, to overcome the self-defense, legal defense, the state has to disprove it not by this much or this much or this much or this much, but and then they raise their hand all the way to the top of the chart by this much. So the jurors put in that frame of mind before they even hear opening statements. And then they asked the jurors, the prospective jurors, to affirmatively, that's the law, the judge will instruct you. Can you tell us now that you will do that? Will you commit yourselves to that standard? And they all nod, of course. And that can make all the difference.
I agree. And I also think that it's cool. You should make that chart high. So the guy has to reach all the way up.
Yep.
It's just sort of subconsciously, it is theater, but it subconsciously puts in the mind of the jurors, at least hopefully a handful of them, well, we got to get all the way up here. It just sort of makes it like almost an impossible yardstick to reach on a subconscious level.
I mean, what was I going to say? Oh, sorry.
Who are you, Theodore Edgecomb?
I just remembered I got some inside info from the court on what happened. B. Ivory Lamar axed the juror too many times and they died on the stand. They died in the jury box. It's an axe wound. They're dead. I killed that joke.
It was an
accident.
I ruined it. Accidental
Ruined everything.
shooting.
That was kind of racist. Gotta tell you.
I'm okay. I'm okay with it.
Deficit disorder.
I'm
no
just covering this.
No
trial
deficit
as
of
racist.
axis, folks. There's plenty of axis.
Mm-hmm.
Okay, where was this? Where was?
Joe comes back in and someone comments, "Hi, Nate."
So finishing back that super chat, the prosecution gets as long for rebuttal as they reserved. So in this case, they technically have about an hour and 8 minutes remaining for their rebuttal. Not that they'd use that, although they could. If you get an hour and a half hard limit, it's up to you to reserve your time. And you can ask the court for help for that, because if they've got a timer or whatever, hey, court, can you let me know at an hour so I can reserve 30 minutes for rebuttal? You can do that pretty frequently, but you get your time and that's what you get. So that's how it's supposed to be. In Rittenhouse, it wasn't that way.
No.
Schrader was like,
Very
I'll let you talk as
loosey-goosey.
long as you want, whatever, but it's supposed to be fair between the two. And remembering that the defense does not get to come back after that state rebuttal and do something else, even if they do reserve time. They get their say once. Andrew H says B. Ivory probably I don't need to read this one. Well, I'll read it now. B. Ivory probably asked the mainstream media not to bring attention to the proceedings of this case to avoid arguing the facts post-judgment. No, he wants the attention on this case. He's going to make a big deal about it, whatever happens.
But he'll get that. I mean, the media only covers the parts of the case favorable to his narrative anyway. So when the media provides coverage, it's only going to be good for him. So he wants media coverage in that sense. Of course, he doesn't want this kind of coverage. He doesn't want objective coverage.
Paul Wolf says, would he have had the nerve to throw the punch without a gun in his pocket? It's a very good question that sometimes investigators will ask when they're interrogating someone. Weren't you scared? Weren't you scared to throw that punch, or weren't you scared to confront that person? And they're looking for them to say, no, I wasn't afraid. I was armed. That's what they're looking for. They're looking for statements like that. Again, a great case of that was the handicap parking spot, Karen, Michael Drejka. He that's what sunk his case. Frankly, he told prosecutors that he wasn't ever scared because he was armed, couldn't be scared.
I mean, he was dumber than Edgecomb, which is quite a stretch, but he actually talked to the cops for whatever it was, 40 minutes, an hour and a half.
God, it's brutal too.
It sounds like Edgecomb pretty aggressively asserted his rights. I mean, he made that stupid remark about pretending not to know what happened. But there's not much in evidence after that of any discussion with him. So I presume he asserted his right to counsel in silence.
By the way, on that question that he was asked, or the comment that he was asked about Milwaukee, you could really walk that away by saying, look, a lot of things happen in Milwaukee. I don't know what you're specifically referring to.
But not you personally shooting someone in the face. That doesn't happen all that often. That would be a remarkable.
People say we want to talk to you about Milwaukee. I mean, it could be like It could be someone else who was a mass murderer in Milwaukee that they think he is.
No,
So-
I don't think so.
Yeah, but this
you're
guy-
on the lam for 6 months. The police grab you. You know what they're grabbing you for. You know why the Milwaukee PD just showed up in Kentucky to talk to you. It's not
And
about
it's-
some unrelated event.
And his narrative is that he was looking for legal counsel for what happened in Milwaukee.
Which
I
that
mean-
narrative never should have come up at all. That was the dumbest thing in the world.
Right.
They never had to, even if that was true, which I think is ridiculous. But even if it were true, I wouldn't have claimed that. I would have just said, look, he was scared because he thought he was going to get screwed by the system. And that's
And you
why
know
he
his
went.
lawyers came up with that, which I don't get. I mean, it's like
they're
the
bad
kind of excuse
lawyers.
a child would have.
Yeah.
Yep. Diego Machado says decided to get hard. So last night it got hard, and tonight I'll finish getting hard. Oh, hi Andrew. I'd love to read your book, but I live in Brazil, so there's no point. Sorry for the misspelling. YouTube censored me.
Oh, the book is
Alex-
still awesome. I mean, you'll learn a lot about U.S. self-defense law, and there's jokes in it. There's no pictures though, so if you need, it's not a graphic novel.
Alex McCamey
And
says
you
one
think
more.
people will get hard.
Alex McCamey says one more name, and I've got bingo. Scott Shook says, "Lol, the prosecutor's big notepad is sitting right there with the word guilty facing the jury." Yep, it's great tactic. I really do like the big notepad versus the PowerPoint, because do you know handwritten in marker on that notepad? Didn't see any crossouts or lineouts. That dude took time, or somebody took the time to write that out. And I mean, to me, that actually says something. And it's right there. You're not making them look across the room at a screen or turn their necks to look at a screen.
Yeah,
Keep the
it's right
focus
next to
right on
you.
you.
Yep.
Yeah. I like it.
I'm
I would
still
put
waiting
them
for
up there.
the capital punishment closing argument where they use the hangman game to outline the
Every
fill
time
in,
we hit
fill
an-
in the person in the news.
look,
with the
we've-
elements of the crime.
We've got intent. There's the head. All right. Now we've got opportunity. There's the body. This is a big point of this. How do you commit a murder? You have to have the opportunity to do it. And then you start.
And that's why I'll
pulling-
never be a Fox legal analyst, because I made a capital punishment joke.
V-Sync says, please bring Natalie on for Edgecomb Rittenhouse comparison, since she's been covering that aspect. Everybody who's on the law panel has the invite. So that's, I assume that Natalie's been very busy during the day. She is she's a defense attorney in New York.
No, I
She's
think
in
it's in the
Northeast.
Baltimore area, right? Maryland
Baltimore.
area.
Maryland?
That's my recollection.
Yeah,
Nate
that
and
sounds
I
right.
are the only ones in the New York region.
Yeah. So she's a defense attorney in Maryland. She's very busy. So she's invited, of course, but if she can't make it during the day, that makes a lot of sense.
I see in the comments some people are suggesting Natalie shouldn't come on. Natalie brings her own perspective, folks. You don't need to agree with it, but it's a different perspective, and she's a genuine lawyer with her own perspective.
Yeah. And I value the other perspectives of pretty much every member of the law panel, member of everybody who's come on to contribute on the show. I value their perspective, even when I disagree, because it gives you a challenge. Do you agree with this new thing that you maybe weren't looking at?
Plus, you can't really disagree with people who don't show up. So if she shows up and there's a point of disagreement, we can talk about it.
Speaking of which, tonight on my channel, by the way, once you're talking about disagreeing with people, I'm actually debating Chip Franklin about Biden's first year. He's a guy who's got like 300,000 subs on Twitter, and he's got a channel. He's appeared on HBO, on CNN, on all these other things. I'm debating him about Biden's first year in office, whether it was an utter failure or not.
That requires debate?
Well, apparently, a lot of people on the left believe that, after they saw the Tom Hanks video claiming about how America is in such great shape right now, and they believe it. And
Saving Private Biden?
I guess so. Yeah,
no, man, it's saving Biden's privates. Get it right.
So I'm actually debating him for 2 hours tonight. So I'm looking forward to that.
Well, that should be exciting. I've never heard of the guy, but doesn't mean anything. I've never heard of just about anybody. So when I'm introduced, I hear my own name.
He's won an Edward R. Murrow Award. I mean, he's actually someone who has,
who the hell is Edward R. Murrow?
Really? You never heard of Edward R. Murrow Award? That's like,
I don't know.
That's like That's how the left like literally licks themselves.
That's
It's-
exactly right. That's the merit it deserves, by the way.
That's their
So-
self-fellatio award. So he's been recognized by the left. He's not like a nobody. Anyway, but that's gonna be on my
Okay.
channel.
No,
tonight.
I'm not
he's
saying he's
important to them.
Yes, he's important to them. So
I'm not saying
And
that he's a nobody because I don't know who he is. I'm saying I don't ever know who anybody is. They're like, oh, you haven't heard of this YouTuber? He has 70 million subscribers. I'm like, oh my God.
yeah,
No.
yeah.
Um,
So that's at 10 p.m. Eastern tonight on my channel, just for anyone who's interested in checking that out.
so continuing the chat from VSync, he says, to be honest, I didn't quite follow some of her points nor her support of trial strategy. So would love an exam of all angles in depth.
Sure.
Yeah, I mean, happy to have her on to discuss it. I disagree with the Lamar Anik Ahmed, right?
Anik Ahmed.
Yeah. I disagree with the Lamar Ahmed strategy that they've put forward. I don't think it's done their client any favors. I think having 19 different types of homicide to convict on makes it more likely, not less likely, that their client will get convicted, even if it's of a lower charge. It makes it more likely. Whereas I think focusing on straight self-defense was the way to go in this case, because
Yeah, I would have kept it much simpler than what they did here. But
yeah, I don't
Clean
think
air.
But
you,
listen, if Natalie, I don't know if she is, that's what's in the comments, and you can't really trust the comments. But if she's analogizing this to Rittenhouse, I think there's a lot of points of disparity between this and Rittenhouse. It would be great to have a discussion about it. Maybe I'm wrong.
Britt Cormier
I mean,
says,
I had a bad first marriage, so it happens.
Britt Cormier says the irony of using wordplay to tell the jury not to not listen to wordplay. Amazing. Ultra 65 says, thanks for Legal Mystery Science Theater 3000. Lots of fun. I do find his little his slide that apparently it's not the slide that's in contention, but rather something that happened in the courtroom. But I do find his slide saying that the cold-blooded was cultural, or just says cultural in parentheses. He hasn't explained that. I find that to be very interesting approach. He's going to say that he didn't, when he said cold-blooded, he didn't actually mean in cold blood. He meant something else. That could garner a.
Do you want to look at that slide?
I mean, if you want to bring it up, you can.
Let me see if I can do it in a useful way.
And because you're recording, so I'm not recording, so I can't.
I have the
pull it up.
the recording of it. Let's see. I'll do the share, and you decide whether you think it's
Sure.
would be useful or not.
Andrew Rohn says B. Ivory sounded like he was doing an Eddie Murphy donkey impression a few minutes ago. He did get a little high pitch there. So here we go. Rod Trail Cameron. So states that the incident was cold-blooded culture, which that's a weird editorialization of his
Not in
thing.
evidence.
Yeah, he didn't say, I mean, culturally cold-blooded. Admits that Theodore withdrew once he got on bike from confrontation.
What does culturally cold-blooded mean? Even does that mean that
He's saying that the cold-blooded is a slang used.
Yeah,
in-
it's slang used by all humans. You don't mean that the guy's blood is literally chilled.
Yeah, but I think what he's saying is that there's a cultural
What, the white
hood-
people on the jury shouldn't interpret it that way?
hood black version of it, like
That sounds pretty racist.
It does, and that's Lamar's stating it. So I want him to explain it more. I also think it's a huge waste of time. But he admits that Theodore appeared afraid when he turned the corner, almost fell trying to evade him on bike. That
That would be at the curb after the turn of the corner. This is different than the alleged striking of the bicycle with the vehicle earlier.
Admits the Cleeremans were driving aggressively and violently after Mr. Edgecomb. Theodore appeared shocked, and he described wife's demeanor as calm, but he was hysterical. Yes, and we have other testimony that follows that later says she was hysterical from their witness, from Stephanie Trotter, saying that she was hysterical.
By the way, I really found this Rodtrell Cameron a remarkable witness because the state dragged him into court like this, in the orange jumpsuit, in shackles, under circumstances where he said he was willing to testify voluntarily. And he gave what appeared to me, obviously I can't read his mind, but what appeared to me is completely genuine testimony.
Yeah. Yep. I agree. I mean, the cynical race baiting side of me would say that he felt like he had to provide that testimony because that was the only way that he would get out of his not showing up for the subpoena under the evil system of the man. But
He wouldn't be Sandra blended.
Yeah. Yeah. Not that that's in evidence in any way, but that's just kind of that's the counter narrative I can see coming, right? As he was under the system, therefore he had to testify in a way that was favorable. He was forced into it. But no, I thought he was very credible. I think, interestingly, I think having him there in the shackles and jumpsuit probably was better for the state because he didn't look like a friendly witness at all. And his testimony was almost entirely beneficial.
Yeah, I mean, if you did that to me, I'd be pissed. I'd be really pissed.
Okay, going back to where we were. In these other ones. Come on. Oh my gosh. Here we go.
The judge will drag that juror back in on a dialysis machine rather than go to a mistrial.
Peter B says, "Hey, Nick, can I get a toast to short pants? I'm a Minnesota resident who's moving to South Carolina soon. I'm never wearing long pants again. Screw winter in this place. Can't wait to leave this commie state." Yes, you can. Yes, you can. I am with you. I wear shorts whenever possible because, commie state is communist, but also cold like Siberia. So real quick. Mr. Peter B, to short pants, brother. May your warmer pastures warm your cockles. Cheers.
There are few words quite as powerful as cockles.
Yep. QGG 639 says, for Branca, comments on some states not allowing legal defense memberships for gun owners versus San Jose now requiring insurance.
All right, so the states that don't allow this, it's just a politically motivated power play. They send letters to these companies, whether it's CCW Safe or USCCA or whoever it is, and says, hey, if you sell these policies in our state, we're going to bring legal action against you. And they have infinite resources to punish these companies. So the companies say, all right, whatever, we won't sell in your state. They would love to sell in those states, trust me, but it's not worth the static they're getting. So if you don't like it, you need different politicians in those states. As far as San Jose doing whatever they're doing, I don't know anything about that. But crazy politicians be crazy politicianing. That's what happens there.
So someone in the chat is saying, Court TV host at the courthouse is saying an older white female juror got sick in the juror box during defense's closing arguments.
It sounds credible to me.
Very racist of her. I mean, I cannot believe that. She would vomit openly because of B. Ivory Lamar's closing.
I think she was going, B. Ivory.
So anyway, that's the update, which means they'll have to clear out that jury box. I mean, they'll have to clear it out, clean it out. You don't want to be the daytime janitorial staff. Normally you don't have to deal with this issue. But today they get to clean up the nasty. I wonder if he'll just send them to lunch in the middle of close.
To the cafeteria, double down.
Yeah. I told you not to eat the fish. One person ate the fish. We saw why. I was right, as always.
Guilty.
Bring the cafeteria worker into my court right now. We're going to judge them harshly. Nick Cornelison says, B. Ivory method. 1, insinuate racism. 2, some light trial prep. 3, ask questions. 4, get client convicted. 5, insinuate racism. 6, the grift goes on. Murdered Out JD says, although I'm not getting hard, I am getting my soft cover delivered today. Thanks, Branca.
Oh, very welcome.
Havelock Vetinari says, €5 says verdict will be self-defense. Prosecution did not move the needle. Clumsy Clairvoyant says, remember B. Ivory? He fights video graphics. Yes, he does. Michael Milano says, is it like it is like the Potter defense, isn't it? Lethal force authorized, but didn't mean to use it. The Potter defense was not an accidental discharge of a firearm in the same sense, because she didn't know she had a firearm in her hand. Her defense was mistake. I think they could have argued, had she never alleged the mistake, that she was justified to make the shoot. They tried to make the argument that she was justified to make the shoot. And that could have worked, but she, in a weird way, she intended the action. I don't know how to describe this. She intended to pull the trigger, just not of the gun. So we're talking about accident, or mistake versus accident, and the idea of recklessness versus non-recklessness.
It's really a mistake of fact, maybe accident, but in any case, it's well clear of criminal intent.
Yeah, in this one, they're arguing criminal negligence, which is what Potter was charged with. The culpable negligence, which is that recklessness standard that we talked about. If you listen to the jury instructions, the negligent homicide still has the recklessness element involved in it. They have to disregard the risk that's created.
Yeah,
So,
I mean, what they're charging here really reflects what I often say about, there is a legal defense of accident. That's a legitimate legal defense, just like self-defense is a legitimate legal defense. But it's very difficult to pull off with guns, because guns are inherently dangerous instruments. And this statutory framework reflects that. They have a specific criminal negligent homicide with a firearm, because you had a gun in your hand, and a gun is inherently dangerous, and you should have known, and therefore you're criminally liable for what otherwise, if you just had a bat in your hand or something else, might simply be a civil offense.
okay. Melissa Faust says, Judge is auditioning to be the next Judge Judy. Okay.
I doubt it, but it would be funny.
Yeah. More like a Judge Miles Lane, I would think. John Meyer says, Andrew, what brand earbuds do you use? I'm looking for some good ones while I'm on the bike.
Oh, I mentioned that. Go to S Plugs. What the hell is it called? They're called S Plugs. I think the company is, just Google S Plugs. Yeah, sorry, I lost my notes, folks, but S Plugs. Just Google S Plugs. The letter S Plugs. They'll probably come up.
That's the thoroughness you can expect from Mr. Andrew Bronca. He takes
when it comes to earplugs,
notes on his earplugs. I mean, he doesn't have them right now, but he takes them. That's a step farther than anybody else I've ever met. Bucky Cat says, Nick, can you guys at some point talk about the law San Jose passed to tax gun owners? Now, there's a difference between carry insurance and just general firearm insurance.
Yeah, this sounds just like a fundamental Second Amendment violation.
I'm opposed to mandating purchases of anything, including insurance, under all circumstances. I don't think that mandating a purchase of car insurance to use the privilege of roads is valid either. So, not a big fan of any of that. Kirill Ragazin says, this case so far seems to be a good example of how not to prove a self-defense claim. Learn more about this strategy at lawofselfdefense.com/get flaccid.
Ouch.
Well, no, they're saying from this case, that's how you would do this case, would be the get flaccid, right?
Yeah.
It's not mocking you. He's saying that he didn't get hard. That's the point, I think.
Yeah, the B Ivory strategy is the flaccid one. Brendan Morgan
I see your admin posted up in the comments the link to my earbuds. So thank you very much.
Oh, there you go. Thanks, C. Goody. Brendan Morgan says, Bronca, what bike do you ride? Could you recommend your earbuds? Yes. Also, lawn crime or pussies. What bike do you ride again? BMW?
The bike's a BMW R1250 GS Adventure. It's wonderful.
There you go. Mudge M says, does this work out better for the defense if they don't try the self-defense route? No, that's a prison term. Super Dude says, I can't wait to see Lamar fights graphics. This is from his promo video, which was done, and they clearly didn't pay the license fee for the software.
There's no way he's finishing this before lunch.
It's 12:15. I discussed the situation with the attorneys. Unfortunately, one of the jurors about half an hour ago, maybe 20 minutes ago, felt a bit lightheaded. She does not feel well. I'm going to make her, and the lawyers are stipulating to this, the alternate. We have 12. I believe we should continue, finish the closings, and let those 12 deliberate. Either side object to that plan?
No.
Great. All right.
No.
12.
No.
The juror, I'm not sure of her number. We'll make a record of that later. It's a younger white female, will be excused as the alternate, given that she's not feeling well. The remaining 12 will come in.
She should have
Younger
done that
white
on day
females.
one.
Tinder just blew up.
Your chat just blew up.
Someone said 2 jurors their faces were shown by the camera. Is that a mistrial? No, it's not a mistrial. Just because a juror's face gets shown. In fact, most court hearings, this one included, if you go into the court, which you have a constitutional right to do, you go into the court, you'll see all the jurors' faces in full view. They try to take reasonable measures to preserve juror anonymity. But it is not a guarantee of juror anonymity. You do not have a right to anonymity as a juror.
Quite the opposite.
Right. And so what, they if you were to go and listen to voir dire and stuff like that in open court, typically you'll hear the jurors' names, even maybe even their addresses. The question is there intimidation and factors like that at a risk? And in this case, I mean, we haven't seen anything like that or heard anything about it. No one's outside protesting because it's freeze your literal testicles off temperature in Milwaukee right now. Nobody wants to be out there doing that. So no, we're not going to see a mistrial from anything like that. The judge has done he's got an order. Worst case scenario, he could bitch at the cameraman for violating the order, but I don't think he's gonna. Sometimes
he might out of principle.
But sometimes a little accident would happen. But I don't think he's even going to find out until later. I mean, if he didn't mention it now.
Like a Packers fan wouldn't have done that.
Turns out cameraman in the courtroom is the same guy coordinating the Packers defense.
Right, special teams. You work for special teams, don't you?
No, the defense was actually great, but special
please.
teams was bad.
Do I know if they will be sequestered during deliberation? I have a strong suspicion we're not going to need to get to that question.
Oh my God, I would hope so.
I cannot imagine this going into, I mean, maybe it will, but I can't imagine it going into a second day. Midnight Green 20 says, does self-defense still apply when
back? Welcome back, everybody. The juror that you saw that was not feeling well. The lawyers and I have agreed she's the alternate. We excused her. There's 12 of you. The 12 of you will deliberate.
You will deliberate.
Checked on her. She's fine. She felt a little lightheaded. She indicated it might have been something she ate, but she feels fine. She's feeling better.
Fucking cafeteria.
Defense can, if you remember where you were, pick up where you left off, but go ahead, counsel.
Our client's innocent.
So members of the jury, we were talking about the state's burden of proof in this case. And just a quick reminder, a quick review is that the defense in this case doesn't have a burden, have no burden whatsoever. And we discussed prior to the break that majority of the reasonable doubt that could be established in this case can actually come directly from the state's own witnesses. So we're going to go through the testimony of the witnesses in this case, and we're going to show it to you. We're going to show you reasonable doubt in that they cannot satisfy this burden of proof. Let's go to the first slide. So the first witness,
The trouble with this cherry picking is it's so easy to rebut.
Yep.
And what Rod
Yeah, let's talk about what Rod Cameron said. I would love to. Here you go.
witnessing
Said he shot him in
the
cold blood.
shooting occur, and he
Point
described
blank.
it as the words being
Wouldn't have shot him.
cold-blooded. Cold-blooded. He used those words. Now,
But he's a lizard.
that's why the state liked Mr. Cameron. That's why they wanted, that's why he's essentially almost their star witness. He's the one witness who could testify outside of Miss Cleereman, outside of Mr. Edgecomb,
Aside from the
had witnessed
other
the
witnesses.
last two incidents that occurred.
Well,
So we
except
know
for
there
the
was
two
three
guys who
incidents. We know
watched
that
it
something started.
across the street.
Jose.
Cameron witnessed the last two.
Yeah, the two
He
smokers.
described the last final incident as being, this is cold, it was cold-blooded. Now,
It's always the smokers.
what was interesting about Mr. Cameron's testimony is that immediately after he described it as being cold-blooded, he testified that the defendant appeared to be in shock afterwards.
So
Those were his words. He said he appeared to be shocked. I don't know how many cold-blooded, heartless, violent killers are shocked after they shoot somebody intentionally. But that was Mr. Cameron's
Probably lots of
testimony.
them,
So
unless
what
they've done
happened?
it a bunch
You
before.
seen the state after they brought, worked hard to get this witness here. You seen the state jump up and start trying to impeach their own star witness. You
When?
remember? Do you recall?
No.
Mr. Huebner was right here. He said, "Well, you never said anything about him being in shock before. You didn't tell the detective, the officer, that when he was on the phone with you in the patrol car, you didn't say he was shocked. Remember that? Go look at your notes. That's not consistent with being a cold-blooded killer. The way they're trying to make Mr. Edgecomb to be. This is their witness. We didn't call him.
Get higher. Get higher.
Let's look at what else Mr. Cameron told.
Hit those octaves, buddy.
He admitted after the punch, he used a very key word. Mr. Cameron used a very key word when he described it. He was asked, did Mr. Edgecomb, after he punched Mr. Cleereman, did he withdraw from that confrontation? He said, yes. He was asked, was he a threat at that point? He said, no. He admitted that Mr. Edgecomb withdrew once he got on his bike from that
Admitted
conversation.
is a weird word here.
Now, members of the jury, you're going to see that word withdraw.
I would have said told you.
withdrawal again. You're going to see it in the jury instructions. It's going to be under provocation. See, the state wants you to believe that, oh, well, let's see who started it. If you started it, you
State
can't
didn't even
claim
argue
self-defense.
provocation in
For sure they're
close.
right. Well, they forget about a very important word. It's called withdrawal. See, once you terminate and you provide notice to
I think they might have. State didn't
But you
mention provocation in
acted
close.
aggressively
I thought
with-
they did.
You
They
can
didn't spend
regain
much
your
time on
right
it if
to
they did.
self-defense.
Because they didn't spend much time on anything.
That's the law.
No, they.
You're going to see it in the jury instructions. Mr. Cameron, their star witness, testified to this.
Their star
They
witness.
did. Okay, they did mention it.
What
The
else
chat
did we
says.
get
I
from
believe the chat.
Mr. Cameron. He admitted that Theodore appeared afraid when he turned
This
the
is
corner.
this is
He
another
almost
reason they
fell,
should have asked
trying
about
to evade
and accused him of
him.
cowardice.
I think that's Joe.
It is.
Cold-blooded killer,
He's a communist.
violent, heartless, appearing afraid. Those don't even go together. This is their witness. They caught him on this stand. We asked him. So when he turned the corner, he appeared afraid. I said, when he got on, when he went from the bike lane and jumped the curb, he said, well, he fell. He definitely appeared afraid at that point. When he continued going on the sidewalk, and when he went into this little stairway, he appeared afraid then too. He told you he was trying to go down the stairs. This is their witness. This is their witness. It doesn't matter how loud Mr. Huebner comes up and how passionate he is. These are the facts.
It's
Says the loud
ironic.
guy.
Check your notes.
So this part of it, folks, is what I would
State
expect
came
from a
up and
defense
tried to
on
make a
closing
big
with a
deal.
tough case.
Now, let's just get this straight. We started and we said this is a very tragic situation.
And now we'll go
Our
sideways.
heart goes out to the Cleereman family. This is a situation that escalated, and it should not have. At some point, Mr. Edgecomb was responsible for a part of this incident. He punched Mr. Cleereman. He got upset because racial
took
slurs was used
responsibility
based
for
off of
that.
his testimony, or whether it was a swear word, whatever the case is. At some point, Mr. Edgecomb got upset. We know that.
Is he avoiding the N-word
But
now?
at the end of the day,
He
this
didn't
situation
earlier.
escalated.
You just said it was
We're
a
not trying to go
swear
back
word.
and forth and blame, do victim blaming. That's not what this is about. As the state tries to indicate, they talked about, well, they said, oh, the wife, Miss Cleereman, was she was not hysterical. She wasn't acting.
Hubner needs a thought balloon above his head right there saying,
You want to know
man,
what's
mom was
happening?
right. I should have been a
Here's our
doctor.
witness. Let's go back to Mr. Cameron. Mr. Cameron.
Doctors don't have to deal with this.
Mr. Cameron described the wife's demeanor as calm, but he was hysterical. That's what he said. That's what their witness said. He said, I thought that was a bit unusual because I was hysterical. I was going crazy. I was on the phone with 911, but she seemed to be calm. We didn't put that at issue. Their witness did.
Squeaky voice is not helping
let's
him
just put
out
that
to
for the
me.
record. Now, as we talk about different things that happen in this case, it is not to, blame anybody, but it's to show that Mr. Edgecomb cannot be
Except
proven
his damn
guilty
wife.
beyond a reasonable doubt. That's the purpose. We're showing all these things that
I don't understand how the wife's
there's a
demeanor
lot
shows
of
anything about
questions
reasonable
that
doubt.
are unanswered in this case. And if the questions are unanswered, they have not fulfilled this burden. This is not about, we've never met Ms. Clement. I don't know her. Either have you. So we
If you
don't
think
know
of
what she
all
would
of
or would
this
not
as
have
an
done.
audition to be the next
We're not
Benjamin
sitting there
Crump,
just
it
trying
makes
to
a lot
choose
more
someone.
sense.
All we're saying is that the possibility exists.
It just makes
We
zero
don't
sense.
know.
If she hated her husband
Mr.
and wanted him
Edgecomb
dead,
should
that
not be
wouldn't
convicted
make
of
him
murder
any less a murderer.
because we have a lack of knowledge in that area.
I
That's
know
why
all
we
these
go
people
through
saying
all these
the
different
wife hired him to
aspects
kill
of
the
the case.
husband.
That's
All right,
it.
so let's assume that's true
Or is that
with no
more
evidence.
explanation?
It's still murder.
Or we talk about the failures of law enforcement in this case, and the investigators, to not be thorough. And because of the lack of thoroughness, that's why these questions
Thoroughness?
remain.
You say
And that's
pheromones?
Keep
Ladies
saying
and gentlemen of the
thoroughness.
jury,
Oh.
Mr. Edgecomb should be found not guilty on every single charge.
Oh, is he done?
No, not even close.
Yeah, seriously.
Next slide.
Oh,
Next, he's done with one witness.
Yeah, he's going to say that several more times.
Patrick Timmon.
the bicycle expert,
Now,
the surprise bicycle expert.
the
I
state
love this
called
guy.
Officer Timmon. Officer Timmon testified that initially he's.
Whoops.
My apologies.
My mistake.
Your whole segment is about the state's witnesses being so favorable to you, you fucking dummy.
He initially stated it was two potential witnesses that he believed wanted to give statements.
Potential
Look at
witnesses.
the video he showed. Remember? Remember the end of the video of his body cam? When he goes and he asks another officer and he says, hey,
You
I
know
see
who
a
else
guy
was a
standing
potential
over there.
witness? Every car that drove
I
by
see a
the
guy
scene
standing
for
over
the
there.
hours that
He
the
looks
tape was
like
up.
he might have seen something. Should I talk to him? The first officer says, we were wrapping up whatever he says, it was inaudible. So then he goes to Officer Mahala, who's coming down. And Officer Mahala, he says, hey, I see a guy over there. Looks like he has some information that could, in this case, I want to go talk to him.
No, he didn't say it looked like that.
Fuck that. We got enough. Fuck that. We got enough. We got the
Say it
wife.
again.
There was nothing to indicate the guy had
Got this gentleman
any
right here.
information at
I
all.
believe it was Jose Perez. He was in the video. We got enough. That's the evidence in this case. How?
And then he turned off his body cam.
You never have enough of anything in a homicide investigation.
Never.
Mr. Cleereman deserves a full investigation.
Infinite.
Guess who else deserves a full investigation? Mr. Edgecomb. He deserves all the facts as well. You don't just jump to theories and rush to judgment. And at any point, this is 43 minutes after the incident occurred on the stairwell. 43 minutes later, you got an officer telling Officer Tiverton, we got enough.
They did. Your guy
Members of the
fled.
jury, you proved
Looks
guilty
like a
beyond reasonable
murder.
doubt.
This should come up on
Thorough
rebuttal.
investigation.
We could have had more if the defendant had stayed on scene and told us what happened.
Like the
Then the evidence showed with Officer Tiverton
what are they
Evidence?
going to solve any further? Looks like a murder
he
when you
was
leave the scene.
instructed to turn his body cam off. He asked, "Hey, are you live? Are you live?" Think that's a fair assertion as to are you recording? Is your body cam recording? Think that's a fair deduction? And what Officer Tiverton does next is he says, "Should I cut it?" He said, "Yeah." At that point, that's the end of Officer Tiverton's body cam. We don't know what
Objection.
happened after that.
That's bullshit. I mean, the state objected to this when it happened. That's not what happened.
This is all reasonable doubt, members of the jury. Next slide.
Next slide.
So now we come to Detective
Sorry, bastard.
Tyler
Detective Vampire. I'm Tyler Kirkwold.
Now, Officer
I've been
Kirkwold,
alive for over 250 years.
only a puppy.
anytime an item is removed from a scene, from a crime scene, it is compromised. That's what he told you. He talked about the duty of a first arriving officer to preserve the scene preservation. He talked about
The arriving officer did
that's why
preserve the
you see
scene
yellow
as
tape
it was
immediately
there
after
when
the
they
scene.
arrived.
You don't want to have evidence tampered with. You don't want that crime scene to be compromised. Members of the jury,
But what about
we're
the
not-
wallet?
It's no longer an allegation as to whether an item was removed in this case. I told you in opening, we're gonna prove it. We've done that. Whether the admission was of a wallet or whatever the item was.
Whatever. I
The
just
item
wave my
removed
hands
in the
and
crime scene has now been compromised. That's just it. So how do you prove guilt beyond a reasonable doubt? We don't know. Again, we're not.
yeah, I
making
think the
any-
prosecution will
I
tell
mean,
you.
listen, we have to put out theories. We don't know. I don't know any of these individuals of these parties. So, Detective Kirkwold said that no citizen, under any circumstance, should remove anything from a crime scene. It should be further investigated. Detective Kirkwold also said he can't confirm or deny whether an item was removed or placed at the crime scene. This is the lead detective.
Of course not. He's not omniscient,
So
despite
what
his
do we do?
appearance.
We go back to the burden of proof board.
Oh boy.
This is the detective. Can't prove anything.
The gun and
beyond
the
a
bike
reasonable
were
doubt
removed from
when
the
your
crime
lead
scene.
detective
Someone in the
can't
chat just
confirm or
pointed out.
deny whether an item was removed or placed at the crime scene. We don't know. Again, it's not an accusation. We just don't know. We don't have enough information.
That'd be funny if the state hits that. Well, we do know that 2 items were removed from the crime scene.
Detective Kirkwood
The
also
murder weapon
testified
and the bike.
that he doesn't know where the first incident happened and he didn't follow up. He
There's a
also
lot of
said-
meat here for the prosecution on rebuttal.
also
If they hit it well,
that-
I'll be
I mean,
really
that's something
impressed
I'm gonna
with
leave.
this
The lead
prosecutor.
detective on the case cannot
I hope he
tell
doesn't
us
drop the ball.
where precisely the first incident occurred, where Mr. Edgecomb and the Cleereman had an altercation of some sort involving a vehicle. We don't know. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Cleereman to get in a vehicle with you and have her show you precisely this is where it happened at? Sounds reasonable?
So the defense closing up to the interruption was about as long as the whole state closing.
It's characterized as a statement that was by Detective Alvarado.
There we go.
Detective Kirkwold.
Yep,
That may be the case, but it's closing.
it's
but-
fine. It's fine. It's fine.
Go ahead.
Say it would take 5 to 10 minutes. 5 to 10 minutes to have confirmed. So we wouldn't be here a year and a half later.
But you got to take those
members of the
opportunities to
jury
point out where
still
they're
not
wrong.
knowing precisely.
No, and it shows the
exactly
prosecutor actually knows the
where
evidence.
the first incident occurred.
Yeah.
5 to 10 minutes. They didn't do it on September 22nd of 2020. They didn't do it on September 23rd. And we asked, have you done it? Have you ever done it? In a year and a half that this case has been going on? No. That shows you the quality of the investigation in this case. Mr. Cleereman deserved better. Mr. Edgecomb deserved better. And that is another reason why the state cannot satisfy their burden of proof. Next slide. So members of the jury, we now remember where Detective Alexander Klabundy was called to the stand. I believe, if I'm not mistaken, that he was the state's first witness, I believe. And he testified that the knife found in Mr. Cleereman's pocket was a folding knife with a serrated blade, perhaps up to 10 inches in length. He confirmed that police never submitted the knife for DNA fingerprint testing.
It's not even a 4-inch blade. Open, the whole knife is not 10 inches.
Look at it.
Here's the knife.
It's right there.
It's in his hand.
Heard in testimony that other items, like
depends on who's
bottles,
measuring.
Eyeglasses, those items clearly would make it really hard to exert deadly force toward anybody. But those items were tested.
But in your demonstrative, you use your
not
sunglasses. You fucking dope. I would point that out. Could show a deadly force threat. In his thing, he used his sunglasses when he demonstrated to you what
He
might have
also
been in someone's
confirmed
hand. When he made
That
it
the
up.
White Claw can.
The hardest part of the
Never
rebuttal is
tested
going to
well.
making it look like you're actually addressing the issues in the case and not just destroying this guy.
Yeah.
The White Claw can that was in a back door. That can was never tested either. We don't know whose hands were on these items. And that, ladies and gentlemen of the jury, brings us back to our board.
What's with the White Claw? What does the White Claw do?
Can't prove
No-
guilty
nobody
beyond a
knows.
reasonable doubt. Now,
There
the
are
state
also
came up here and talked about,
floor mats in the
well,
key.
his hands were bleeding, and his hands were, came out the door. He got punched. He touched his face.
Oh, boo hoo hoo.
So that's kind of trying to indicate whether or not, the knife should have blood or anything like that. But
It should.
remember
pocket.
this exhibit, the Fitz 11? This is the pants pocket of Mr. Cleereman.
Okay, there's a tiny brownish dot on there. Is he going to show that has blood on it? Is that the idea?
You see specks of something.
Of something.
Could be blood, could be dirt. We don't know.
We don't know.
We just don't know.
That's your
Now-
burden to raise, by the way.
Does the state have resources to make that determination so we don't have to guess? Of course they do. This pants pocket could have been submitted to DNA as well,
Well, also by the defense, by the way.
but it wasn't.
Yes.
Assuming the pants were
And
still
that
in
brings
evidence
it to the
because
jury,
their
brings
client
it back
fled
to
for
the board
6
again.
months.
Proving guilt beyond a reasonable doubt. We wouldn't have to speculate if the state would have done their job. Next
Did
slide.
the defendant do his job when he shot somebody in self-defense?
Now, it brings us to Ms. Evangelina Cleereman. And again, our heart goes out to the Cleereman family. Now, I want to...
They made her look whiter than the paneling
clear.
behind her.
Just get a couple things clear. We understand,
Remember that they objected
That
to a
after,
mugshot of their client.
seeing or being involved in such
Being
a traumatic
prejudicial.
experience, one would
The
tend to be
worst
distraught.
possible photo of her they could.
That's fair. You don't know how you would react in a situation like that, especially involving a loved one. That's fair.
Then why'd you assert
Now,
she should have acted
the issues
differently?
that we bring are not to any way, blame, victim blaming or anything like that, as we just discussed. But when there's conduct which is somewhat suspect or it brings or begs a question, we have to present it. We have to bring it to your attention so that you, the trier of fact, can determine whether something has been proved beyond a reasonable doubt. So one thing I can say is that, there's several things in this testimony that, we have questions about, some of which, like I said, could be reasonable under the circumstances. But the state has not proven beyond a reasonable doubt. Her testimony is simply not reliable. It's just not. And we're going to go through why. So it doesn't mean
Oh
that,
my God.
she's a bad person. It doesn't mean that, there's any type of issue. But it just means that simply because of those circumstances, her testimony is not reliable. Let's start. The first thing that she recalls saying, she said her husband said, "What the heck?" That was her recollection. She said, "What the heck?" Ms. Cleereman went and did media interviews, and she told those journalists that Mr. Cleereman said, "What the heck?" There. Now, on the body cam, we showed you in evidence Ms. Cleereman clearly saying, "What the fuck?"
At a different point in time.
The issue is it just goes to the reliability.
Does
This
it?
could indicate a tendency to water down a situation that was a little more severe than what it actually was.
More severe than a bullet to the head?
Being said that was beyond what the fuck, as Mr. Edgecomb claims in this case. But that tendency, we don't know.
I have to say, I thought
Ms.
he'd be
Cleereman
throwing
also
the
said she
N-word
saw-
around quite a bit more.
She was looking
And
at
it's
video
not.
in her rearview mirror.
We'll see
I
where it
wonder if
goes
they
on.
think it's just not credible.
She also
On the
said she
close
doesn't
of
recall
closing.
her husband opening a door after being.
I don't think he's much of a judge on a strong judge on credibility.
Now,
She
again,
doesn't. I
when you
actually
have a
believe
traumatic
this
situation, I'm sure
100%.
this, when Mr. Edge came up, and I'm sure the stage is going to come up, he came up, he violently punched him in the face, blah, blah, blah. We know that. But
I
we
just
have to
forget that.
now assess
We know that. That's
her
in the
recollection
past. We're talking about now.
Because you members of the jury have to determine the veracity in the weight that you're going to credit her testimony. So what she testified to is that she doesn't recall the door opening when Mr. Cleereman looking to exit, likely to proceed after Mr. Edgecomb.
What's the contrary evidence there?
Now, generally, when you open the door, especially at night, your lights are on, right? Her lights were on because you're going to see later that those same headlights were going toward Mr. Edgecomb. But when the lights were on, when you open the door, some cars, the interior light comes on. That would further be an indication that that door was open. Sometimes you might hear some type of noise when a door opens, a chime, if you will.
Sometimes you might be looking for your husband's bloody glasses that just flew across your lap.
I'm sure it was a traumatic situation.
I'm
But
sure
again,
it was
we have
traumatic.
to determine how much. Some credit should be given to her testimony. Absolutely.
In the just
How much
world,
do we
Theodore Edgecomb would jump up and
That's
punch
where we
this
go
guy
back
in
to
the
the
face and then have him
This is how
continue
the
his
state
closing.
is improving their case. Guilt beyond a reasonable doubt? No. So let's go to the next slide. She said her husband told her to turn the corner because he wanted to talk to Mr. Edgecomb. But the video shows that she likely made
She made an illegal turn.
middle lane to make that right turn.
I can't believe you would
Also
even
admits that
include this.
Mr. Edgecomb was
Yes,
no
seriously.
longer a threat when he
Compared
got
to
back on the
a
bike.
defendant who just punched a guy in the face. She's making an illegal turn.
That's important.
She turned from the left lane.
They throw the
I can't
blinker
let
in
that
there.
stand.
I don't know if you recall when we stopped.
She
the
could have kept
video.
driving straight, just like
And
Edgecomb
probably
could have kept
wonder,
riding his
doing,
bicycle.
why is this point being driven so hard? Because we wanted to make sure that she agreed that Mr. Edgecomb was not a threat to her at the time he punched and got back on his bike. And that's why we asked questions.
Actually,
So
she
he's in
didn't
front of you,
know
right?
he was a threat to her,
Yes.
but he had
You see
a
the
gun
back
in
of
his
him,
pocket.
correct?
He kind of
Yes.
was.
And at this point, he's not a threat to you. She said, yes. That's important for a couple reasons. Number one, it shows that Mr. Edgecomb retreated, or the word that you're going to see in the jury instructions, he withdrew. That's the word that the state is not going to want you to pay much attention to. They want you to gloss over that fact.
Okay.
Withdrawal. That's what it is. He got on the back. He got on his bike. He proceeded forward.
Got on his
The
back.
state explicitly
That's
mentioned
notice
that on
that's
their
imputed
closing.
Yes,
to the
I thought
claimant at
so.
that point.
They're not trying to hide it.
No doubt about it. The next point is she also admitted that she could have kept driving straight to go home. I don't know if you guys, members of the jury, I don't know if you recall, I don't see it here now, but we had a board that we referenced at a couple times in the trial. And in that board, we look, you turn right here, you know, what's these locations here? And we asked, okay, so which way is home? And she testified that, you know, yeah, this is the board. Thank you.
Oh, they found the
board. But we asked which way is home. And here's Brady Street. Here's the intersection where the X is. One of the witnesses during the course of this trial placed the X at that intersection. That's important. And she testified that home was straight. That would be the direction to go home. So Mr. Edgecomb had already made his right turn already. He already made his right turn. That's not a dispute. You've seen it in video. She decided to go take a right turn after Mr. Edgecomb, likely under direction of Mr. Cleereman. So when the state comes up and they talk about, you know, he's a cold-blooded killer. He's a cold-blooded. He's violent. He's all of this. Mr. Edgecomb at this point now,
he's just trying to get away.
And the question you have to ask, did he have a firearm at the time he punched the first time? Did Mr. Edgecomb have a firearm on his person the first time he decided to punch Mr. Cleereman?
Yes.
Of course he did. Of course he did. If Mr. Edgecomb was a cold-blooded killer, why not take the gun out at that point and shoot at that time?
This is an argument used by defense attorneys for rapists. If
again,
he wanted
he
to
said
rape
it- he
her,
said
he
at
could
the
have raped her an
beginning,
hour
there's
earlier.
no justification
So
for
clearly he
punching
didn't mean to rape her an hour
Mr.
later.
Edgecomb should have called the police, let the authorities handle the situation. He should have done that, just as the Cleeremans should have done so as well. The state asked Mr. Edgecomb yesterday, they said, when you came down that stairwell, did you know it was a police department right there? Did you know it was a local police department right there? You know when they were grilling Mr. Edgecomb?
They're grilling him.
When he was
Holy
grilling
shit.
him. The same question applies to the Cleeremans. Actually, the Cleeremans would have gotten there faster because they had a vehicle to get there.
I know you had to go down the steps and on the bridge.
He's supposed to pick up her 250-pound.
Police station that Mr. Attorney Huebner came up and asked Mr. Edgecomb.
Oh, I see.
Could have went to the same police station, but they didn't. And
All right, well,
that's,
good effort.
members of the jury, are why we're here today. They didn't.
It's their fault.
It's their fault.
Nothing stopped the Cleeremans from taking a. How did Mr. Edgecomb get apprehended? They did great work using video to track him down. Just like they are tracking him down for a murder case as we're here today, they could have tracked him down for a simple battery case.
Oh, yeah. Same
A
thing.
misdemeanor.
Happens all the time.
For punching Mr. Cleereman. They could have used the same technology to track him down for punching someone, but they didn't. That's key.
It's key.
Next slide. So, Ms. Cleereman also, confirmed that,
She admitted a
her
gun
husband
was
assumed
brandished
Mr.
by the
Edgecomb wanted
defendant.
to bicycle.
Is that against her
Talk
interest?
about that. She admitted that a gun was brandished by Mr. Edgecomb. She admitted she shouted out, he has a gun, but says her husband did not hear her.
No,
Yeah.
he drove his head into the muzzle of that gun intentionally.
Why is
What
that
is he-
important?
What does he think he's getting to with this? This is
If
weird.
Mr. Edgecomb has a weapon brandished, that was his testimony, right? On direct, he talked about it. I
thought it was the
my weapon
opposite
sitting around
testimony.
his waist area. He said, I brandished it.
No, he didn't say
Well,
that.
Yeah, I
He
know.
never
Now,
said
listen,
that.
We know certain parts of Mr. Edgecomb's testimony. You're probably like, okay, it's some part that, especially in cross, that is questionable because he was feared. He was scared at that point.
Hey, listen, don't trust my
It wasn't
defendant.
me talking. So
Yeah.
it's
Don't trust
somebody
my
that's
client.
who's trying to convict him of murder.
He has to say something about
But
it.
when Mr. Edgecomb was actually
He's
saying,
infuriated.
I had the gun brandished. He said, I used
He
my
never
left
said
hand
that.
and I said, stop. Do not come any closer. That came out on the record.
Yeah. Stop. Don't come any closer.
The gun was out already. The gun was used to deter conduct of Mr. Cleereman.
To be fair,
But
they
it
did
didn't work.
deter the conduct. He's dead.
Even his wife, who loves him dearly, yelled out, "Jason, he has a gun."
So it's so weird. They're trying to simultaneously argue the gun was never brandished; it was at his waist, but also
It
everybody
was
saw the gun.
deterrence. Yeah. And it was
Ladies and
deterrence.
gentlemen, that's why we're here today.
It was an accident.
Next slide.
He never brandished it, but he was using it as a deterrent when showing it, which is brandishing.
2 points here. Ms. Cleereman admitted that Mr. Cleereman got so close to Mr. Edgecomb. This would be invading his personal space. She admitted that her husband advanced toward Mr. Edgecomb. So initially, she testified that she seen her husband walking toward Mr. Edgecomb, which is fair. She pulled off and she used her vehicle to catch up with Mr. Edgecomb. And then she turns on her flasher lights in the bike lane. You've seen the video. So maybe it's fair that she didn't see a part of the jog as the state has described it. We consider it to be running or hunting someone down.
Yeah,
But
of
the more
course you do.
friendly term is jog. But nonetheless, we don't have to talk about words because it's just wordplay. We seen that yesterday.
Oh, words. They don't matter.
Testimony of Mr. Edgecomb. It's wordplay. Just words.
His whole testimony is just wordplay. Don't pay attention
Mr.
to
Cleereman
it.
described it as advancing toward Mr. Edgecomb.
Nonetheless, Binger engaged in wordplay.
Like it wasn't.
This DA did nothing
It wasn't Mr. Edgecomb
that could be qualified as
was
wordplay.
advancing
He was as
toward
direct as
Mr.
possible.
Cleereman. Ms. Cleereman's testimony says it was her husband that advanced toward Mr. Edgecomb.
All I can say is, if I'm ever
That's why
prosecuted
self-defense
for
is
a
at
criminal
play.
offense, I hope it's this
A cold-blooded
prosecutor.
killer doesn't run. How many cold-blooded
Of course,
killers
he wants
run?
to put me in jail, but at least he was straight up about
Cold-blooded
it.
killers normally go after who they're trying to kill. That video shows Mr. Edgecomb running, trying to save his life. That's her testimony. Next slide. Okay, we
got a
talked
meme
about
face
that
in this
there was a
picture.
warning first, then then the gun. She touches. So then immediately after the gunshot, she goes to the scene. So immediately after her husband
That's
is
not
down
an
on the
evidence.
ground, she gets out of her vehicle and she goes to the scene. Now, you've seen the video, and
Oh my God, the person
gets
she
out the
called is
vehicle within
named
6 seconds.
Yavana?
and she goes over to the body. She reaches down.
That sounds
And I
not
count
very
it, 4
racist.
seconds. Count it. When you get in the jury room, go to the video. Now, the defense has actually enhanced the video to try to make it more clear.
Oh, yeah.
You're going to learn Mr. Edgecomb had to give $5,500 to have, Mr. Mark Robinson fly in from New Jersey to testify about.
Are we going to hear
the
that?
video.
I don't think we're going to hear that. I think you just introduced evidence,
This case is
new
about
evidence
seeing. It's not
in
about just
closing.
hearing different versions. Thankfully, we got A-class evidence in this case.
A class, not B class.
Better than
Lie,
B class.
Women lie. Video does not. You got permission, members of the jury, to believe what you see.
Their own John Black witness said video lies.
So what she kneels down for, we don't know. She testified that she placed her hand on her
I feel like the
husband's back
prosecutor's just
to see if he
just
was alive.
waiting. Like,
Then she
oh,
ran
I
back to
can't
the
wait.
car.
I can't wait to do this.
Very possible. We don't know. And neither does the state. We don't know. But that was her testimony a year and a half later. You know who didn't ask that question?
Why was it a year and a half later?
Milwaukee Police Department, when they were investigating this case. She was never asked. Why did you go out the first? Why did you go the first time? There's no record of that. Now, We later learn, and we'll get into that later, that she goes a second time. Again, she retrieves, you know, they don't say. She makes a 911 call, you know, and she testified that she wasn't able to remember her PIN code initially. Very possible. Again, it's a traumatic situation. That's very possible. You know, it's, your mind, I can understand your mind not working the same. But so that being the case. However,
I want to see what the prosecutor's writing here.
at
It's
the
like,
time that
your
Mrs. Pryor
diary. I have to rethink
comes
my
on,
life.
she testified. She came right to this stand and she said that between the time that she got back in the vehicle and you see the red SUV come around, Ms. Trotter testified that she was on the phone with somebody. That's the testimony in this case. These are the confines of evidence that you have to consider. We don't know. I wasn't there. I don't know. Either does the state, and that's why we have reasonable doubt, because they can't prove guilt beyond it. You also heard in testimony that she said she wasn't in the car with Denise's boyfriend, who was an off-duty police officer. Then later she says that after seeing the video, she's like, oh yeah, I do remember him. The police officer, the off-duty police officer who came, Ivana's, you know, boyfriend or husband. She's like, after seeing the video, oh yeah. She recalls that. Again, sometimes after traumatic situations, you know, your memory can fade. That's possible. Our point, members of the jury, is that just the testimony is not reliable. That's all.
That's all.
That's it. No blaming anybody. That's reasonable to not recall certain things. Only thing is the state has to prove it beyond a reasonable doubt.
I should have started a timer
Next slide, please.
and stopped it during the break.
So, you know,
You should have, Nick.
she admitted
Bailed.
that she did go to Mr. Cleereman. Now, this is all before the
Pure
authorities
boomer.
arrived. This is all before Milwaukee Fire Department, Milwaukee Police Department. Anybody gets there. It's just civilians at this point. She testified and admitted that she went back and forth with Mr. Cleereman while he was laying on the ground, not once, but twice.
Didn't even try to save him.
Then she
Stuff
admitted
those
to
brains
removing
back
a
in his
wallet
head.
from Mr. Cleereman. And here's the question, here's the issue.
Question or
We
issue?
don't know when that wallet was removed.
Why didn't you ask her the question then?
We don't know when the wallet was removed. She admitted of taking the wallet. We understand you want a piece of, okay. She said she wasn't interested in the contents of that wallet. Fair game.
She wanted his
When
money.
was the wallet taken? We don't know. The defense does not know. Guess who else doesn't know? The state.
Because it's not relevant to why he was shot in the face, man. Like that.
Well, all I can say, it's a good thing that
Did
Harvard University is working so
or the
hard to keep
detective
Asian students out of
ever asked
the
Ms.
college.
When she said, hey, I have his wallet, right? And then remember, Officer During goes to Detective Kirkbold. And he said, I'm Detective Kirkbold, Tyler Kirkbold.
We're 60 minutes
And
in,
Officer During
according to chat.
says, hey, I have her wallet. And he says, did that come up out of him? Go into it's in the blood, the body worn camera of Officer During. It's that video. And he says, did that come up out of Mr. Cleereman? He said, I think so. He said, that's a problem. Testified to that understanding. That's a problem. The other detective next to him said, incredible. So what happens next? At that point,
That's a mischaracterization. He
Kirkbold
said incredible to them not knowing
orders
where it came from.
Officer During, go find out where that wallet came from. Who got it? So you see on that video,
Hubner looks like a husband in marriage counseling right now.
now he goes
Like,
and he
I'm
asks,
just waiting for my turn. Just let me know when you're done talking.
And he said, do you know where this came from? He said, no, I don't know. He said, I think the wife got it. He says, I don't know, or maybe MFD. Milwaukee Fire Department. Maybe they got it. So Officer During is shown on that video going to the Milwaukee Fire Department, individuals that are on the scene, and he says, "Did you guys get this wallet?" And they say, No, we didn't get it. No, we didn't get it. No, we didn't get it. Why is this important? Because that goes, it imputes notice to law enforcement. Notice is now imputed to the Milwaukee Police Department. And now that they know an item has been taken from Mr. Cleereman, it has been removed from the crime scene, at the very least, members of the jury, wouldn't you expect them to go ask Ms. Cleereman, well, why did you take the wallet?
They did.
Why?
You did.
Isn't Mr. Edgecomb entitled to at least understand why?
You asked
Item
her.
was removed from a crime scene in which the state is prosecuting him for murder?
You had her
They don't
on
even ask the simple
cross-examination.
question.
That's when Edgecomb
And you
gets to
heard
ask.
testimony from a retired Officer Burns, who said that would have been standard protocol to ask someone why something was removed from the scene. And that, members of the
Taking
jury,
more notes.
is yet another reason why we go back to our board here, burden of proof, because they can't prove guilt beyond a reasonable doubt. Too many questions unanswered. Too many
It probably
questions
says
never
removed
asked.
from Christmas list.
Next slide.
Sorry, Joe.
What for what?
No, I'm just kidding.
Hanukkah list too.
Well, yeah.
Christmas and Hanukkah. He's off
We
of both of
have
those.
Miss Stephanie Trotter. She admitted, and she said that it was weird that Mrs. Cleereman was going inside of Mr. Cleereman's right pocket. And we just talked about, she admitted that
He
when
could
she
object there.
pulled
She
up,
actually
when the
testified that he never
was
made
on
it.
the
She
red
never made it
vehicle,
inside the
Why
pocket.
is it
They
saying
go side
Stephanie
to
Trotter
side.
admitted?
You know,
She
in that
was
1 minute and
testifying for the
34-second
defense.
video, she admitted that she was on the phone and she was saying, Anna. So she was indicating that she was on the phone with someone. Now, let's go back to the first point.
These are not admissions, folks. It's just testimony. It's so weird to me. This
Trotter testified.
lawyer doesn't understand
We know she
normal
was there.
legal terminology.
We seen her on video before the video.
He doesn't know the difference between testify
He
and
knows she was
statement
there.
either.
This woman was
So
there.
it's not really that
We
surprising.
know that. She called 911 while Ms. Cleereman was by Mr. Cleereman while he lay there. Ms.
Dead
Trotter
with a bullet in his
was
head.
very specific when she told you one thing, members of the jury. She indicated that Ms. Cleereman was doing something with the right pocket. Of
I don't
Mr.
think she
Cleereman.
said that. I think she said she
The
couldn't
right
tell which pocket.
The right front pocket. That was her testimony.
I don't believe
The
that was
right
her testimony.
front pocket.
She didn't
That
say
was her
front
testimony.
pocket. She just said right pocket.
I didn't make this up. She came on this stand and
She
she
didn't say
made her
front
right
pocket.
hand like everybody else did in this case.
Actually, I think she might have said front pocket.
Members of the jury, what was found
She
in
said
that right pocket?
that she never made it into the front pocket, but she was in the pocket area. That was the testimony. They asked her, "You never saw her put anything in the pocket, take anything out of the pocket. You never saw her hand go in the pocket. Isn't that right?" "Yeah, I never saw it."
You can't trust a Filipino woman going into a
Oh,
man's
yeah,
pocket.
was found in that
I mean,
right pocket.
So what? I mean, he's basically saying she planted a knife on her dead husband.
Yes. That's
Let's
been their
discuss this
theory
issue.
for a
Let's just
while.
Get it out the way right now.
Look, why would she
Are we
plant a
saying that
knife
she
on
put it
him?
in there, this and that? No, we don't know.
Oh,
We're saying we don't.
we don't know.
there's no testimony.
But
she
it's
took it from his
reasonable
hand.
doubt.
Right front pocket. I don't know if the wallet in the knife was in the same right front pocket. We don't know.
We have
never
testimony that the
even
wallet
asked,
was in the
when did
right
you get
rear
the wallet?
pocket, actually.
The question was never asked.
That question was specifically fucking asked.
That's why we
And
have
you
reasonable doubt.
and you could have asked her, even if it wasn't.
All the questions were asked. If we had the whole video, maybe we would have more information so that maybe the state could get up this ladder
The whole video.
to guilt beyond a reasonable doubt. It's not there. Now, the state just said something in their opening. They said, well, Mr. Edgecomb is saying he's seen something in his hand. That's his perception. He believed he's seen something at the time.
So are you saying
Now,
he had
what
something
you
in his
didn't
hand
see
or not?
is Mr. Edgecomb come up on his stand and try to exaggerate a situation.
What?
He didn't try to say, oh yeah, it would be quite convenient for him to just come on the stand and say,
That's why
oh,
they
yeah, I
didn't
seen
say
the
knife. This is what I said
Mr.
yesterday.
Edgecomb didn't do that.
So that's why they're
He
not
just said, "I
claiming the
seen
knife.
something."
It wouldn't be
It
credible at
happened
all.
so quickly because he had a big right step and then he lunged at me. So he couldn't really determine what was in his hand. That was his testimony.
Well, you can't shoot
He
someone
also
because
indicated
they have
that
something
there
in their
was a second
hand.
threat that he perceived, which was the vehicle. The
Oh,
same vehicle.
He had the
that hit him
Kia
in
Soul in
parking
his
lot,
hand.
that knocked him on top of another vehicle,
Could be.
and where a racial slur was yelled out at him. The same vehicle that you saw, members of the jury,
Drink.
almost hit him a second time.
I don't want to.
Same vehicle. So at the time, Mr. Edgecomb's perception is these two threats. So he's not going to exaggerate something just to make the story sound even grander.
No way. That would never happen.
What
He has
second
every
threat?
reason
The
to,
second threat is an
because he's
exaggeration.
facing a very serious charge, but he took the same oath that every witness did.
Yeah. So he couldn't
And
have
he
been
was
lying.
advised, you don't exaggerate anything. You only tell the truth.
Is that the oath? The oath
Wait,
says
is
you
that
don't
what happened
exaggerate?
with the wife?
Then that's simply what it is.
You spent the whole time saying the wife was lying.
We don't need to exaggerate anything.
She took the oath too.
They still can't prove guilt beyond a reasonable
Oh, good
doubt.
Lord.
Next slide.
Next slide.
Kevin PEAF Smith says the melody is beautiful, but the lyrics are horrendous. Will style trump substance?
That kind of brings me to, testimony that was provided by Miss Cleereman when she said that they were out drinking. And I always messed his name up. So you got
everyone who drinks.
Either Scafides, it's one of the two. But they were, wherever they were at that evening, she indicated that she had one glass of wine. And she indicated initially that Mr. Cleereman had 3 beers. That's what she testified to. Once I brought out, based off of his size, in a way, he's not a small guy. He's 6'3", 250 pounds.
That's not 6'3".
Not a
This
small
is
guy by any
600
imagination.
pounds.
So
Not
when
250.
we
250
presented the
pounds
question
at
to her, we
6'3".
said, well,
Go about to here.
it showed on his toxicology
Go about to here.
a blood alcohol level of 0.12.
Because I'm 190.
And we question now,
All right.
3
whatever.
beers? Now, this is Wisconsin. We know, if we know anything about anything, we know about beer.
You're a bunch of fat drunk people. Come on, let's finish
3
it.
beers, a 0.12. And then she testified and said,
That's like a
maybe it was 4 beers.
0.89
Okay.
or normal
Maybe it was
people.
4 beers. I don't know. The defense doesn't know. You know who else doesn't know? The state. But their witness testified
He just
that based off of
he's
that
got a
blood
very
alcohol
poor
level,
understanding of what reasonable doubt means.
a guy with that
Not every question can be answered is not reasonable doubt. That's not what that means.
that 8 beers was more consistent with the blood alcohol level of Mr. Cleereman.
No, he did not.
Is that what he testified?
He did not do that.
That's
that's
not my
part of the
recollection.
The autopsy indicated that Mr. Cleereman
There's a
was
complete
250
mischaracterization of his testimony.
Look, Hubner just pushed back from his desk. He's like, "All right, motherfucker."
Thank you, Your Honor. Next slide.
Time alert from the judge.
So then we go to Lorenzo Hernandez.
Check
This time
yourself,
was canvas
BIV.
4 blocks between Houghton and Humboldt. He observed many video cameras going east on Brady Street.
Just told him he had 15 minutes
Suez,
left. I mean, he better pick up the
Morello,
pace.
They were all marked on the maps. This is diagonal to Dynamite. Evangelina said during her testimony, this is where the first incident occurred. He stated in testimony, he never
You're so
completed the
high.
follow-up task as the investigation was turned over to the detective. Again, a lack of follow-up. Next slide. Dr. John Black.
By the way, guys, if you want us to
John
stop
Black
talking,
essentially,
go watch
you know,
somewhere else.
told us he
I
talked
won't do
about
it.
selfies, and he talked about when we take a picture
This
with
is-
a selfie and how,
We're not cutting off anything of any
merit.
merit or note
You have to
here.
get the picture, and then you notice some of the other things that might not have been in your perception at that very moment. That's the same thing in this case. So when you're looking at the video evidence, understand that everything might not have been.
Look at that. Video
within Mr.
captures
Edgecomb,
undisputed facts.
Perception at that moment.
That's the opposite of what he said. His
Obviously, it
testimony was the video is different.
So again, that's something for us to consider. Next slide.
Oh, next slide. Yeah, I'd go right past that one.
Can't wait for the prosecutor to
All right.
get up and
Next slide.
do the rebuttal. Oh, we're just going to skip this slide. It's fine.
All right. So that brings me to the next point.
Oh, he only shot him in the head once.
That he had 17
That's his
bullets,
defense.
fully loaded. How many bullets were actually fired?
One.
As many as it took.
A cold-blooded killer that only takes one shot.
To the face.
He never shoots at the vehicle that struck him one time.
Have you ever
and
heard of a
almost struck him
sniper?
another.
One shot, one kill.
He never shoots when he could have punched, when he punched Mr. Cleereman. He doesn't shoot then. What kind of cold-blooded killer is that?
He didn't kill the whole town.
Mr. Edgecomb testified
This
that
is kind of
after
cold-blooded
you'll see the
killer.
steps,
Only needs
you know,
one shot to
Mr.
kill a
Edgecomb
man.
just standing
He
there
could have killed
and,
17
Mr. Edgecomb just
people.
pulled out the gun and shot him. No. Let's go to the video. Let's scratch. Let's go straight to the fence. Was it 15?
I look more notes by Hubner. I hate my life. I can't believe I have to do this for a living.
Every note he writes just says, this fucking guy. This fucking guy. Every time.
All right. So Edgecomb actually saved 16 lives because he didn't shoot the other 16 people. He's a savior. He's a lifesaver.
Oh my gosh.
It's a shame he didn't have 50 bullets because then he would have saved 50 people.
Oh my gosh. And I still can't predict jury verdicts because they're crazy.
This is the last time the defense will show you this video.
Oh, thank God.
No kidding.
Their own.
Oh, it's clearly the enhanced with the
There's no doubt, members of the jury, at this very moment.
filter.
See, we use that word, withdraw. Don't forget that word. Withdrawal cancels out the first.
Or if you're more comfortable, pull out.
It makes it first incident. Who cares what happened in the first incident at this point? It doesn't matter. It also doesn't matter. The second incident doesn't matter either because of the word withdraw.
Then why'd you spend
This
so much
video
time
at
on
this
them?
frame shows withdraw.
You spent so much time on the first incident. You said it doesn't matter.
Could we play console?
Good thing the prosecutor only used 20 minutes. If he wants to really build out a rebuttal to this, he might need that hour and 10 minutes.
Stop it right there. Mr. Edgecomb testified
Look how far the
to
car is
fire
from
that
him
occurred.
when the door opens. The car stops.
This
He
is the
felt
heat
motor
on
and he
his
felt
back.
He testified to just a loud noise and shouting coming from this vehicle. He's testified
No one
to
else
fear
testified to
at
any
this
of
very moment.
this.
Mr. Edgecomb didn't chase after them in the vehicle after he punched them, which he already admitted.
He
It's not
accepted
charged with civil
responsibility.
battery. When you get that verdict form, battery is not going to be on there. If it was, Mr. Edgecomb would have took responsibility for that. He admitted.
I would object to that.
Continue playing.
The state should have hammered on him illegally riding his bike on a sidewalk. Since they're going after the turn from the middle lane. Look at this great video. Grade
At this
A.
point, stop.
Too
Back
late.
it up, please. And stop. Right there. That's the key frame of this case.
Is it?
See that right step? That was the right step that Mr. Edgecomb described.
Oh, that's when he shot in the head.
Turn the corner, he made the right step as he's lunging toward him. And when you heard the evidence, that's when the gunshot goes off after he lunged after me, Mr. Edgecomb's trying to describe the time that he believes makes his actions reasonable. The time of when the shot goes off. That's important. Not the, there was some accident. Oh, no, it malfunctioned. No. This was the time that the shot goes off. This is what makes his actions reasonable. This is why this jury should find Mr. Edgecomb not guilty because of self-defense in this case.
Oh, please, please be done.
Continue playing.
Oh.
Next slide.
When I was referring to no one else testified to the things, I'm not talking about the heat on his back, you weirdo. I'm talking about he just said screeching tires. He also said on testimony, roaring engine. And he also said just now, shouting from the car. No one, even the people standing across the street, didn't hear that. No one heard it.
Mr. Edgecomb has testified that
The CVT transmission
he goes down
delivering
the
enough
stairs,
power
he goes
from
home,
a 1.5
you don't see
liter
him
engine.
for 6 months. Now the state is going to argue, oh, that's consciousness of guilt. Remember in voir dire, Attorney Ahmad, he came up to the podium and he asked the question to you. He said, how many of you believe that only guilty people run? Remember that question? Only guilty people run. None of you raised your hands. And then the
Tell you
next
what, though,
question that Mr.
guilty people
Attorney
run.
Ahmad raised. What other reasons might there be that someone would run? In that jury room, there are several different people. They said, well, somebody could be scared. Somebody could be fearful of their life. Somebody could, especially as an African-American man, like we still have issues in this country. I mean, listen, we talked about the cases. He talked about, he believed he was hunted down like a mud. He talked about the George Floyd and being taken into custody.
Drink. He
talked about that.
Ding, 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 ding.
We still have work to do. Now, the state, he also testified that he set up a GoFundMe account, that there was a GoFundMe account set up, and that he was trying to get a lawyer. They said, well, couldn't you just call one of your lawyers? Just because you have a lawyer on one matter, this is common sense. Use your common sense. Just because you have a lawyer on one matter does not impute an obligation for them to accept you on another matter.
Well, he would have found out if they would accept him if he called them.
He called lawyers. They told him $50,000 to $140,000. That was the testimony in this case.
All right.
So
no evidence.
Having a lawyer available doesn't mean you have the resources to get one.
But here he has some.
He was scared. He talked about that fear.
The $50,000 to $100,000 quote just was from B. Ivory Lamar.
Stuff, that's a distraction
that he gave.
That's simply a distraction. If he's not charged with, just running. He's charged in this case with murder. If you want to charge him with battery, go ahead. You want to charge him with obstruction or whatever you feel
they're
like
going to bring in Joe Rogan
for not being available or turning yourself in for 6 months, do so. It's not murder. You got video evidence to make that decision on. Thank God for video. Look where Mr. Edgecomb is when there is video. He's still sitting here. That's why he's so nervous on this stand. He thought that the video itself should be enough. You see it with officers all the time.
Never testified to that.
I thought it was a gun. It turned out to be a cell phone. But understand.
There's another one.
No one said that.
He's reaching for something. It's the same law. It's reasonable. It's still the perception that Mr. Edgecomb had. Now I'm gonna wrap this up.
He never testified to that.
Frederick Douglass once said,
"Oh my God!"
He said, "In a composite nation like ours, as before the law, there should be no rich.
Huebner should step up and do Genghis Khan quotes.
No high.
What is best in
no
life?
No white.
Hear the lamentations
black,
of the women.
But common country, common citizenship, equal rights, and a common destiny." And here we are, members of the jury, still embarked on that destiny.
Yeah.
Mr. Edgecomb has accepted responsibility for his actions. We told him.
Well, he could.
He wasn't supposed to have a gun. He pled guilty to bail jumping. He took responsibility so that you guys wouldn't have to start your year off having to decide something that he needs to take responsibility for. He punched the guy. If he got charged with that, you're right. He should be charged with simple battery. He fled for 6 months. He provided his explanation for it. It wasn't because of what you've seen in that video. Any reasonable person would be fearful under those circumstances.
Really?
Those are all true. But ladies and gentlemen of the jury, those are not charges that Mr. Edgecomb is facing.
I want to see Huebner turn green like into the Hulk.
It's going to be murder.
You wouldn't like me when I'm angry.
Multitude of degrees of murder. You got to go through that. That's what's on your verdict form.
State, you get up and say, you don't actually have to go through that. You got plenty of evidence to convict on first degree. You don't have to go through all this shit.
Murderer. He's a very soft-spoken, scared individual.
Who shot someone in the head?
Members of the jury, I want you to look at Mr. Edgecomb.
Won't that make him nervous?
Well, let's wrap this up. We're at about an hour and a half. The jury's had plenty of time to look at the defendant. Let's just finish.
Yeah, no kidding.
Counsel, and let's be done, okay? Please.
Yes, Your Honor.
Please.
Mr. Edgecomb is no murderer. What he is, he's a survivor. He's a man who has already taken responsibility for any wrongs related to this incident. But today you decide, is he an imperfect person? The answer is yes, he's imperfect.
Well, he's not on trial for
But is
that.
he a violent, heartless, cold-blooded murderer?
Violent?
Absolutely not. Members of the jury, as the great Willie Gary often said, you have the power. You have the power, members of the jury.
Willie Gary.
You can see wrong, and you can make it right. You can see suffering, and you can stop it. Members of the jury, Attorney Huebner is going to come again, another great attorney. He's going to talk
The
about
same great attorney
the
from
rest of
before.
his arguments. Use your common sense. You didn't check it in when you came in this building. Use your common sense.
Yeah, I would say
And
that on
if
rebuttal.
upon doing so and applying the law to the facts,
Use,
there will be
indeed,
only
use
one
your common
That's
sense.
a verdict in this case on all counts that have been on
Everything that
verdict
guy
form.
just said was bullshit.
That
Use
verdict,
your common sense.
members of the jury, is not guilty. Thank you.
Thank you, counsel. You can just move that exhibit, please, and the stake and.
Everything that guy just says bullshit. Thank you. Thank you.
Oh, Nick had it
Defense
spooled
counsel
up.
stated that the state
He's
has
ready to
not
go on that one.
met its burden of proof. And then they didn't mention a single element. Not one of the legal requirements you have to take a look at here. Not one of them. We showed and proved that the defendant caused the death of the victim. We showed he did so with intent to kill. And defense counsel stated, oh, well, he's not a cold-blooded killer because why didn't he shoot 17 times? That's not the law. The law is whether or not he shot with intent to kill or practically certain to cause death. He took a gun that he's trained on, that he knows what will happen. He points it at the head of another individual, ladies and gentlemen, and he pulls the trigger and he puts a bullet in the victim's head. He says he's not a killer. He killed someone. That's what this is about. Ladies and gentlemen, Retro Cameron didn't say he was a cold-blooded
didn't
killer.
kill
What he said was
two
what the
people.
defendant did was cold-blooded. He didn't mention any time, during any time, about the defendant looking shocked or in looking scared or any of that. Not when he's talking to the police. Ladies and gentlemen, when he was talking to the police in that 911 call, what was he doing? Begging the 911 caller to do. Get here.
Get here.
He's still here. He's still here. You can find him. He's got to go. He just shot him in the head. He was begging the police to find that man, the defendant. Rotrell Cameron wasn't saying, oh my God, that guy looked really scared. You better go try to find him and make sure he's okay. He's saying, find him. I'm a person that just saw a man's head get blown off in front of me, and I want the person who did so found and caught. And he couldn't because he ran. And then he ditched the weapon. And ladies and gentlemen, we talked about a lot of things in voir dire. We talked a lot of things in voir dire. One thing we didn't talk, that defense counsel didn't mention, was that we also mentioned that your verdict has to be based on this case and this case alone.
Yeah.
The defense, with the way they present their arguments, is like a Chicago Bears fan talking about a quarterback. They'll talk about anything else. They'll talk about anything. They won't talk about what
Genius.
they're actually talking about at the end
Genius.
of an argument. We bring up other cases. We bring up all sorts of other things. We bring up other things that have happened outside in some other place. Let's talk about here. Let's talk about what he did. Some injustice that you may feel that happened in some other case does not excuse or allow or invite an injustice in this case.
Well put.
What the defendant did was homicide. All of the elements have been proven. It was not self-defense. Ladies and gentlemen, even if, yes, you withdraw and he provokes, that doesn't mean he then is automatically in self-defense. A man comes up with no weapon in his hands. And ladies and gentlemen, be absolutely clear about that. This leaves just a few specks. The weapon, the knife, has no blood on it. No one says that knife is out. Not one single person says this is out. Defense counsel spent 35 minutes talking about a knife that's in a pocket that nobody sees come out. And says that is what makes it self-defense. Well, ladies and gentlemen, let's take a look at what defense counsel is saying. Your Honor, could you give me evidence control quick? Ladies and gentlemen, defense counsel is saying that the defendant was acting in self-defense because someone approached him. Someone engaged in his personal space. Someone had their fists up. Someone had a weapon that nobody sees. Ladies and gentlemen, at 1 minute and 26 seconds into this, all of those things apply to the defendant.
Yep.
He's got a firearm that nobody sees. He's engaged and invaded Jason Cleereman's space. He pulls his hand back. He's engaged in violence. He has violence intent in his heart. He's going to punch him. And if Jason Cleereman shot and killed the defendant right then and there, oh my God, would there be a different sort of circumstances and arguments coming?
We'd be prosecuting him right now.
Lawyers. I'd still probably have to run all their equipment for him, but it'd be a whole different
shit.
I wouldn't have done that.
Drop the mic.
Your verdict wouldn't change. Because at this moment,
He's angry.
ladies and gentlemen, it's not self-defense.
He's saying Cleereman wouldn't have been justified to shoot, and he's right.
He's right.
In an attempt to influence your verdict just goes to show you don't have an argument. If Jason Cleereman had shot and killed the defendant at that point, I would be here arguing the same thing that he's guilty.
Yep.
And the
Called
defendant
it.
is guilty. There was no weapon. There was no imminent threat of death or great bodily harm. He started a fist fight, and then he ended it with a bullet.
Lethal.
And I am just glad that finally at the end of this, the defense is willing to admit that the victim's wife loved him. Because for 2 or 3
that's
days
good.
we were hearing about purportedly loves and why didn't she do CPR? And oh my God, how cold she is.
So
and
bad.
oh, why didn't she get the wallet?
She wanted him to die.
I told the officers right at the beginning. It's on
Said
the-
it before. You never do that to the one that's grieving.
Understand, she got the wallet.
But it sounds great on The View.
The knife never came out.
It sells on The View. It does.
The defendant shot and killed a man with his hands up, worst case scenario, in a situation in which Jeffrey Parr states he shoots an unarmed man, in which Jose Perez states he shoots an unarmed man, in which Rodrigo Cameron states he shoots an unarmed man, in which the video shows he
Well,
states.
in fairness,
it shows
I'm
that
not
he
sure
shot
they
an unarmed
stated
man,
that.
in which Evangelina Cleereman states that he shot an unarmed man. And keep in mind, defense counsel stated that she heard the defendant give a warning. No one hears that. Not one person. Not one person hears any of what the defense counsel is trying to say the defendant heard. Nobody hears it. Because it didn't happen. It just didn't happen. He started a fight, and then he killed the man. Every portion and escalation of violence came from the defendant. Words, I'm going to punch you. You want to punch me? I'm going to shoot you. And ladies and gentlemen, when you go through all of the elements like I went through with you and the defense avoided, you find that he's guilty. Negligence out. But I do think you should at least keep in mind one thing. Defense counsel spent about a half an hour trying to explain away his own client's words.
There it is.
The defendant could not have been more clear. He says the gun is pointed down. He states that the victim is lunging at his gun, by the way, or about to spear him, and the gun goes off. That's his words. Not I shot in self-defense, not I was trying to keep him away. I step back and the gun goes off. That is what he said. And defense counsel spent half an hour trying to make it seem that it's not what his client said. That is what his clients said. Because when that last-ditch effort by the defendant doesn't work, now the defense counsel's got to try Plan Z.
Plan Z.
Running didn't work. Ditching the gun didn't work. Lying to Kentucky didn't work. Lying to MPD didn't work. Lying to you didn't work. And now we got a whole nother plan.
Yeah, that's good.
Good stuff.
This case is what happened.
You lied to everybody
right
else.
there.
Why not
And
you?
on that video, there
Without
was
saying
not a
it.
lunge. There was a step. Retro Cameron says he has his hands up. Other people didn't see it. But regardless of it, the worst case scenario.
You
is a
decide
person
whether
who
he
got
lied to
punched
you.
Was getting ready to punch back. And the defendant shot him. That is first-degree intentional. If you think he actually believed that there was a threat of death or great bodily harm, because that's what he has to believe, then it's second-degree intentional, because there's no way that's reasonable. If you think that maybe shooting only once somehow is not intent to kill, even though he's a trained weapons guy who's got a gun
Oh my
and
God,
at
that
close range
testimony
puts
hurt him
one
so
into someone's
bad.
brain, then it's first-degree reckless. If there's utter disregard for human life, if there's not, it's second-degree reckless homicide. Everything defense counsel just went through in terms of their arguments does not get you to not guilty. It's just a matter of which one of the homicides he's guilty of.
It's good
Because
too.
there was not a valid self-defense claim here. Ladies and gentlemen, when you go through,
that defense team looks sad.
regardless of whether or not they went and found something at Glorioso's. And keep in mind, defense counsel made a big deal of all this video, only to find out and not mention at all in their closing for some reason, that the defendant says it's even further eastbound than that. Who cares about the swerve on video? It wouldn't have changed what happened when the defendant pulls a gun and shoots the victim. And their whole point for why that matters is Ricky Burns. Keep in mind, you are taking and hearing someone criticize an investigation in which they are doing everything they can, and he and they cherry-pick the evidence, cherry-pick the result, and Ricky Burns never asked for anything more. There were reports he didn't see and didn't even care to see. Why? Because they didn't want him to see him, because it didn't help what they wanted him to say. Talk about showing everything.
Who is biased?
We called all the witnesses. You've heard all of the case. This is about this case and nothing more. And the simple fact that anybody tries to draw your attention to something else goes to show that they know they can't win when it comes to the elements and the facts in this case. He's guilty, ladies and gentlemen. The facts are clear. The law is clear. He's guilty. Your verdict is clear.
Short and lethal.
That's good.
I like that
Thank
better
you.
than just ripping him apart on point by point. He just, instead of going point
Ladies
by
and
point
gentlemen,
and
I'm
bullet
going to read
picking
you a
him,
couple of additional instructions.
he took an atom bomb and just blew him up.
The duties of the attorneys in the court have been performed. The case has been argued by the lawyers.
I've
I
done what I
will
have to
instruct you
do.
regarding the rules of law, which should and must govern you in your deliberations.
God willing, I'm released from
Time
this
has
case.
now come when the great burden of reaching a just, fair, and conscientious decision in this case is to be thrown upon you, the jury, the jurors selected for this duty. You are not to be swayed by sympathy, prejudice,
Not.
or passion. You will be very careful and deliberate.
Not.
I
Please
love
be
Midwestern
careful and
accents.
deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. You will have the jury instructions when you go back immediately. You will also have verdict forms submitted to you. There will be eventually 5 verdict forms. First one will read, we the jury find the defendant, Theodore Edgecomb, guilty of first degree.
You can stop at that
homicide.
one.
If that's your decision, you then answer the second question. Did the defendant commit the crime of first degree intentional homicide while using a dangerous weapon? Yes or no.
He could use a pop filter,
Second
though.
potential
The answer
verdict
there
form
would be yes.
that will be submitted is we, the jury, find the defendant, Theodore Edgecomb, guilty of second degree intentional homicide in violation of the Wisconsin Criminal Code.
Also,
And
yes.
there will be the second question. If you find him guilty on that charge, did the defendant commit the crime of second degree intentional homicide while using a dangerous weapon? Again, yes or no.
Yeah, it's all
Third
yes.
verdict form. We, the jury, find the defendant, Theodore Edgecomb, guilty of first degree reckless homicide in violation of the Criminal Code of Wisconsin. Again, if that's your verdict, you will have to answer the second question. Did the defendant commit the crime of first degree reckless homicide while using a dangerous weapon?
So it's an
Yes or
enhancement.
no. The next verdict form will be we, the jury, or reads, we, the jury, find the defendant, Theodore Edgecomb, guilty of second degree reckless
Did the
homicide.
defendant pretend to be an
violation
idiot
of
on
Wisconsin
cross-examination? Just
Again,
vote yes.
verdict. You answer the next question. Did the
The
defendant
third
commit the crime
question
of second
will
degree
be,
intentional homicide
should his
while
counsel
using a
also
dangerous
go to
weapon?
prison
Yes
with
or
him
no.
for delivering bad arguments?
And then finally, the last verdict form.
Last verdict form is should we just give B. Ivory
We, the
a
jury, find the defendant,
Call him
Theodore
Thomas.
Edgecomb, guilty of homicide by negligent handling of a firearm in violation of the Wisconsin Criminal Code.
You shouldn't need this one at all.
And the
Stupid
last
that it's even in
verdict that's
here.
submitted, the sixth
Undisputed.
verdict, so you'll have six forms. Reads, we, the jury, find the defendant, Theodore Edgecomb, not guilty. It is for you, the jury, to determine whether the defendant is guilty or not guilty of each of the charged or any of the charged offenses. You must make a finding as to each count.
How many immigration lawyers are going to move to Florida from Minneapolis if this is a not guilty verdict?
Counts that I just mentioned.
Like all of
except
them.
the crime, and you must consider each one separately. Ladies and gentlemen, as you know, this is a criminal, not a civil case. That means before you, the jury, can return a verdict which I can legally receive, the verdict must be reached unanimously. In a criminal case, all 12 of you must agree in order to arrive at and reach a verdict. When you retire to the jury room, I would ask that one of the first things you do is select one of your members to preside over your deliberations as the foreperson. That person's vote as the foreperson, however, is entitled to no greater weight than the vote of any other juror. If during deliberations you need to communicate with the court, that means communicate with me. You need to send out a note through the bailiff that's signed by the foreperson. To keep a complete record of this trial,
We have a
it's
note, Your Honor.
important
We don't need to
you
go back to the
communicate with
jury
me
room.
as the court only by writing or only with a written note. If you have a question, I, as the court, will discuss the matter with the attorneys before I answer it, so it may take some time. You should and must continue your deliberations while you wait for an answer. If there's a question, I will answer the questions or any question in writing, or I might bring you here to answer it here in open court. Most likely I'll answer it in writing. After you've agreed upon and reached your verdict, you should have it signed and dated by the foreperson that you've selected to preside over your deliberations. Madam Clerk, if you can swear in the bailiffs, please.
All jurors sworn at this trial together in some private place, and that you will not, before they render their verdict, communicate the state of their deliberations or the verdict they have agreed upon.
So we're going to have at least an hour-long deliberation while they eat their lunch.
All right, ladies and gentlemen, if you can follow my bailiffs out, you'll have the jury instructions immediately. You'll have the verdict forms in just a minute or two.
Where's the Italian buffet?
Don't think he did it. I think the judge is a liar.
Like the
I
Packers.
I love that Chicago Bear. So
That was
I
a
know,
great line.
I know Nick doesn't really fully understand the impact of that, but Packer fans and Bear fans are very heated rivals. So you're in Wisconsin, you got a jury full of Packer fans, and it's true that the Bears, they've had some great teams over the years, but they've
I love
never
Nick's
had a
visible offense at that comment, by the way.
they've never had a decent quarterback, and that was why and anyone who follow, and look, if you're in Packer territory, they all follow the NFL.
All right, the jury's been excused to deliberate.
What other bullshit do I have to hear from the parties?
Today, well, let me step back. A few days ago, there was a juror that was excused because she had a family emergency. I think there was a death in the family. Both sides stipulated to her being an alternate.
Your Honor, we object to the possibility that our client might be convicted.
And today, the juror that was not feeling well, that was lightheaded, the lawyers, both sides also stipulated to her being an alternate today, correct? I think I should also make a record, and both sides can chime in. The jury that was seated in this case is one of, if not the most diverse that I've ever seated in Milwaukee County. The jury that's deliberating has 6 people that are white or Caucasian and 6 people that are minorities or people of color, including at least 4, possibly 5 African Americans. It's a very, very diverse jury.
I can't tell because I'm not
Obvious
racist.
to the lawyers, but both sides agree with that for the record.
Oh, that's the cup B.
No, defense won't agree.
Is that a yes, Mr. Hibner?
Yes.
Defense agrees with that statement.
Yes, Your Honor.
All right,
Oh.
we're in recess. Give my clerk, please, a phone number that you can be reached. As is my normal practice, I don't send back exhibits unless they're requested. I have sent back or will send back the jury instructions and the verdict forms. If they ask for an exhibit or anything along those lines, I'll advise the lawyers. We'll come back. We'll discuss any exhibits that are requested. It's about 1:45.
So no infinite video
we're in
viewage.
recess. Off the record. Thank you.
That's an interesting thing for the judge to note on the record, the diversity of the jury. I've never seen a judge do that before. You can understand it in this case. But
Yeah.
it's a really weird thing to actually have to hear a judge.
It shouldn't matter, right?
Right.
But that's the world we live in.
Yep.
That's a new change in our world, which is obviously yay for the better.
Well, I
don't know
think
if it's
he's
that new though. I don't know.
I think he's he's putting on the record because he knows exactly who this defense team is. That's
Yep.
why he's doing it.
Yep.
He knows exactly who the defense team is. The defense team here is prone to make something. Oh, this is a
Yeah.
racist jury.
What's the newspaper there? Milwaukee Star Tribune or something? Whatever the local paper is. The paper is going to run the propaganda line. And the judge wants to be able to say, hey, I explicitly said in court that that's not what happened.
And the defense acknowledged it.
Right.
Yeah. So it's just him heading off the obvious attack from the obvious defense team here. Tell you what, I have been drinking too many liquids. I got to run to the bathroom, and then I'd love to get back and discuss some of these closing arguments. So I'll be right back in just a moment. And then, by the way, hi, Legal Bites. I'd like
Hi.
to talk to you too.
All right. I'm going with Nick. I'll give you a fist bump.
He's like,
Nick.
I'd like to talk to you too. Bye.
Yeah.
Let me mute myself and leave.
So what's going on with you, Alita? What's the story?
Same as usual. I'm gonna be going on Natalie's channel later. Natalie Lawyer Chick.
Okay.
We'll be talking about this case also.
Oh, okay. I understand she has a different. I understand she has a different take on this than some members of this panel have. Is that correct?
I think so. I mean, I haven't seen most or much of her reactions to the trial so far. And I haven't been watching this as closely as I was watching the Rittenhouse trial or even the Potter trial for that matter. But I did see that she had the impression, at least early on, that the judge was potentially treating this defendant differently than Judge Schrader treated the other defendant, in Rittenhouse. specifically. But
Yeah, I would say in the Rittenhouse trial, if anything, the judge showed ridiculous latitude to the prosecution, meaning, it's.
well, I mean, Schrader apparently is known for being very defendant friendly, and just his overall treatment. I mean, just as a reminder, I mean, anytime that he spoke negatively or raised his voice to the prosecution, I mean, he always did that outside of the presence of counsel. This judge obviously has a different style, but different judges have different styles. So, I mean, and I haven't seen too much about his rulings in this case. For this particular trial. So I don't know. Like this was just what I saw from someone else's impression, but
And it's an important discussion to have, the comparison between Rittenhouse and Edgecomb, because look, they're both so public. They both quote unquote involve race, even though it was all white people in Rittenhouse. And they're both getting a lot of they're getting this public scrutiny, and they're both admitting that they killed people and alleging self-defense is the motivation. So to highlight the distinctions between them, why I think that that's where, to my mind, the comparisons end. And that's going to draw a lot of people towards trying to make comparisons. But to my mind, the comparisons end right there, full stop. And the reason is because, and I don't think I've ever said full stop before. I'm very proud that I managed to bring that cultural thing into my lexicon here. So, but the reason it's so different is because the video evidence in Rittenhouse makes so evident how he's trying to avoid engaging, and that it's always as a last resort, when there's really, it's me or the other guy, that he pulls the trigger, and he shows such trigger discipline. He's also surrounded by a mob which wants to see him dead. And that changes the entire parameters of self-defense. When you have a whole bunch of people who are swinging skateboards at you, trying to jump kick you, trying to tackle you, screaming, kill him, kill him, kill him. That's a very different self-defense situation than a guy who literally just threw a punch and like a coward ran away after throwing the punch, and then says, hey, he has a knife in his pocket, and that's the reason I had to fire a bullet into his face that I intentionally accidentally fired. This is not at all the same sort of thing. You have Rittenhouse on the stand, and he's sitting there basically explaining that every time it's like, look, I did what I had to do. I wish none of this happened. I did what I had to do, to live. And over here, you have a guy who's chasing after someone and saying, I had to catch up with them. And it's like, because they slighted me, and then I had to punch him in the face, and take the first aggressive posture, which is something that Rittenhouse never did, unless you believe the hocus pocus out of focus thing. And that's why I think that the whole dynamic of this situation, where Edgecomb is not surrounded by a crowd, he is the one who starts up in the physical altercation as far as chasing, and then punching him in the face and sending the glasses flying, and then as soon as the guy comes up to him with nothing in his hands, nothing at all, and really very little video evidence of, if anything, the video evidence, from what I can tell, doesn't show anything that the guy is really attacking him, and he's got nothing in his hands, and he shoots him in the face. I mean, that's.
Are you sure it was nothing, Joe? Are you sure it wasn't a nebulous something?
Yeah.
Have you thought about that? It was. I
want to hear more about Edgecomb's first aid kit that he brought to the scene. That was carrying around for hours.
Yeah.
The dueling theories that kind of came out too don't really help the case. I mean, because when you have a theory of the case, you should usually stick to one. So this idea that it was either self-defense or just the gun went off. I pull back the hammer and the gun went off. I pull back the hammer and the gun went off. Like what Alec Baldwin said. It's the Alec Baldwin defense doesn't really work so well in a self-defense case. The one, I was thinking about it. The one, I guess, thing that they could possibly say here in favor of the defendant would be the fact that he was, being pursued by a car. But I mean, if the decedent, if he got out of the car, he wasn't in the car, he wasn't in control of the car at the point at which he shot him. It seems like a very weak self-defense claim. Like that's the only potential dangerous weapon that I could think of.
He was not in threat from
in
the
this
car at the top of the stairs where he shot the victim.
Right. And they've testified that it's a, like what that, I mean, as far as they're concerned, it's a 2 foot by 2 foot box boxed in by railing. No Kia Soul is going to fit in there. Not even the smallest of compact crossovers will fit in this box.
But the heat of the engine, Nick.
I know the heat,
The
of
roar of the engine,
The
squealing
screeching
of the
tires.
Yeah, and it's pretty bad when like the whole closing argument is trying to nitpick these teeny tiny details and also continuing to dig into the widow and her memory. And I mean, obviously her memory is always at issue. Every witness's memory is at issue, and there's a way to pull that apart for a very sympathizing witness in a way that is also not going to take your own case down in the process, right? Like we saw that with Earl Grey. He gave a masterclass in how to cross-examine a sympathetic witness. But you know, in this closing, the way that they're trying to nitpick these little details here and there, the way that it's and then also trying to basically dismantle their own defendant, their own prime witness. It's just, I don't know. It doesn't look like a very strong case for the defense at all.
Yeah, the way you make this case is, in my opinion, I could be, you know, I'm not the one doing it. This is easy for me to say. It'll never be tested in this particular instance. But the way you make this case is very straightforward. And you say, look, you've got an incident that occurs that kicks off a chain of events. And that chain of events ends up with a big man, way bigger than our client, chasing him down, confronting him, and attacking him. My client, perceiving a threat, reasonably determining that this person who just tried to run him over with a car is trying to kill him still. But he couldn't get to him with the car anymore. My client tried to get away, couldn't get away. This guy kept coming. So he's trying to kill him. And my client perceives the threat and deals with it with self-defense. And it's reasonable because anybody who's being pursued by a giant person on foot after trying to get away, they can't get away. Anybody in that situation would be in fear of of their life, because we have no idea what this person was going to do. You can't take the risk. You can't get hit. He can't get thrown over the railing. Anything that happens to him ends up with him dead. And that's the way you go about it, in my opinion. I mean, obviously a little more polished, but this straightforward case of self-defense, you got a big guy squaring up, trying to harm you. So run that defense, but the more you sensationalize everybody and everything.
Hey, as Robert Kennedy said before he was assassinated in 1968,
by an immigration attorney from Milwaukee, might I add. Yeah. To quote Frederick Douglass, it's like this guy. Do you remember, have you seen the movie American History X with Ed Norton?
No. Never watched it. Aware of it, but never watched it.
So Ed Norton is a neo-Nazi or whatever.
Not in real life, folks. That's in the movie, the character.
In the movie.
Right.
Right.
Yeah, be careful, man.
And he kills.
You saw what happened with Cardi B.
He kills an African-American man in a gruesome fashion right at the beginning of the movie. But the story is kind of, it's about his little brother, who's played by Edward Furlong. That's the main story. And Edward Furlong is like following in the footsteps of Ed Norton, except Ed Norton kind of changes his opinion in prison when he kind of sees the nasty, he's revealed the illusion of the white supremacist gangs that he's been involved in and idolizing, because in prison they kind of get along with all of the minorities that they're supposed to hate. So anyway, Edward Furlong, he has this voiceover narration throughout the thing, because his whole thing is he's supposed to write a speech.
This is my favorite.
What? Okay.
It's a puzzle of whomever this is.
Okay, I'll talk about it later. It's great. Edward Norton is supposed to write a speech for his high school, And in the voiceover, he says, you always start off a good paper, a good speech with a quote from someone famous. And it's like B. Ivory Lamar is just taking notes on like an intro to speech writing 101 class, like fortify your speech with notes from excellent speakers and writers of the past. As JFK Jr.
As
said,
Genghis Khan said,
was it
I mean,
Frederick
yeah,
Douglass once said, not on closing argument to me, in my opinion, that does not really belong in a closing argument.
It has the feel of a mock trial closing.
Yeah.
it
Well,
has the feel of a trial whose purpose for B. Ivory is not actually criminal justice, but some broader political purpose.
The racial justice narrative. He's trying to make this into and he said it, this is a precedent-setting case. This
It's
is
different.
absolutely
It's different.
not a precedent-setting case.
It's different. I mean, black people don't normally shoot white people. I mean, is that what he's trying to say?
Yes. Yes, that's literally what he's trying to say. It's precedent setting because you have a black man shooting a white man in self-defense. That was the whole thing. But precedent setting, for the chat, in case you don't know, what a legal precedent is done on appeal. It's an appellate decision or a Supreme Court decision. He doesn't want this to be a precedent setting case, by the way. If it's a precedent setting case, that means they lose. And then on appeal, a precedent is set that goes to one of the core issues of the case. A precedent-setting case would be a nightmare for his client, even if they ultimately end up setting a favorable precedent. That means his client's in prison for a year or two, presumably.
I mean, apparently the defense here wants you to believe that this immigration attorney and his dark-skinned Filipino wife were driving around Milwaukee looking to hunt down and kill an African-American male on a bicycle, and he foiled them by whipping out his pistol and shooting the husband in the face. That appears to be the defense narrative here.
Yes.
You can believe that or not, but I choose not.
Well, and what I was getting to with the, I guess just with the manner of his approach to the case, if you are actually arguing a landmark case, using some, like, this is a landmark civil rights case, we're going after a real issue. You've got Black Americans excluded from movie theaters or something, in contradiction to the entire civil rights movement. And we're going to set this up. That's when you draw on speakers like Martin Luther King and Frederick Douglass. That's when you put that in there. When this case is about that, but this case isn't about that. And you don't want it to be. This case is about whether or not this guy was justified to pull the trigger. But the defense has made it about everything except that, including arguing that he didn't even pull the trigger on purpose, which is ludicrous to me. Did you intend to shoot him? Yes, I intended to stop the threat. Or no, but I did intend to stop the threat. I used the amount of force necessary to stop the threat to my life. That's what I did. I didn't want anybody to die from it.
Can you ask that question
stop the
again?
threat.
Can you ask that question again?
Exactly. Just wildly embarrassing. So my feed over on Fox 6 died and is not back. They've actually removed their stream. So Andrew, I'm going to send you the WISN live video link, which is live, although it's just the picture of the stately gentleman currently. But
okay,
what
I'll
I
be back
don't
in just a sec.
Yeah, sounds good. Here's the link to that one. What I don't want is a situation where we get informed that the jury is coming back in and the live stream isn't up yet. So I've got this other stream going right now with it. So just to let the chat know.
I am looking for this, and I will do this.
Warzone Brother says, what do you think of Natalie's opinion on this case? I don't know Natalie's opinion on the case. I've seen the chat give a summary characterization of it. And I try not to argue too often with summary characterizations of things because people could get stuff wrong. So if Natalie,
No,
would like
I
to
would
just-
prefer to hear from Natalie herself. She can make her own arguments. We don't need to hear it from the chat. And
Right.
if I agree with those, that's awesome. And if I don't agree with those, I'll state the reasons I don't agree with them. And but she's entitled to be here.
Right. Yeah, I don't want to sit here and dissect her arguments while she's
No.
not able to respond
No,
or
that
clarify.
wouldn't be fair.
Plus, I don't even know that it's her argument. But that's the nature of the internet. What I will say is I believe in this case, the state has the better case. I think the state has pretty much had the better case from day one. The main reasons the state has had the better case are a jury's going to look at this. And in this on the law, you've got a problem because we don't see a lethal threat presented in the video. We see a physical violence threat. Had he defended himself by punching this guy in the face, or something like that, certainly he would probably, a guy comes up to you and raises his hands like he's going to hit you. You can reasonably respond with some level of force. That's probably okay. Responding with deadly force without him even moving forward. And I don't buy the video personally that says that he was lunging forward. I don't think we can make that determination. I don't buy it from the defense. And I don't
So
even
when was he shot in the head? Was it after he lunged forward? Does that seem credible? I mean,
that's the argument, I guess. But it doesn't make sense with the way they're presenting it. Because if he was spearing forward, you'd expect the shot to be somewhere up here at an angle through the skull downwards or down in back. Yeah, down and back. If his trajectory is forward, no matter where he's firing from, if he's firing from extended or if he's firing from the waist, the bullet is coming from a 2-foot range of where the gun, a 2-foot elevation range. So wherever that is, you'd expect the bullet to be hitting and going down into the brain or into the, throat or something like that. You do not expect the bullet to enter at a slightly upward angle. If he's spearing down at the guy, you would expect and this is a point I think Joe was making earlier, that the bullet would be coming in and going back through into this area. But instead, this bullet comes in at a slight upward angle, which indicates either he's pointing the gun slightly upwards towards a taller individual, which kind of makes sense, or he's got the gun down at his hip and it accidentally goes off, if that's his narrative, and which would be at a lower angle with a slight upward trajectory as well. So I don't buy the him lunging thing. So I think they've already got a weak case on the lethal self-defense angle. And I think that's a big problem. I think that case is weakened considerably by the fact that he ran, that he never indicated to anyone that he acted in self-defense. They didn't bring up one of his family members that he allegedly spoke with, by the way, to say, you know what, he came over. My impression of him was that he was terrified.
the family members who apparently turned him in. I mean, what we're hearing is they told law enforcement, this is the guy. Yeah, they kind of glossed to that. But remember, he stays with someone for a couple days before leaving the state. He alleges. And none of them, no family member is brought before this jury to testify that they believed or perceived that he was in an excited or a distraught state, that he was in fear, that he had expressed to them anything about using self-defense and being afraid of the white oppressive system. None of that came out. And they could have done that. They could, because you can't testify to hearsay. They can't testify to what he said as the truth of the matter. However, they can testify to their present sense impression. Right. If they spoke to him and they got the impression that he was afraid or terrified, they could have brought them out and testified. Not one. Remember, he left the state to consult with family to try and find counsel and resources to acquire counsel. He doesn't manage to do that at all. They can't produce a single cell phone record of him doing this. They can't produce cell phone records of him calling his dad, calling his uncle, calling his aunt, whoever it is. They can't produce anything to suggest that his story is true. So I don't buy it for a second. I don't buy it. I'd like to bring in Legal Bites. Legal Bites, what are your thoughts?
Yeah.
You're here,
On which aspect?
but whatever
Everything I
aspect
just said.
you'd care to
I
address.
mean, yeah, no, it seems like the whole bit about like, well, he's scared. This is his first time being charged with murder. This is his first
This is
time,
my first time.
like that doesn't really help. I mean these jurors, most of them are probably saying, okay, this is my first time being
a
on the
juror.
jury, but yeah, like, okay, but so what? Like, this is the first time for a lot of the people here. But no, I think yeah, I just the closing for the state was super short, but it was exactly what they needed, I think, for them.
I
I
agree.
mean, it's because they didn't really need to do much. He pointed out the bit about the widow. He pointed out that, okay, here's a question that I have, because
Sure.
the defense in closing paid a lot of time on this wallet situation. The fact that the wife, that they didn't know when the wife took the wallet, that she had her hand in his pocket, like after her husband was shot. This seems like such a nothing burger for them to focus on for so much time, because if it were me and my husband in this situation, yeah, that would have been one of the first things that I would do, because I'd be concerned about the things in his wallet, like it's someone's ID, someone's credit cards, like that impacts you
You
as
want his
well,
money. I
because
mean,
you're a
that's why you married
spouse.
him in the first
Oh,
place.
of course.
Thank
Yeah.
you.
No,
Yes.
that's
Finally,
it.
someone
That's the whole
says it.
reason. No, because
And of course, the wallet here never went anywhere. It never left the scene. She told
Like,
officers on the scene she had the wallet. I mean, it's not like she took it
did
home
the wallet tell
10
him
miles
to shoot
away.
him? Like,
and-
I don't understand what
did,
the
did,
point
did someone
is.
kill someone with the wallet? I mean, is it even relevant evidence? It's
No, what they're trying to raise again, I've said it before. I think it's well stated, so I'll say it the same way again. They're trying to fill gaps in the story with gaps in the evidence.
Yeah.
You can't fill gaps with gaps. You have to fill gaps with some sort of substance. And
are you
in this case,
anti-gap? You're
I am
anti-gap.
no, listen,
I'm gonna
Mr.
tell
Branca,
YouTube.
I'm very serious here. I am pro thigh gap, and I will always be, but I'm anti most other gaps. And in this case, like, I'm anti tooth gap, Michael Strahan, disgusting. But no, I will say it that you can't fill a gap in this type of story with a gap in the evidence. You can't answer a question with a question when you're asserting self-defense. Now, if it's a whodunit, you can point to all the gaps and say they don't have a story. But on a self-defense claim, you're not saying they don't have a story. You're saying this is the real story.
I did it, but I have a legal justification. Well, that's a different case.
Yeah.
I mean, because technically, according to legal standards, the defense doesn't need to put on any evidence themselves. They can just try to poke holes, but generally speaking, that's not best practice.
It's not
right?
really
Because-
true in a self-defense case, because in a self-defense
true.
case, the state has to disprove self-defense beyond a reasonable doubt, but that means the defense has to raise a reasonable doubt
Yeah.
about self-defense. So it's not really that the defense has to prove nothing. There has to be something in support of self-defense, or there is no legal defense.
Yeah.
But this is a good example of why you still need a decent narrative, and just stick to it. Like, that should have been a relatively simple strategy for them, is just to at least stick to one narrative.
Yeah, they've been arguing in the alternative a whole lot, and so that's been a mess. You can't argue in the alternative on this. They're asking for all of these homicide instructions, and we know why, right? They're trying to obfuscate the facts and confuse the jury. Well, if you can't agree, like, one guy's on first degree and one on negligent homicide, they will never come together and determine one of those things to be true. Therefore, there'll be a hung jury, because one person says, I'm going to hang that N-word, and the other one says, no, it's justified, or it wasn't so bad, or whatever. I don't think that's actually how the jury in this case is going to work.
And
but I
frankly,
think
for
it's
the defense, you want as many charges as possible, because one of the things you're hoping for is you might get, out of 12 jurors, you might get 3 agree on this charge, and 3 agree on that one, and 3 agree on a third, and 3 agree on a fourth. But you can't get 12 to agree on any of them. That's an acquittal.
Yeah.
No, that they usually end up bargaining. I think they bargain and they're like, okay, you think that?
Well, in New Jersey, Joe.
No, that's not unique to New Jersey.
I'm just kidding. I'm kidding.
If you have a criminal case and you need unanimity, you're like, okay, look, that's what a lot of lawyers suspect happens, especially when deliberations have gone on.
Of course, it does.
Period of
Yes.
time.
Yep.
Yeah, I actually need to bail out of here because I have to drive my wife to the airport.
Oh, sure you do.
Sure you do, Joe. Okay, yeah.
Wasn't there something about her driving you?
No, yeah. I think you were confusing me with that whole cheer camp story that Nick always tells. So,
never been to.
Why
cheer
was she
camp in
taking
my
you to cheer
entire
camp?
life.
What's going on? Why
I
was
don't
she
know
taking you to cheer camp?
you have to ask
What
Nick,
were you doing at cheer
Nick
camp?
about his cheer camp days. I don't know.
Never
about
been to cheer camp. I
the
don't
whole
know what you're
the whole
talking
pom
about.
poms. It's
Never used a pom pom in my life.
I get it. Maybe it just came out in the middle of stream when you fell asleep from your narcolepsy, brother. I don't know.
No, you mean when I was a cheerleader and how I met my wife, who I used to lift up in cheerleading. Yes,
Oh, yeah.
but I've never been to cheer camp or held pom poms.
Okay. All right.
I don't know what kind of weird cheerleading you do on your weekends while your wife is driving you around, but I know what I don't do.
I will say from my own experience, cheerleaders are awesome.
yeah. Okay. I never simped by saying I'm gonna throw on a miniskirt and join them though. So I don't know. I guess
I don't know why you would throw on a mini skirt. I mean, so much is coming out
What are you trying
about
to say,
what
Joe?
you do, Joe. It's very weird.
I'm just saying.
Joe likes to wear cheerleading costumes. Is that where we're at?
That's what I'm getting out of this. It's so weird. He's
So
bringing this
doesn't
up on his
drive.
own.
He
These
doesn't
are all
drive,
statements
and
against interest, by the way.
I think you're doing it backwards. You're supposed to drive.
I'm just speculating. Look, Andrew, you can keep giving fellatio to Nick. That's okay.
Whoa.
It works.
Whoa.
Bigot.
Hey,
part of the agenda.
I met my brothers. Anyway, I really do need to fly. So it was great seeing you guys.
I bet Joe doesn't even fly the plane. I
See
bet
you,
he lets someone else fly the plane.
Oh, by the way, tonight, seriously, anyone who just joined, tonight at 10 p.m., I will be debating liberal Chip Franklin, Edward R. Murrow winner, Chip Franklin, on Biden, on the success or failure of Biden's first year. That's going to be on my channel tonight at 10. So make sure you click the link, follow, and you'll get noticed about that other good stuff. And also sign up to Legal Bites because
I mean, if you want.
Thank you.
She does fine work, and she knows a lot of Natalie's, and they come on her channel.
Well, this time I'm going to the other Natalie's channel, so it won't be on my channel. But be sure to subscribe so you can see the other Natalie.
Amen. Amen. Take care, my friends.
See you, brother.
Godspeed.
See ya.
Careful driving, Joe.
No, he's not used to it. It'll be a new experience for him. VPB says, I disagree that the defense doesn't have a burden in this case. Clearly, the defense is burdened by incompetent lawyers.
Oh, no.
No, but this goes to an important thing. It is the state's burden, right? It is the state's burden. But we tend to gloss over the way that burdens work and how burdens shift in criminal cases. The state's burden is to prove beyond a reasonable doubt the elements of murder, which is what the prosecutor just went through. Here you go. Intent, the actual act.
But it's a mistake to say the defense has no burden. They do have a burden. It's not the prosecution doesn't have to prove guilt 100%. There's a balance there. The balance is very favorable to the defense, but it's not 100%. It's whatever, 90%, 95%. But the defense has a burden to not let the prosecution get past that barrier.
Right. But so the prosecution makes a case. They lay out the elements. Here are the elements for first degree intentional homicide. Here you go. We've made it. The defense then says, aha, but we have an affirmative defense of self-defense. And they have a very low bar to raise the specter of it. Sure, to get the instruction. They say more than 0. Yeah, there could have been self-defense here because of this, this, and this. That's a burden. But here's the next burden. The defense has to raise a reasonable doubt.
Yes.
And then it's the state's burden to overcome that reasonable doubt. If the defense says it could have been self-defense, y'all, They've never raised the reasonable doubt. Therefore, the state has no further burden than the initial proof. So we tend to summarize and make succinct these burden shifts that happen in civil and criminal cases. And some lawyers get really pedantic about it, and they're like, "It's not a burden," but it is. In this case, the burden was on the state to prove murder. They've proved it. And in fact, the defense basically admits to some level of murder, maybe not first degree, but some level of either murder or manslaughter. Some level of homicide is admitted to necessarily by the defense to claim self-defense. So
it's
then
such a complicated self-defense case where your defense counsel is allowing for demanding jury instructions on 5 different elements of unlawful homicide,
including the negligence instruction. They should have stayed far away from that, in my opinion. I think it would have been funny if the judge would have said flat out, he just would have said, yeah, if you want the negligence, we're getting rid of the self-defense. If you're so inclined, I'm happy to oblige, but I think it'd be bad for your client.
Yeah, I mean,
And
if
then-
Jason Cleereman is breaking into Theodore Edgecomb's house and Theodore Edgecomb shoots him in the head, that's a clear-cut self-defense case. This is a lot more ambiguous than that.
But wouldn't you agree that they made it even more ambiguous than it is? How would you defend Edgecomb, Branca? What would we've got the facts of the case as they have. Let's assume
I'd concede he was the initial aggressor, and then in a non-deadly force fight, he threw that first punch. He was he earned a punch back. But what Cleereman did was presented himself not merely as a man who was trying to throw a punch back, but as a man who was presenting as a deadly force threat. He outweighed him by 50, 60 pounds. He was going to throw him down the stairs, which would have resulted in serious bodily injury. That in that way he presented, but I would have left all this N-word racism stuff out of it. It would have been, it shouldn't have mattered.
you don't need it.
You don't need it.
Because if this
But the
other
problem you run into there is if that's what happened, then Edgecomb would simply have waited for the cops and told them what happened. But he didn't. He fled for 6 months, recovered 1,000 miles away by Kentucky State Troopers, lied to them about what happened, lied to the Milwaukee police about what happened when they showed up to question him. That doesn't look like a self-defense case anymore. And I mean, maybe if you cry racism, that'll get you out of it. I don't know, but it's not a compelling legal argument.
Yeah.
N200 setup says, Nick, y'all are acting as lawyers instead of jurors. The jury doesn't know the law. So what you all keep forgetting while making your comments. We're not forgetting it. First of all, we can't comment on what a juror knows or thinks. That's outside of our realm of possibility. But 2, think about this. If a juror very possibly says, hey, this guy rode up on his bike and punched him in the face, provocation, which is in the instructions. Remember, that was Binger's entire strategy, was to improperly introduce provocation into the Rittenhouse defense, to say Kyle lost all privilege of it. If a juror believes that, even though the law is wrong, or the statement of the law is incorrect, if a juror believes that, they can find guilt easily. They can say this guy provoked the attack and therefore he had no privilege to self-defense. They can disagree that the withdrawal was complete and reasonable, even though, as Andrew has said a couple times, there's not much withdrawal that needs to occur before you're clearly communicating to the person that you're not intending to fight anymore. But a juror doesn't know that. That's a legal standard. So while be very careful in saying you guys don't understand the jury, they're not lawyers. I mean, we're glossing a whole lot here, but we cannot know the state of mind of a juror for sure, but we are glossing a whole bunch of legal precision.
There's a certain amount of information that we can get by watching voir dire. Did you watch voir dire on this one? Because I know.
No,
yeah,
it was.
I didn't think so.
The televising of it was really awkward, and at the they started doing voir dire, and then one of the jury pool members got shown on screen, and the judge scrapped the entire jury pool and redid it.
Yeah,
it was a mess. So I didn't see it.
Yeah.
But,
Okay. Yeah. So I mean, there's a certain amount of information that we could get through there, but otherwise we can't speculate as to who's on the jury. I mean, other than what the judge just said about it being half white and half people of color, right?
Right.
So, I mean, other than that, I mean, we really don't know, and even that doesn't tell us anything about what they're thinking.
I
Let's
agree.
be real,
doesn't.
because people are not monoliths according to their demographic. Like,
When-
not every woman thinks the same, not every man thinks the same, not every white person or black person or Indian person or Mexican
Well,
person thinks the
right.
same.
White people
Yeah,
can
and-
be racist or not. Black people can
And-
be racist or not. Anybody could be racist or not. I mean, you just can't assume it. If you assume it based on a person's skin color, you're kind of being racist.
And for
Yeah.
example, my friend Drexel very controversially says he's a black man. He very controversially frequently will assert firmly that black women hate black men and will sell them upriver 10 times out of 10. So if the 4 African American jurors
I'm not sure
are-
white women are much different, frankly, but
But if he says that if the 4 African American jurors are women, in Drexel's mind as a black man, he would suggest that they're more likely to convict this guy because, quote, he ain't shit.
oh,
I
no
mean,
kidding. Did
and
he say that actually, or you're just presuming?
No,
he
I'm
said that?
I'm presuming what he would say. I could ask him. I could ask him. Oh,
Bring
here.
him on.
Well, he's not going to be on right now. He's probably working, but I'll message him and say, black man shoots white man in self-defense. Black woman juror, guilty or innocent. That's what I'll send him, and we'll see what he says. This will be a fun test. Okay, here we go. Black man shoots white man in. Oh, I know exactly, especially because a white man's been shot. I know exactly his answer. This is terrible. Okay. He usually responds pretty quick, so we'll see what he says. But yeah, so the idea of determining the outcome based on the racial makeup, I think there's a whole lot more that goes into it than that. And like Legal Bites eloquently said, no group is a monolith, and there are internal politics within groups, even within political groups.
Yeah.
That will change this. I was saying the other day that even if you assume that all the jurors are quote unquote woke, do they strain their woke credibility or the credibility of the movement to defend someone that they believe is too far? Or do they think that damages the movement to extend that out? You don't know. You never know. So, but no, you can't predict a jury. That's why we don't predict outcomes on this stuff. Although the chat is predicting an outcome.
By the way,
Or
Legal
well-
Bites, I see people in the comments saying that I rudely interrupt you. If I did, I apologize.
no, you're
but
fine.
but feel assured that if you ever feel the need to, I mean, I'm not trying to inhibit your ability to voice your opinion.
No,
So-
of course. No,
Andrew
I know.
Bronca is
and I
the
get-
glass ceiling. Oh my God.
No,
I
get
do
this-
tend
I
to
get this all the
interrupt. I
time.
know that about myself, but I'm not trying to keep other people from speaking. I'm just.
I know I get this all the time because I frequently let other people talk because I like hearing what other people have to say. So, but I get the critique from people that I need to be a little bit more
Man
I guess
up.
aggressive or assertive. But I think I've gotten a little bit better over time, but maybe not 100%. But no, you're fine. You're fine.
Okay.
So.
The next super chat here, because we have a grip of these. Decaf Geek says, ladies and gentlemen, this is Chewbacca. Does it make sense he lives on Endor with a bunch of Ewoks? I think not. The defense rests, Your Honor. Yes, the infamous Chewbacca defense of South Park. So the chat has determined after closing argument, they have cast their votes. The vote options are guilty of murder, guilty of manslaughter, not guilty, self-defense, or hung jury mistrial. After closing arguments, the chat says 78% guilty of murder, 11% guilty of manslaughter, 3% self-defense, and 8% hung jury. So, if the jury pool is a Recato Law chat, this dude is high likelihood to go to prison for the rest of his life. But
then he'll get his degree.
Kevin PEAF Smith says defense closing arguments were not for the defendant. They were an audition for future lucrative work for the lawyer. Sickening. Time for African Americans to consider themselves Americans, not African Americans, as the Democrats want. This is what happens when you choose an attorney based on his skin color. Coy 540 says, how do you feel about Supreme Court Justice Stephen Breyer announcing retirement? One, good, I guess. I don't know. Go live out the rest of your life and be a happy man, Stephen Breyer. I found his presence on the bench to be irritating whenever he was speaking, but his opinions, though I disagree with them, I didn't ever think they were ill-reasoned or anything like that. I just disagree with his judicial perspective. I would prefer him on the bench more than likely to whoever's going to follow. I have a feeling that that's going to be a disaster, but I think it more indicates just how afraid the left is of the midterms. They think they're going to lose the Senate.
Yeah.
And by the way, folks, in this case, this defense was not great, not because they were black. There's plenty of awesome black attorneys out there. It's got nothing to do with your skin color. I don't think B. Ivory's not a good attorney because of his skin color. I just think he's not a good attorney. There are a lot, thousands. Who knows?
He seems inexperienced. That's the impression that I get.
In a
because
murder
there
case.
are certain terms. Yeah, in a murder case, it's being
let's face it.
televised,
Inexperienced is, I think. Listen, he doesn't know what witness means or testimony means. Apparently, I mean, the way he
that's what I'm referring to.
That's like someone who's never been to law school. I mean, and he's co-counsel on a murder trial.
Let's see.
It seems a bit over the top to me.
He went to Howard University School of Law. He got his JD in 2019.
Yeah.
It's very possible that this is his first major crime trial, in all honesty. In fact, not only is it very possible, it's likely that this is his first major crime trial. Remember, criminal law is not his sole area of practice. It's not his area of expertise. The first area listed on his practice is personal injury.
But would you take on defense of a murder
testimony
trial
and witness, and like those are terms that he still should. And the whole quotes being used in the closing, I don't know. It feels like somebody who just got out of law school and maybe did like one round of mock trial in law school, and this is their first trial that they somehow managed to snag.
A murder trial. So you graduated from law school. You had your first trial. Was it a murder trial?
I've never had to take anything to trial.
No, I'm just saying. Would you?
No.
Would you?
Today I wouldn't do a murder trial. Today I would not do a murder trial on my own. No, not a chance.
I wouldn't
Certainly
either.
not first trial, or not first chair.
Well, I don't think, I'm not sure he is first chair, but I mean, he did the opening and the closing. I wouldn't do opening and closing in a murder trial.
Yeah, no, my first criminal case was felony theft. And that turned out fine. Had some stuff, but these were not hard cases. There were some minor things that the police did wrong or that the state failed to do, and we were able to either plea them out or get them knocked down to basically inconsequential things for the overwhelming majority of my criminal defense cases. But would I do a murder trial? No, I would immediately suggest that the person be referred to anybody else. Someone like, your life is on the line. You want a firm with the sufficient resources and experience to do this. You want a firm who can investigate every single witness. You want a firm who can do social media research on the jury, on the jury pool.
But in fairness, the defendant doesn't know any of this, right? Edgecomb wouldn't know any of this. I mean, he's presented with legal counsel. They look good. They have nice suits. He doesn't know.
Lawyers are lawyers,
But I'm not.
right?
I'm not suggesting. I'm not presenting from the portion of the defense. I'm presenting from the lawyer who is approached.
I just wouldn't do it. I wouldn't do it.
Yeah, I would refer them. That's what I'm saying. I would say, hey, you don't want me. You want somebody else. This is what you want.
I mean, who knows what that conversation was, right? Because I mean, they may have said like, hey, look, there's literally no one else, that can do this, that'll do this. No one or no one else that I trust to do this. But they may have been priced out of other attorneys. That's another thing.
There are plenty of perfectly competent public defenders who could handle this case. Plenty of them.
This is
Sure.
this is
That's true.
Jacob Blake's attorney. This is a guy who's been on stage with Ben Crump. He saw. I
It's
would wager
theater-
he sought this
theater
guy
law.
out completely.
It's not real law. It's theater law.
Okay. Anyway, Cosmic Sense. Oh, so wait, Drexel responded to me. It's surprising. I feel completely wrong. I don't know him anymore. He says depends on if she's a swirler, which is offensive. Then he says, but most likely the black dude walks. And then he says, here's why. She's afraid of the community destroying her for sending a poor innocent black man to jail for defending himself against the white devil. That's how it'll be framed anyway. So there's his response. So the wise words of Drexel.
I defer to his greater expertise.
Cosmic Sense says, I'm checking my notes, Mr. Ivory, sir, but all they say is Edgecomb is guilty. French Fries says, why would a Wookiee, an 8-foot tall Wookiee, want to live on Endor with a bunch of 2-foot tall Ewoks? That does not make sense. But more important, you have to ask yourself, what does this have to do with this case? Nothing. So there you go. More of the Wookiee or the Chewbacca defense. Very important and well-established legal maneuver. It's like chess. You know, you have legal maneuvers in the same way you have documented chess strategies. Pretty much the same thing. Where is, oh my gosh, the YouTube window is going really slow right now. Scroll. I hate everything.
I thought you had a way to export that to a spreadsheet.
I don't like using, I mean, I do, but I don't like using the spreadsheet because the spreadsheet isn't color coded in the same way.
Yeah.
And
okay.
it's just how I organize super chats because
Yep.
I do the $20 plus ones first. This is easier.
Okay.
Matthew Jones says maybe Miss Cleereman shot her husband in the car and Mr. Cleereman ran to the defendant for help where he died. We just don't know. We just don't know.
It seems credible.
Billy Witch Doctor says, could fleeing for 6 months also go to reliability? Yep. Yeah. Brian Miller says, I feel I could do a better defense lawyer be a better defense lawyer than this tool. Joe Everyman says, pray for me as I take this arduous journey to listen to this leftist close. Frederick Little says, hey, Nick, glad to be a member for 16 months. Also, did you happen to find my super chat from yesterday's Edgecomb stream that I had commented you missed? No, Frederick, please tag me or tag one of the mods or something in so I can read it with what it said. I don't have an easy way to look it up right now. Randy May says, love the show. Rittenhouse trial was the most compelling 2 weeks ever. What's your opinion on the Brendan Avery confession and wranglings since? Peace. Who is Brendan Avery?
Don't know.
Legal Mites, any idea?
Mm-mm.
Okay, Brendan Avery. The hell is this? It's Brendan Dassey. With Steve Avery. No, that's Steve Avery. I don't know who Brendan Avery is because when I look up Brendan Avery, I get Brendan Dassey from the Steve Avery making a murderer charge or case. So that's not very helpful. So sorry, I don't know who that is. Never heard of it. One Last Riot says, strike one, defense needs to use a clicker to control his pet. It grates on me as a technician when someone says next slide. Strike two, defense made a juror puke. Prosecutor didn't strike. Or didn't. Strike three, don't remember, but he needs it. Okay. Yes, making a juror vomit with your closing argument is never a good look. Randy May says, please read in Richard's voice. Your Honor, my client referred to Brendan Dassey as Brendan Avery by mistake. He's very sorry and wishes to plead guilty at this time. Okay, so Brendan Dassey is from the Stephen Avery case, and I have no idea. Like, I've never watched How to Make a Murderer or Making a Murderer, Making a Murder. Never watched it. Did you guys watch that show at all?
No. Nope. A lot of my friends in law school did, but I don't know, for whatever reason I didn't. I did listen to the first season of Serial.
Yeah, I did too. What did you think of that?
I thought I mean it was pretty good, but I mean it didn't quite capture my imagination as much as it did for a lot of people, because for me, I was like, the legal questions were much more mundane, I guess, rather than the I guess that the evidentiary questions that were coming up, if that makes
Sure.
any sense. So,
Yeah.
but season two, I just I couldn't get past what,
I
like
got 3
episode 2 or
episodes
3.
in, and I was like,
Yes.
this is boring and terrible.
Yes, because
See,
I was like, okay, Bo Bergdahl taking the story, like assuming that everything that he's saying is true. Like it was almost like a motion to dismiss standard, like assuming the facts and evidence or the facts alleged to be
This
correct.
sucks.
Like even still, like you're a terrible person, and what you did was wrong, and like also how would you think that you could be making the changes within the military that you think you're entitled to make, first off, and second off, what makes you think that any general is going to listen to you? I don't know, it
and
just
third, how do you accomplish those changes by deserting your base?
right.
That
Right. Like his ultimate goal apparently was to like get a meeting with a general about the things that were going on. But it's like, okay, even if you
No.
force a meeting, what makes you think that they're going to listen to you?
That was all a lie.
yeah.
Like I said, it was assuming that his alleged facts were correct.
Yeah.
And even that is like has problems.
Yeah, I was not enthralled by the story. Look, they made a pretty interesting case out of Adnan Syed. I think they've raised the specter that Adnan Syed that there was some bad work that led to his conviction. Now, there are a bunch of people who say he's really guilty. I don't know if the guy did it or not. There's not really a good alternative theory, but there was an alibi witness who was not brought to the stand, was not even called, if I remember right.
Yeah.
I
think not even investigated. There was,
right.
I do remember that there was one witness, one potential witness that the defense attorney was told about, and she didn't even investigate herself, which is, I mean, there were a lot of professional responsibility issues, I think, in that one.
Right. And whether or not she should have disclosed her terminal illness and all of that stuff, those are all real interesting questions. Also, the cell phone testimony, when they actually broke that down and showed how selective the cell phone metadata, it was, I believe, the first murder charge, at least in that state, maybe in the entire nation, that used cell phone tower triangulation to support a factual narrative. And when they showed, when the evidence is presented in court, it's like, oh, this makes sense. And then when they show all the other cell phone tower pings that were happening, and you're like, wait, they cherry picked only the ones that supported the narrative, and they got rid of the overwhelming majority of them, then you have to ask questions. And they didn't really have a good expert on it or anything like that. So maybe there's something there, but maybe not. Right. That's how it goes.
But you don't know until you look. And that's one of the reasons that the money matters for the defense. You need the money to hire the experts to do that.
Yeah.
Yeah. And you're talking about at the time they're doing it, it's the first time they're ever I mean, they still had payphones when this case happened. And payphones were all over the place. But when they're doing it, you don't have anyone for the defense, these experts, as easily available as they would be today. Today, you could go online and find a guy who can be an expert on cell phone tower triangulation and tell you all about it. Back then, you'd be paying top dollar to like a Verizon or AT&T tech to come and testify as an expert witness on how this actually works out. And
yeah, this seemed pretty mundane in the Halderson trial, right?
Yeah,
because that came up for that one because of all of the locations where they found his parents' body parts,
and his mom's cell phone pinged a tower from the house.
His cell phone did too, right? Or am I mistaken on that?
So no, his cell phone had the GPS locations from Snapchat, basically. But his mom's cell phone, which was supposed to be presumably with her, was of course wrapped up in foil and in a shoe in the garage. But it was pinging the local cell phone tower that had it in the house the entire time. It never left, even when the text message was sent from her phone to him, supposedly from hundreds of miles away or whatever. So yeah, it was very mundane there. But in the in the Adnan Saeed case, we don't know if it was adequately argued at all because I don't think they had an expert even do it.
Yeah.
William
Andrew,
Gabriel
you
says,
okay?
No, I'm fine. I'm just so back in the day, we had, of course, expert witnesses in trials, but they tended to be in very defined silos, like a medical malpractice expert, that kind of thing. I mean, but the world's become a lot more complex in the last 30 years, and now anybody can be an expert in anything. And I know I get invitations all the time to be an expert witness in these. I guess because I'm old, I would call them yellow pages of expert witnesses, but. Expert witnesses are everywhere today. Everybody thinks they can just be an expert witness and make $1 million a year doing that because they have a degree in IT or whatever, whatever it might be. Right. That's not really the way it works. I think most of those yellow pages of expert witnesses are making exactly $0 per year being expert witnesses, but they're everywhere.
But if you're a good expert witness on something important like genetics, for example, you can make quite a bit of money doing it.
Yeah.
You know,
some of them do.
Yeah. So Sakaki in my chat here is saying that according to Shannon Bream on Fox News, Breyer was not planning on announcing his retirement today, and he is incredibly upset about this.
Well, an
I mean,
unbiased
he's been
source, so
pressured.
that's good.
he's been getting pressure for a long time by the Democratic Party to retire because they're worried that he's going to pull another RBG.
Yes.
So.
I mean, that's the fear. He'll die at an inconvenient time. They'd rather he just die or retire at an appropriate time where they can pick his successor. And
so humane.
Why doesn't he care about the mission, that bigot? William Gabriel says, can Mr. Branca talk about when self-defense with a firearm would be appropriate when facing imminent threat against fists? Fists absolutely can be lethal force. Fists kill more people than rifles in this country every year.
I can talk about it, but it would be more succinct for me to say get hard at lawselfdefense.com/get hard, and you will learn everything you need to know in 3 or 4 hours.
One additional comment on that. It is true that fists and feet kill more people than rifles every year. That's because the rifle death rate is exceedingly low.
It's effectively zero. So
it's very, very small. The other is those, if I'm not mistaken, those fists and feet events tend to be group violence. It's not this narrative, which does happen, but is very rare, where a guy comes up, clocks someone one time, and they go lights out for the rest, forever. That is rare, although it does occur. You're talking about someone getting knocked to the ground and stomped on, getting severe brain damage from being pummeled over and over and over again, sometimes by multiple people, or you're talking about potentially fragile people. Sometimes those fists and feet homicides are child abuse type things, a parent beating or shaking a kid. So, the reality is it's always whenever you perceive reasonably a deadly force threat. I mean, that's it.
It's never, even in the Wild West, it's never been the law in America that if someone throws a fist at you, you can shoot them in the head. That's not the law. The courts, the criminal justice system sees traditional fistfights all the time. People don't die. They're not maimed. They're not crippled. They're not going to let you escalate a simple fistfight into a deadly force fight by pulling your gun and shooting someone in the face. That's not how it works. You may want it to work that way, but that's not how it works.
And remember, in the Zimmerman case, the amount of evidence that occurs by the time he pulls the gun and fires, which is, as you pointed out, also combined with the fact that there's testimony that Trayvon Martin was reaching for his gun, that his jacket fell open and the gun was exposed.
It was a sustained beating. His head was getting beaten to a sidewalk. It was not a traditional fistfight anymore. It was something more than that. There were aggravating factors.
Yep, and that's the type of stuff that you're looking for. Now, and I don't know how else to say it, but if there's someone who's particularly lethal, like maybe you watched them kill someone right before coming to you, like they go up and they just knock someone out and then pound their face into the dirt and kill them. They cave their skull in right in front of you. Then they turn towards you and put their fists up. Well, yeah. I mean, you've now got a reasonable fear of imminent death or serious bodily injury. That occurs very quickly.
Or
Yeah, but
you
something
know,
has to happen. Something has to happen in front of this person to show that this person is actually lethal or potentially
right?
lethal.
Or they knew
right?
beforehand.
you
They
can't
know the
just assume
person, right?
that.
They might know the attacker. They might know the attacker has an exceptional fighting skill,
Yeah.
or they might know that they themselves have some exceptional vulnerability to a simple punch. That can happen too.
Mhm.
But we're talking about those aggravating factors now. Absent those aggravating factors, a thrown fist is not justification for shooting someone in the face. Absent those kinds of aggravating factors.
Yep. Eric Allen says Edgecomb did say he was defending himself in the beginning of Cross a million times, but he switched up and said that it was also an accident. So I guess he accidentally protected himself. Yes. Also, to put a point on that, Edgecomb saying he was defending himself is a legal conclusion. I was defending myself. I was acting in self-defense. Those are not actual facts. Those are just things that are said. If he goes up and testifies, I was not murdering the man, that doesn't mean he didn't murder the man. In the same way, saying I acted in self-defense or I defended myself is not on its own sufficient. You have to establish a factual basis for your arguments for the jury to use. In Kyle's case, he didn't want to kill someone as he testified, but he needed to act. He pulled the trigger to stop the attack from happening. And he didn't pretend that he didn't pull the trigger. He didn't pretend that he didn't aim at the person as best and as quickly as he could and pull the trigger. That was always in the factual record. He just put in there his motive was not intentionally to kill, but to end the deadly or the threat to his person.
Yeah,
So.
and on that note, you can have, in generally speaking, in a lawsuit, you can have alternative legal theories, right? You can have different legal arguments for why one party should win over the other. But when you start to have alternative facts that you start introducing, or alternative reasons for why someone did something that start to compete with one another, that's when you have problems, because the jury's just going to look at it as this witness is just being dishonest.
Right. So you shot somebody in the head. Why did that have to happen? That's what the jury wants to know. You killed someone. If that had to happen, that's fine. That's allowed. But why did that have to happen? And if your explanation is, well, maybe for this reason or that reason or another reason or 8 other reasons, it does not appear to be a compelling reason to shoot another person in the head.
Right.
Yep. You have to tell them the story. Or the facts have to tell them the story. One of the two.
Yeah.
Barry Soitoro says the prosecutor should replace Little Binger. They probably want this.
Okay.
They probably want this guy in Milwaukee rather than Kenosha. Frankly,
the prosecutor was fine. He was good. Binger was fine. Technically, he was fine. I don't like him.
Mandy Karavichus says legal bites. Please be careful around Bronca. He'll get hard. Damn. Timothy Brown says any predictions on jury deliberation time? Do you think they will come to a decision today? I don't know.
I would hope so. Who knows?
I think he's guilty. I think his guilt is pretty obvious from the testimony from the trial. So to me, I'm thinking this should be wrapped up pretty quickly. An hour, 2 hours. Chandler Halderson, they found in 2 hours, and they don't even have his mom's body. That's kind of wild to me. So,
yeah,
but I have no idea that the defense has done a lot to try and obfuscate the issue and cloud it up. And so maybe it'll take them longer to sort through everything. That's one thing I think was missing from the state's closing statement on rebuttal would have been, for me, he said, the defense says you'll have to go through all of these things. You'll have to sit down and go through each and every one of these potential charges. But that's not actually true, because this is first-degree murder. And remember the judge's first instruction to you. If you find first-degree murder, you go no farther. He's guilty and it's done. And that's what happened here. So you don't have to go through all the
you need to
charges.
be careful, because if you basically tell them it's first degree murder or nothing, effectively, then if they don't find first degree, it's nothing.
Yeah, you could say you only need to go as far as his guilt will take you. There you go.
Yeah, but I mean, I don't know how much a jury is going to understand that phrase.
Yeah, I don't know.
Like,
I
really?
don't know. I think he could have easily countered the and maybe he doesn't go as specific. Just says it doesn't actually take that long. You have the elements here. You have the law. We have the facts. We know he's guilty. The defense wants you to believe in nothing. We've given you something to agree on, or whatever, and then wrap it up. I would have liked to see something about simplifying the jury's time, but that's me.
The trouble with the prosecution accepting all these lesser includeds at the end was now he has to talk about them all in his closing.
And he basically completely dismissed the negligence one. He just said negligence, that's out.
The fact that you have to talk about all of it suggests that you don't have confidence in the highest degree. And maybe you don't. I mean, and I don't mean it doesn't have merit. I mean, maybe you don't believe you can convince this particular jury of the highest degree, despite the legal merits. But now, instead of focusing your closing on one charge or two, first degree murder or second degree murder, now you have 5 different charges on homicide, plus whatever that other stuff was, the gun charge and so forth. I mean,
well, the gun. No, in this case, the only charge is the homicide.
Okay.
That actually bothered me because Lamar kept saying that.
Oh, I guess the gun charge was part of is an element of the negligence, right? Negligence with a firearm.
Yeah.
Okay.
Yeah. But he does also have the gun charge and the DUI charge in his pending misdemeanor case. And I was annoyed that B. Ivory kept saying, oh, he accepted responsibility for that. It's like, actually, he hasn't yet. He pled guilty to bail jumping, but he didn't plead anything and other than not guilty as far as we know in these other charges. So that was just personally grating to me. Scarlock says, CNN, can we at least all agree the wallet and the knife conspired with the gun to kill the radical immigration lawyer who was planning on replacing blacks with Ukrainians and Canadian truck drivers? I think so. That's good. They made a big stink about that wallet. Which I really don't see that as, I mean, and maybe I'm biased, but I don't see that as very damaging.
It never left the scene. So she told the cops at the scene she had the wallet.
Yeah.
That's not tampering.
Yeah. I mean, especially since it would be different if she was somebody who came on the scene after the events occurred, but she was there the whole time, right? I mean,
yeah. And she immediately turns it over. I mean, she immediately, the cops are like, oh, we can't find his wallet. And she's like, I have his wallet. I grabbed it off of him. Here it is.
Because I'm his wife and that's what I would do. You know, I don't know. That's whatever. It's so stupid.
Yeah.
To me. I don't see the point. I don't see the point in spending so much time on that. I mean, other than literally having nothing else to argue about, you know, that's just one of the few straws that you can grasp at. I don't know.
C. Goody sent me a couple chats that must have been a mess. I don't know. He says, from Ghost of Ace says, do you think that Floyd had 2 times a lethal dose of fentanyl in his system for the upcoming cop trial? No, I think he's been clean for a while now. He also says, at Matt Roberson, see if you guys can get Rekieta Law to send Scott Reish at Crime Talk a link for the stream. I did. Nick wanted to hear his experience of getting DMCA'd by Law and Crime. So it apparently happened to Crime Talk before as well. I sent him an invite. You know, he's welcome to come on. I don't know that he's got the time. That's always the question. Kyle Service says Breyer stepping down for Camel Toe to take seat and Hillary gets VP just before Joe Obama steps down. I don't think that's going to happen. I don't think they'll appoint Kamala Harris as Supreme Court Justice to replace Breyer and then have Hillary Clinton come in and be vice president. I just don't think that that's the likely outcome, but that would be funny.
It would be fun.
C Red Dot says, as a 34-year-old working class individual that never finished their college degree, watching you all has reinvigorated my obsession with debating and dissecting law. Do y'all think going back to school for my JD is worth it?
No.
It depends on what you want to do with it.
Yeah, not
if
for
you actually want to practice, but I would get some experience in the legal industry in some kind of law firm. Just getting your foot in some law firm
Right.
for some
Be a
time, just to see if
paralegal.
you actually like it.
Be
Or
a
an
paralegal.
investigator.
See how bad it sucks, and then
Yeah.
don't do that.
Yeah, but if you just want to debate and dissect law, I don't think a law degree isn't what you need. You get a law degree because you have to, because you want to practice law.
Do people still think that law school teaches you how to think? Is that still a thing? Because it doesn't really, folks. I'm sorry. Most of the good lawyers I know knew how to think critically before they ever went to law school.
What the hell? Oh, damn it. All right. I hate picking names for this damn account. It says, would any of you join as co-counsel on a murder case that the defendant requested you on if they have heard your opinions on other cases and value them as well-reasoned and needed perspective for their case? I might question why they would want me on there, but maybe.
I'm never co-counsel, so I only consult on cases. But yeah, I mean, if you're a platinum protection member, law self-defense, and you're involved in the use of force event, you get my consult for free.
So there you go. What about you, Legal Bites? Would you co-counsel a murder case?
I don't know. I mean, if I had a strong first chair to work with, because I like commenting on law. I've done civil practice. I don't have too much criminal trial experience. So, or criminal law experience. So I don't know that I would be comfortable with working on a murder case. Unless, like I said, I had a trustworthy, strong, person to work with on that, to make sure that the person's rights are fully represented. Because it's one thing to comment on it, right? But it's another thing to actually put the practice,
very
you
different.
know, yeah, because we're talking about somebody's rights, which impacts their entire life. You know, I don't know.
Yeah, and co-counsel would be different than consult, right? Like maybe consult, or consult on a case.
Yes.
Sure.
Yes.
Again,
Absolutely, I would consult. I mean, well, I wouldn't guarantee that, but like I would be much more willing to consult rather than like actually putting the trial on.
Yeah.
But even still, I would question why they would want me on a criminal case.
Yep. Man says the defense point regarding the wallet is that the wife actually took a knife out of the husband's hand and put it in the pocket. The wife covered up for the husband. I mean, I get that. The problem is they don't have
There's no
any evidence of that. In fact, they have evidence contradicting that. They don't have blood inside the blood inside this guy's pocket. If he's got blood all over his hands and grabs the knife from his pocket in the first place, there should be blood in one of the pockets, if not both of the pockets.
Mm-hmm.
There should be blood on the knife that gets put in the pocket. None of that occurs. That's a big, big problem. And the state brought that up rather expertly in their closing argument today. So I get that that's their point, but even on close, the defense was remiss to actually say that. They wouldn't do it. They said, "What? We're not saying she did it. We're just saying we don't know if she did it." Well, for my money, you better have a story.
Because realistically, that's the most that they could possibly say, which isn't enough to convince a jury. Because if they were to basically say we think that that's what happened, they run the risk of drawing an objection from the state, saying objection, facts not in evidence, which is like a huge bummer to have at the very end in the middle of your closing statement.
Yeah, the state also brought up good counterpoints. Why would she think I'm going to fold up this knife and put it in the pocket rather than, if she's trying to hide the knife, throw it, put it in her purse, do literally anything with it at all? If she had taken that knife from him and put it in her purse, that knife wouldn't be in evidence today. Because remember, there's no blood on it. If the cops search her purse, she says, "Oh yeah, I carry a knife in my purse." If she's the liar, if she's the mastermind doing this, that knife coming from her purse saying, yeah, I carry this knife all the time. And, you know, it was with me. Then it never even becomes evidence. The only reason that knife is in evidence is because it was in his pocket and it doesn't appear to be anywhere else. No one testifies to that knife. That was never his story either. That's his story now. It was never his story when he was apprehended or anything like that. Typically, when you've got a self-defense case, you are alleging pretty quickly some facts about the situation because you want to tell the cops why you're not guilty to some. Now, you should do this through counsel usually, but you want to tell them why they shouldn't even bring charges against you. And it's, this guy came at me with a knife. I needed to defend myself. Or your attorney saying, guy came at him with a knife. He needed to defend himself. This is obvious self-defense. Charge here is inappropriate. You can't even meet probable cause. Come on now. That's where you go with that. He didn't go with that because it's not true. I mean, frankly, like, to no longer sugarcoat it or pussyfoot around it, it's just not a true story. The knife thing needed to be supported by any evidence, and they had zero evidence. So, big mess on his part.
Yeah. Well, I need to get going because I need to get a little bit of sleep before my next YouTube appearance. I'll be on at 7 p.m. on
You said you're on
Natalie the
Natalie's
Lawyer
channel?
Chick. Yep.
Very cool.
Yep.
Tell her we say hey.
I will. Yeah, I'll see you guys next time.
Hopefully you'll have a verdict by then that you guys can discuss. That'd be good.
Yeah, that'll be nice. I think we'll be talking about Edgecomb and Cardi B. So
Alrighty.
fun trials.
Okay,
All
catch
right.
you later.
See ya.
Peace. So now it's down to just you and me, Andrew. Just us sitting here doing the Lord's work, standing on the walls, watching for the Mongol horde of a verdict to come.
Oh, the Mongol hordes were horrible.
So we can announce to the world that the verdict is coming. I'm kind of curious how close they'll get today, if they'll get it or not. We'll have to see.
I don't know. I'm really interested in Natalie's take. That'll be interesting.
Well, we'll see. We'll see.
If she cares to share it.
Yeah. Well, she may be sharing it tonight, right? Like on her stream, even if she doesn't share it here. Okay, let me hit some of these Odyssey chats. My generic channel sent tip thing. Thank you. Jason Ash says, in the same vein as Potter, a Jacksonville, North Carolina police officer who was playing airsoft with his son while wearing his service weapon pulled his gun and shot his son in the head. The son later died. Oh my God. Why? Oh, why are you carrying your service weapon while playing airsoft with your kid?
Yeah. So it's almost really a political decision. I mean, is that reckless? Oh my gosh. Yeah, it sure looks like reckless. Is anybody more sorrowful that the son died than the father? Probably not. I mean, it looks like it was completely unintentional. Do you put that father in jail for doing that? I don't know. I don't really have a personal opinion on it. I mean, I think it's really
that's a really really tough one. I've seen that style of argument before on the kids left in car argument.
Yep.
And I personally think you should
Very
prosecute
similar.
out the kids left in cars. I don't know how old this guy's kid was or anything, but man, what are you doing? What are you doing? Just don't. But see, that's a different category. The question is why he's wearing his service weapon, I think, becomes relevant. If he's wearing his service weapon, he's like on a break. Like I don't see how he's playing airsoft with his kid on such a short thing, on a short break. So why is his service weapon on him in the first place? Or why is any weapon on you in the first place while you're playing airsoft? That seems like a little bit different than Kim Potter, she's carrying a service weapon and a service taser for the purposes of being in the field.
And the problem came to her, right? So listen,
Right.
I'm a guy, I wear a gun every day. Every day, my entire little life. I'm wearing a gun right now. I wouldn't wrestle with my kids with my gun on me. I'd say, hey, you want to play around? Fine, let's do that. But I'm going to put my gun in a lockbox before I play with my kids.
Yeah. Yeah. I can't believe you're wearing a gun. Do you think I'm a threat to you? You think
Obviously,
I'm a deadly force threat?
It works over the internet.
I'll come through this fucking screen and get you. No, it's that's an awful story. And those things are hard to figure out. Like how much do you punish the parents? But you know, part of it is the state protecting the rights of the child, the right of the child to not die. And so you have to balance it out and make that decision. I don't know. That's a lot harder mistake argument for me, but it depends on the circumstances. If he's horsing around, horsing around doesn't sound like a good defense either. Yeah, I don't know how you deal with that. My generic channel says lawyer cosplay significantly less entertaining than I thought it would be. Defense counsel, I'm guessing. My generic channel says prosecution's rebuttal. The defense should have been strangled with his/their own birth cord. The state rests. My generic channel says, Joe, you're an idiot. RE defense team helping. He also says, but we all know where your thumb was, Nick. He says, I like Joe. Doesn't mean I won't give him shit. My generic channel also says there are no accidental discharges, only negligent ones. And he says, you want to talk sentencing? Okay. You want to talk culpability? No. Great US says public service announcement. Anyone supporting Nick's channel by being a member, keep mind out of the gutter and giving CCP loving anti-American YouTube 30%. It might be more beneficial and enjoyable if you pay sub on locals.com for the same price. Yep. I encourage people to use locals, preferably. Locals is my favorite go-to. Great US says other lost Monday comments. 1, Attorney Wisco, Milwaukee County courtrooms encased in bulletproof glass due to 2 previous incidents. 2, consider closing Gab, Minds, Discord, or others depending on site traffic or other interactions. Although on Gab, let you be yourself the most. Great US says $20.22 Monday tip message. Thanks for sincere customer service despite you Walking Dead tired Friday night stream. Had glitchy net and browser equals slow interaction. When saw you chat, tried to close other tabs to improve, but stream closed tab 2 and not see your other replies till you left. Okay. Herman Armenia says filled with emotions on both sides. Sees crying wife. Stop faking it, bitch. Nipple Salad says, I look forward to every SCOTUS ruling coming with a side of salt and snark when Nick is on it. My generic channel says, activist who is a lawyer, not a lawyer who is an activist. All out of bubblegum says, you should get this state lawyer on. He seems pretty based. We talked about this. The likelihood of him coming on the show would be very low because lawyers prosecutors who are focused on doing their jobs aren't usually focused on looking good in front of a camera. But maybe. Herman Armenia says, you don't just wake up and decide you're a murderer one day. You first have to be traumatized, like being invited to your neighbor's house for pool time and being mesmerized by the eldritch abomination Titty Roth and hypnotized to kill and eat your folks. Correct. You don't just wake up and choose eating. Okay, where were we on these YouTube chats? Again, we are currently on jury watch. So what I'm doing is I'm catching up on super chats because jury watch gets to be long and tedious. Let's see. Okay, here we go. I think here's actually exactly where we left off. Midnight Green says, does self-defense still apply when the defendant punched the victim while possessing a firearm? Wouldn't it fall apart due to provocation? Short answer, it would not fall apart due to provocation automatically. Punching someone can be provocation. In this case, provocation should be defeated legally by the withdrawal.
Right.
And possessing a firearm is not relevant to provocation unless the possession is both unlawful and provocative. Both of those things. So if you're brandishing a gun unlawfully, actually, That's an interesting thing in this case. He testified to brandishing of some sort, showing him the gun.
Well, was that brandishing unlawful? That's a different question, because was he apparently being threatened with deadly force at that point? He says he saw
True.
an object in his hand. I mean, it becomes an open question, but we have to distinguish between the different events. So the punch event, which is supposed to be the provocative event, the gun was not present. I mean, it was present, but it was not known to the lawyers. So you can't provoke someone with a deadly force threat they're not aware of.
Yeah, but it is kind of an interesting thing, because if the brandishing was not justified and was provocative, then it was also unlawful, and therefore it would fit provocation.
It's not usually how provocation works. Provocation is normally, go ahead, throw the first punch, and then when they throw the first punch, you use force against them. That's not really what happened here.
Jackson Graham says, per Judge Borowski, the media will be given a 20-minute warning prior to the reading of any potential verdict. Well, that's fine.
Warning. You got a 20-minute warning.
I'd be surprised if he gives a 20-minute warning if, let's say, that verdict comes in at 4:45. This guy's been out of court every day at 4:50. He's done. He does not want to sit around. But I think he would probably drag this out till 6 if it meant he didn't have to come in tomorrow, or didn't have to deal with this tomorrow. Flower Child, message retracted. K Rab says, if you have chronic pain, you can complain to medical boards and nothing happens. Doctors don't write because of risks to their license, period. If you're dosed properly, addiction is not an issue.
Okay.
Stephen Oglesby says that doctor, oh shit. I missed this one. EW says, Kratom saved my life, was addicted to painkillers for a decade. My life was destroyed by doctors. Found Kratom, and within a month I was clean and working 80-hour weeks. Kratom saved my life, and I thank God I found it. Yep. And again, my caution on Kratom is there are Kratom advocates out there who suggest that there is not an addictive property to it. And I would suggest that there is, based on experience with people that I know. But yeah, if it helped you get off of painkillers, that's great. And I would hope people would turn to alternatives that are far less dangerous like that, if that works for them. And yeah, Stephen Oglesby says that doctor's in Columbus, Ohio, and hasn't gone to trial yet. Tyler M says, I struggled with drug addiction for almost 20 years and am in active recovery still for 5+ years. I wouldn't wish it on my worst enemy. Love y'all. Michael Curie, thank you for the donation. Not applicable says, I love Ron Toye. He's the most entertaining F-slur. Thomas says, according to Dr. Drew, opioids should not be used to treat pain for more than 3 months. Going to ER for chronic long-term pain points to addiction. A crafty Huragok says, chat is always right. James Clint says, so what do we get with a head-covered Bronca? More reserved or more wild? Oh, that's in reference to your hat. So is this a more reserved or a more wild Bronca?
Probably more wild.
When you're entering the south side of Chicago, do you suggest wearing that hat straight on, or perhaps moving it slightly to the side, or anything like that? What do you have any legal advice on that one?
No legal advice. When I knew cops back in the day, they used to call these hats slap hats, because that's how hard you had to slap the person to get the hat to end up straight when their head came back.
Oh gosh. I hope someone screen capped you with that hat off to the side. KR, welcome to Paralegal Status. Flower Child says the problem with weed is how it affects motor skills. A large chunk of public transit jobs aren't being filled, and it's partly due to applicants not being clean. I understand medical usage though. Well, people shouldn't drive under basically any influences at all. But to me, that's not a justification for making something illegal. Robert Lombardo says the Honorable Judge Vince McMahon, because there is no chance in hell he's going to let the defense do that. Dennis Pettit says, at Bronca, Range Ear Pro, what do you like? Oh, ear protection at the gun range.
I have so many different headsets of Ear Pro. I don't even remember the name. Sorry, I've got a box full of them.
Bailey 7 says the Chewbacca defense. Lillian Shortimer says Teddy's going to get his degree finally. Great job, guys. Gonfall says Glocks can go off on their own. Let me tell you how. When the Glock is in your hand and your finger is not on the trigger, but your dream is in control, your gun will then have a mind of its own. Yes.
No, probably not.
Wait a minute. Are you contesting the dream Glock discharge theory?
Yeah, I am.
I can't believe this. Neighbor 605 says, does unintentional / involuntary self-defense exist?
No.
No. Again, no. What they were trying to do in this case was analogize this case to a Wisconsin case that involved a woman who made an intentional self-defense, allegedly intentional self-defense decision to point a gun but not fire it. And then subsequently, during a struggle that followed the brandishing of the gun in that case, the gun accidentally discharged. They're trying to
Two different things.
Yeah, those are two separate events that occur during this altercation. That is not actually like a negligent discharge self-defense. So there you go. Sonny Chris, welcome to Paralegal Status. Reagan Virostek says, as a junior and a juror and a layman, I would want the closing arguments to address each jury instruction point for point. Bought my first bottle of Lagavulin last night. Only 8-year was available. I'm just a noob. Hey, Lagavulin 8's good, but as a noob, it might be a little harsh. So prepare yourself. Lord Vader says, Andrew, fellow adventure motorcyclist here. What make headphones are you using? Do they provide hearing protection on the highway? Love the streams. You mentioned this earlier.
I did. I talked about it. They do provide good hearing protection on the highway. I like them. They are. Sorry, I don't remember the brand, but the admin posted it up earlier, so maybe he'll do so again.
See, Goody posted it before. Patrick Allen says B. Ivory is up to 47 Twitter followers. David Caggy says, my only confusion on what is the legally correct outcome is on the fact that he rode away. I think it would be more clear if he rode up and shot him instead of punching him. Jury could also think this. So it would have been more clear if he rode up and shot him. It would be first degree murder without much question at all. There would be no specter of self-defense if he just rolled up next to him on the bike and shot him through the window of his car. So yes, I agree that it would be more clear there. William Barnes says, you know that scene where the jury goes back to the juror room single file to deliberate and start coming back out before the last one makes it in?
Yes.
Harrison Klaus says, what are the odds the Innocence Project takes up his case after he's convicted? Guilty people who throw racism accusations are their primary clientele. The Innocence Project, don't they usually pick up much older cases, though? I
would imagine they will do whatever gets them the most funding.
Yeah, that's true. Kyle Guerrero says, when Edgecomb is convicted, what are the odds he flips his shit and drops the N-bomb? Low, I think. Usually people who are convicted remain rather calm.
Shocked.
They don't make a big scene. And remember that their life is gone right in front of them. Their life is destroyed. And their lawyers sitting there saying, hey, it'll be okay. You know, we're going to appeal this, blah, 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 blah. Or we got a good chance or whatever.
That check's still good, right? Check's still good.
Yeah. Yeah. I'm glad we got that retainer knocked out. Bass Mentier, thank you for the donation. Lord Vader says, thank you, Andrew, for answering the earbud question. Ride safe. Thank you for sharing your intellect, time, education, humor. Bass Mentier says, not guilty. Lawyer fucked around and found out. Shall not be infringed. Well, the interesting thing on Edgecomb is
would actually not apply to Edgecomb because he was unlawfully in possession of the weapon.
Yeah, his he forfeited his right temporarily to the gun. That's the thing. Some people think that maybe shouldn't be a thing, but that's the way it was for him. Synapse says Brazilian justice is much worse in most aspects. Still interesting to see. Jeremy Triguna says, I need this judge to count sheep while I'm trying to sleep. I'll be out like a light. Montel Williams says, B. Ivory Lamar's law firm got hella review bombed on Google. Bass Mentier says, Bassman Tier, maybe, says, not guilty. Lawyer fucked around and found out, shall not be infringed. Yes, I felt the same about Rittenhouse, shall not be infringed. Greetings from Croatia. We have no Second Amendment here. And again, to me, this isn't a Second Amendment issue. He does not have the privilege to carry a gun at this point because he is legally prohibited due to his prior behavior.
Not that it should matter anyway.
But it doesn't matter. That's not the basis for whether or not he has a self-defense claim or not. And he's actually not charged with illegal possession of a firearm in this case. He's not charged with that at all. He's charged with it somewhere else. He has a pending case there, but he's not charged with it for his possession here. So this case is just about, did he have the privilege to shoot Cleereman in the face? Kelly R says, Baltimore jury finds not guilty. No justice, no peace. Judge flings laptop. Lol. Sigkill says, if I'm a firearm manufacturer, could I sue any of these defendants in cases like this for claiming my product randomly fires?
No.
AML says, the strangest thing in your trials are the dramatic storytelling. Is acting and dramaturgy obligatory part of law school? No, it should be.
Yeah, it should be. Yeah.
Storytelling should 100% be part of law school, and it's not. Sage 5, welcome to Paralegal Status. Lightning Ninja 36 says, I thought they couldn't call him victim. No, that was the Rittenhouse case. Most courtrooms will allow you to call a deceased person a victim. That's I prefer Schrader's method in Rittenhouse. Most jury or most courts are not like that.
At least at the trial level. I mean, once you get to the appellate level, everyone's kind of a legal technician. They understand the difference. But when you're arguing in front of a jury, I would argue that the victim is too emotionally loaded a term to be appropriate to use before them.
Yeah. Right. Yes. Good caveat there. Patrick Allen says, do we know the jury makeup? Will this prosecutor get accused of white-splaining? Well, we know it's 6 white people, 6 people of color, and he said 3 or 4 of those being African-American. Don't know what the other people would be, or if it's 3 or 4. Very, very strange.
Not that it should matter, but
right. But unfortunately, today, that's a big part of the consideration. Sean Thomas says, good prosecutors like this really shine a light on corrupt ones like Binger, night and day.
Yep.
Monker002 says, in Kermit voice, he's a good boy. Didn't do nothing.
Okay.
Skeleton says, looks like the prosecution is going to be charged with murder because they are killing the defense in their entire case. I heart bald Gordon Freeman. Leaf Me says, a lot of racism and N-word shouting is just a normal Friday night, not a closing argument. Matt Hutchinson says, has any testimony supported the racial slurs being yelled at Edgecomb? Edgecomb's testimony, if you believe it,
for what it's worth,
that's the only place that that has come in. So, yeah. Whether you believe Edgecomb's testimony or not, that's where it is.
That the immigration attorney and his Filipino wife were hurling the N-word at him vocally a dozen or so times over the 3 minutes of their interaction, and nobody else heard any of that. Could be.
Oh, there's a jury question.
Oh,
there's a jury question apparently. So I have the court stream up. We'll see.
Can we make this a death penalty case?
Here's the court stream. We'll wait and see if let me know what the jury question says or if there's any reporting on it when it actually comes on. I have the court feed on, guys, and you'll hear it. If the audio from the court feed comes on, it's set to pipe straight through, even if it's not on the screen. So, Whale Ear says, B. Ivory starts with a quote, I too took comms 101. Name 530 says, I suspect Bronca of all people can commiserate on why I avoid MMJ, even though I could easily get my medical card. I refuse to lie on a 4473.
Yes, of course. Yeah.
Although that's an interesting question, right? Like, because
no, the feds will flag you for sure. If you have a medical marijuana card and they're aware of it, and a lot of states report it to the feds, then they'll flag you on the 4473. You won't be able to buy a gun.
That's wild. It shouldn't be that way, in my opinion. 'Cause
No.
if you have a medical card, you're legally
It's only
as far
state.
as
The card's only
state law.
state. So the
Yeah.
4473 is Fed. The federal prohibition is Fed.
That's yeah. The what needs to happen, the federal government needs to reclassify marijuana and take it away from a class A. A class A, I think it is, controlled substance. It just doesn't
Hey, Nick,
belong there.
can you
Yeah.
send me whatever link you're using for the courtroom video? Because I think I need to.
You're using the same one I am.
I don't know if I am.
Oh, okay.
But I think I might have. I mean, not your fault. I think I screwed it up.
How dare you? Well, the one you're sharing to me is the same, but I'm sending it to you anyway. It's this
Oh.
WISN feed. So, but I sent it to you again just in case on Twitter.
Thank you. I appreciate it.
Lee Nicholas says, at what point do we stop addressing the jury as ladies and gentlemen, not knowing which of the several dozen genders those jurors might be? Lol. Yeah, that'd be good. You can't even address them as people because some of them might be cats, for example. Jurors. You just call them jurors. That's what you do. Let's see. Roger G says, gotta go with the Chewbacca defense. Chris Cap says, if I were a juror. Oh, here we go.
Theodore Edgecomb, 20 CF 3535.
He called him in for it.
Grand shooter for the state.
Theodore Edgecomb appearing by attorney Nick Ahmad and the Ivory Lamar.
It's here on a jury question. A while ago, the jury sent out via the four-person, who's juror 4, the question. It says, hi, Judge, can we see the enhanced video when the shooting actually occurred, per the jurors? I'll hear from both sides. Mr. Hubner.
I believe they're requesting the enhanced video that was shown by the defense. I mean, there were 2 that were shown, but I think they're referring to just the last one.
Let's presume for the moment that that's what they're requesting. What's your position on that?
I have no problem them watching it. They want to watch it.
Mr. Ahmad, any objection to that?
No objection.
All right, I'll have the defense queue it up. As neither side's objecting, I'll allow that. I will say, however, that it's not going to be played repeatedly for the jury. This isn't.
Case law can be played once.
It's the opposite of
Case law,
Schroeder.
that's also my rule, because otherwise it turns into a trial over a video. There was at least 6 people, 4 potentially or arguably independent witnesses, all of whom testified. The defendant testified. Mrs. Cleereman testified.
Can you
That's
imagine
6
this in the
people
Rittenhouse
at
case?
the incident
Yeah, we've seen different arguments, haven't we?
that saw.
No, they can watch it as many times as they want.
If there's a case out there, great, but that's certainly my rule. These cases are not going to be situations in this or any case where I'm going to repeatedly play or allow a video to be played repeatedly for the jury while they're deliberating. This video and other unenhanced video was played. I can't even count how many times during this trial. I said multiple times. It was cumulative. Both sides belabored it too much. That's not going to occur. It'll be played once. Counts can make a record on the exhibit number and how long.
Right
it
call,
is.
by the
It's a
way.
minute,
Right call.
minute 35 or something like that. It's played start to finish. No commentary from anybody, including the court, and then they will be told to continue to deliberate.
So they're going to come back in the courtroom to watch it?
Her number is it?
Yep.
That's a right call.
Yeah,
That's
sorry,
the rule
exhibit number.
that they were arguing in Rittenhouse
25,
too.
It's 1 minute and 49 seconds long, and I think, Judge, the jury can be told if they want to look at the monitor and get out of their seats, they can.
What?
I don't want them parading around, but I'll move the monitor closer. to
Parading
the
around.
Monitor, or I'll have Mr. Hubner do it.
Like a bunch of Nancy's.
Since both sides are stipulating, if you can cue that up, counsel, I'll have my bailiff in a minute, go and get the jury in about 2 minutes. When you get that queued up, 2-minute recess.
Oh my goodness. So there we go. We'll get a jury viewing in just a minute of this
For a
video.
minute and a half.
And then they'll go back into their room. They're going to try and see if they see a lunge, and if
Right.
they
So
see
some
hand
jurors
raise,
are
I guess.
arguing to other jurors. I saw that video and I saw X, and the other jurors are saying, no, we didn't see that. Well, guess what? One viewing of a minute and a half video is not changing that.
Yep. So we could be looking at going into tomorrow on deliberations if they're
That would be
arguing over this. That'd be terrible. Chris Cap says, if I were a jury, I think I'd walk out right now. This was back during closing arguments of B. Ivory, I believe. Adam Riley says, he's got a weapon. Stop resisting. Bailiff, kneel on him. No. The Bud CJC says, Chewbacca defense confirmed. El Sar says, Edgecomb hasn't moved since the trial began. Scary. Chris Hoff says, did you notice prosecution laid the flipboard down in a manner still visible to jury through balance of closing, e.g. his guilty artwork? Thoughts?
I don't think he's that clever, but I would be impressed if I saw that. Be a good trick.
Yeah, if he did it intentionally, good job. Thoughts? I don't find his writing of guilty in marker on his thing overly prejudicial. I mean,
He's arguing for guilt.
Yeah. Tekadan says, summary of Edgecombe's story. Can you repeat that? 2012 James says, well, he did watch the Rittenhouse trial. Instead of a gun, though, it was a knife. It was bad was understatement, responsibility of murder. Goodest Goy says, B. Ivory is the high end of the black bell curve, which is a little bit offensive, I think. Nabor 605 says, is accidental self-defense a thing? We discussed this. No, not really. Eric Johnson, welcome to Paralegal Status. But let me be clear. Just because something isn't a thing does not mean you cannot try to make it a thing. You can make the legal argument. You can try and develop it into a thing. That's something you can certainly attempt to do. So that is what you can do, but generally speaking, it is not a thing. In Fantasy I Die says, hey, Nick and panel, male fashion question. I work in an office environment, no suits. Any rules for matching and color coordination of shirts and pants? Thanks for covering these trials. I mean, just try and look good within the dress code. I don't know. If you look at yourself and think, I look retarded, don't go to work like that. But other than that, I don't have fashion advice for anybody. Bearded Wonder says, are we sure Edgecomb isn't just Alec Baldwin in blackface? Not quite. Ultra 65 says, thanks for legal MST 3K. Lots of fun. Gonfall says, brother is black. He insint. Mutant Bamhammer says, that Get Hard guy on the panel is Titus Welliver, star of the original Amazon series Bosch. Changed my mind. I didn't watch Bosch.
It's true. It's me.
Casey Moody says, Cleereman was visiting the Haldersons at the cabin. Edgecomb was hired by Canabro to get rid of his parents. Edgecomb was just cleaning up a witness. That's the likely outcome. No Name says, judge joked about food poisoning yesterday. So ... Yes, we had a juror pass out feel not well. Josh Vermillion says, he's so happy he gets to tell his make-believe story with no evidence to support it. Think he knows how ridiculous people think he is or cares. I think there's a lot of people who don't think B. Ivory Lamar is ridiculous. They don't think his story is ridiculous at all. That's what's crazy to me, because to me, it looks ridiculous and I don't see any evidence to support it, but somebody does. Some people out there, you can find them on Twitter.
Everywhere.
Let's see. Gene Angry Penguin says, ladies and gentlemen of the jury, he did that shit. JK Wynn says, B. Ivory in Training Day, drag queen story hour, got nothing on me, judge. I doubt it. B. Ivory says, well, take your swing. And Binger says, wait for me, I'll help. The Islander says, are we sure that the defense is not just Binger and Krause in blackface? I mean, we'd know if it was Krause.
Binger and Krause are better.
MH makes, thank you. Dr. Bunter Hayden says, thoughts, SCOTUS Justice Stephen Breyer retiring. talking about this. Apparently, the new rumor is that he did not intend to announce his retirement today, and he's mad about it. Scott Shook says, Nick, you misunderstood. The prosecution left the big notepad visible to the jury during the defense closing. I don't see what the relevance of that is, or how that.
It's a grainy video, and we're concerned about the distance.
Hang on, we're on the record. Everybody use the mic.
Wait a
please.
minute. Now they're going to complain about the graininess of their own video.
Go ahead.
We just want to request that the TV be placed closer to the jury box. We also want to put on the record, we understand that the court is inclined to show the video once. Obviously, this is a grainy video. It's the moment in which they're
It's your
requesting
video.
happens very quickly. So we understand the court's position to show it once. We will do one like to preserve our objection as to the amount of times that the video be shown, and also request that the TV be moved closer so that the jurors can at least appreciate what they're seeing.
This
We would
court
like to
reporter
preserve
is
the objection
terrible.
as to the amount of times that the video be shown.
Yeah, of course.
The video
They want the jury to imagineer.
is requesting happens quickly, and we believe that the jury should be able to see the video evidence.
Jury's
as
still
many
not in the
times
courtroom,
as
guys.
Necessary. In addition of that, we would also request that the TV screen be moved closer to the jury box to ensure that all jurors have the same.
The judge seems so amenable.
Video. Thank you.
Mr. Hubner, be brief, please.
Well, first of all,
Yeah. Somebody, if you guys don't use the mic,
Judge, I'm
seriously,
really close to
I'm
the
gonna
mic.
sicker on both you guys, really.
That's okay. Judge, I guess I can move the computer, but I have to be able to see also what's being shown here. If I moved it, this is the closest it's ever been to the jury.
Right. If it gets much closer, then some jurors are gonna have a very bad angle. You can move it another foot or two closer, probably 8 to 10 feet from the front of the jury box. It's
One out of these two.
right. Fine. It's fine where it is. It's direct. Hang on.
We're not able to see the video. Attorney Hubner is stating his positioning to be able to see it, but we're not.
Assuming it's gonna be on both screens.
You're running it from your machine.
We don't have the same view of the jury, but I just want to put it on the record.
If you let me run it, then I got no problem, because then I can see it. But
Okay,
right now, I
enough.
can't see anything.
The defense
Enough.
is running it. It's on the screen.
Don't
in
make
front of
me
the
stop
defense.
this car.
Behind the defense, which you're 2 feet away from. The jury, it'll be in front of the jury. I'm playing it once, period. The jury's gonna hear it's being played once, start to finish. No commentary, no stopping, nothing.
Period.
It's over by the wall so I
Stand
can
to
see
see it, yes. And if the defense wants to move and stand next to Mr. Hubner and you guys all want to be buddies to watch this, that's just great. Let's bring the jury in.
This judge, he's so tired. He's tired of this shit. He didn't want any circus bullshit in his court. He knew it was going to come.
It's
He's-
Wednesday.
He's like, this should have been done by Friday. This guy should have been locked up already and eating shitty court meals with everybody else. Can't believe we're still here. He has no chill for any of this nonsense. Joshua Bergen says, see where Supreme Court Justice Stephen Breyer is retiring and Biden promised to elect a black woman. Only what the chat has said about it. Shockingly, I'm on a show, so I'm not looking that up live. Kevin Zulik says, did you notice the prosecutor got the trash can, but B. Ivory just stayed there? Does this play a role with the jury?
No.
Anything could or couldn't play a role with the jury. Their shirts, man, could play a role. It's impossible to know. It's impossible to know. But I doubt it. Matthew Vicari says the defense closing has been entertaining so far. I didn't quite understand what the objection was that got the judge so pissed off. It was hilarious, though.
All right, the jury's coming in. You can remain seated, please.
What was that objection during the close? It was, do you remember?
No. Sorry about the chips, folks. I just got hungry.
Oh, how dare you get hungry? We've been live for 7 hours.
I'll try to remember to pause the audio during the chip munching.
I'm trying to remember what the objection was.
All right, the jury's back in the box. I received your question from the 4-person juror 4.
Oh, he brought up the
The
Waukesha
lawyers have
driving
queued
thing.
up
Was
the
that it?
video. It's the enhanced video.
No, that
There
was
a defense
prior.
exhibit.
That was
It's
that
going
was
to be played.
during
It's going to be
instructions.
played one time. No one is going to comment on it. It's going to be played start to finish. Then we're done. And you go back to continue to deliberate.
So pointless
Go
for the
ahead.
defense.
Oh, is what Ivory said, that he had developed a relationship with his client, was he was testifying to his client's character based on their conversations. Okay, the jury's watching this now.
He felt the heat of the engine.
Not that he had a duty to, but man, he easily could have walked down those steps. He stopped and waited at those steps for several seconds while this guy trotted up to him. I didn't notice how long it was until watching this video just now. Because it's not like that guy was right on his back. They're under no, you're under no duty to retreat in the state of Wisconsin unless you assume the duty due to provocation and blah, 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 blah. However, the jury can consider your lack of retreat to be unreasonable. Not that you have a duty to do so, but that your remaining in place is an unreasonable act. They can determine that if they so choose. I mean, man, looking at this video, he's there for 5-6 seconds while that guy is walking up.
All right, if you can all retire to the jury room and continue deliberations. Thank you.
That's all you get.
Going to watch it one time. That's going to be it. I'm not going to hear anything else about it. I hate this already. I hate all of you. I hope all of you catch gonorrhea.
I'm actually eating my kids' school snacks, folks. So yes, they will be angry with me about that.
45. Thank you.
This is a lawyer on hard times. He's eating the kids' school snacks. Oh my goodness. So there we go. That's it. We're back to deliberations. I wonder if that solved the jury's problem. Are we going to get another jury question immediately? Can we watch it again, Judge?
It does make you wonder what question came up in deliberations that's the video they needed to see uninterrupted once. What's that going to settle?
I have no idea. Well, you know what? That video changed my personal perspective on this viewing, actually, because I had not paid attention to how long it is between the time that he gets to that stairway and Mr. Cleereman catches up to him. And it's a lot longer than I remember. So I don't know, I can't say what other jurors are going to see from that. But for me, like, that more solidifies, I think, an unreasonable level of action based on his testimony. Again, in a vacuum, you can't assume anything about his stopping there. But his whole thing that he was feeling in threat for his life from the moment he's up on the curb.
He was hunted down.
I mean, if he has enough time to get down those stairs, probably before that guy even reaches the stairs, get on his bike and ride off. And that guy will have no chance to catch him by the time he's on that bike. There's no way. So, I mean, to me, that goes towards unreasonableness, in my opinion. I'm not saying that jurors will find that or even see it. That's just what I happen to see. But I've watched this video, a few times leading up to the trial, not not the enhanced video, but the other trial, the other stuff, and then watched it during the trial as well. So
Ironically, I wonder whether or not Jason Clearborn or Cleereman would have been a better criminal defense attorney for this client.
He'll come back from the grave, like offended at the bad lawyering going on. He'll come back and be like, I can do it for you. He didn't kill me. It was in self-defense.
Luke.
Oh yeah. So going back to that though, where the judge got really, really angry. Thanks to the chat for helping remind us of what happened. But B. Ivory Lamar was trying to rehabilitate the bad testimony of Theodore Edgecomb and the evasive testimony he had on defense. And what he said was that, well, he was not comfortable with the state's attorneys because he doesn't know them. But with me, he's more comfortable. When he first came to my office, he told me, and that's where the state objects and says, Your Honor, come on. He's going to testify to what his client told him off the record outside of this court. Yeah. And he's going to do that. And then that's wholly improper. And
hey, did B. Ivory just make himself a witness? Cross-examine him now?
He may, I mean, if we got nitpicky and technical on it, he may have defeated attorney-client privilege for that conversation that he had with him as well. I mean, you don't get to just
say, volunteering what the client told him, right?
Yeah, you do not get to assert attorney-client privilege and hide behind it after you tell the world what your client told you. Now,
that's not how that works, right?
The extent of how far the door is opened.
You don't get to you don't get to tell the half that's favorable to you and hide the other half,
right? But obviously, this is just purely an academic exercise. The state isn't interested in pursuing it. But it just goes to show how, they talked about how Edgecomb is sitting there and one wrong answer can sink can send him to prison, which
there were a lot of wrong answers,
which is a stupid line. But one wrong statement by an attorney can do a ton of damage as well. And in a different type of case or with a different prosecutor. I mean, imagine if Binger was the prosecutor of this guy going at him the same way he went after Rittenhouse. Imagine Mark Richards said, Your Honor, when my client first came to our office and he started talking to me about that night, here's what he said. Like immediately Binger's going to be like
all over that, and appropriately so.
Yeah. We want the notes. We want the notes of what he said. We want to know. We're going to cross-examine you on what he said. And you can always enter an adverse party statement or a statement that is adverse to the party's interests. So the party in this case being Theodore Edgecomb as defendant, any statement that he makes, hearsay or not, someone can come in and said, he said this and it's opposed to his interest. That comes in. There's no hearsay objections. Says, oh, you can't bring that. That statement is in there. Anyone can testify to that. The question is, do you believe their testimony or not? So in this case, they could easily just sit down and put B. Ivory Lamar on the stand and have him testify to exactly what was said. And if he refused to cooperate, it would look really bad for the jury. Or there could be, potential sanctions involved. Again, an academic exercise because it didn't happen here. But imagine if you have a real nasty bastard of a prosecutor, and some of them are pretty mean. They will do this. Some of them will do it. So, yeah. Again, think about how they went after Kim Potter and her discussions with the doctor, right? Like they went after the notes of the conversations that she had with the doctor. She's supposed to have some level of patient confidentiality, but that was not a big hurdle for them to overcome. And they got notes of her statements in, not even her statements. They got the notes in. Something like this would have played very, very different. But yeah, the judge shut that down really quickly. Matt Hagan says, if you Google S plugs, make sure to have safe search on. Oh, stop it.
Okay.
Steve Animatrix says, Andrew, I missed the link. Is it lawofselfdefense.com/get plugged?
Well,
Blank
you
name.
could try it. I don't know what'll come up, but
The blank name says younger, white, female. Ree! Gaius Nautius Caesar says conspiracy. The defense tampered with the food and gave an unfavorable jury member food poisoning. Blue-eyed Roof Curry in the base says, are there any states that prohibit pricing according to political affiliation? I've been making a killing in plumbing, triple charging Democrats in Massachusetts. California's civil rights law. I think it might be called their human rights law, but their human rights law or their civil rights law actually does have political opinion discrimination built in to it. So you would not want to do anything like that in California. As far as other states go, I'm not aware of any other that purport to protect political opinions, and I'm not aware of any consequences for increasing price based on something like that. However, you got to be careful on the product. If the product is necessary, price gouging rules can kick in and stuff like that. You got to be very careful.
I can tell you personally, I wouldn't charge anybody any different because of their political leanings. I'm just expensive, period.
There you go. Jeff 4423 says, if he really had training, he would have put a few center mass to make sure the threat was stopped. Well, maybe, but unfortunately he testified to training and the prosecutor got to use it in the way he wanted to, which is put a bullet in the head, as he was trained on the knowledge that would kill, I think is the more appropriate thing that he's going for. Snowboard Dan says, speak in jive, see if that works well. Next.
And by the way, folks, you don't know what training he got. A lot of training sucks. So just because that's a training you got doesn't mean that's a training he got. Just because that's what the training should be doesn't mean that's what he got.
The reality is he probably sat down for a multi-hour class.
And they all suck.
Yeah, and then he went out for 20 minutes of range time where
maybe
they said, here you go, fire these, and an instructor will walk by and look at you shoot a couple rounds into the target, and then you'll go on your way. At mine, there was someone who did not pass on their first couple attempts at shooting, and they had to get some coaching from the person. Their accuracy still was not great. And the bar was low. I mean, I passed it.
So I can tell you, when I moved from Massachusetts to Colorado, I did my concealed carry permit thing here. And it turned out I could have waived the requirements because I'm an NRA instructor and other nonsense, but I didn't know. So I did the whole class. And when it came to the shooting portion, they had a full body silhouette in the range. And they had us run it out all the way to 3 feet. 3 feet from the firing line. I thought I was going to set that target on fire just with the muzzle blast. So I fired my shots, whatever they were, 10, 20, 30, I forget how many. I made a big hole. And then I looked at the guy next to me. He fired 30 shots, and there were not 30 holes in that piece of paper. 3 feet in front of him, body size. So when I suggest I don't have 100% respect for a lot of these CCW classes and what they train, that's why.
How do you miss something 3 feet away? That's just your arm.
Good question.
It's like when I go to like a Chuck E. Cheese or whatever with my kid, and they have this one game where you're supposed to throw ping pong balls into different farther and farther away things. And the farther you throw, the bigger the ticket prize is. But it's like, I can just hold onto the edge and hold my hand over and just drop them into the farthest one. Yeah. That doesn't seem fair to me.
You mean like a pedophile would do, like that?
No, I don't think a pedophile would be dropping ping pong balls into a clown machine, but maybe, I guess, if they were trying to lure kids in with
I don't know. You're on a Chuck E. Cheese. Doesn't look good.
I have 5 children. Sometimes you end up in a Chuck E. Cheese.
Give B. Ivory those facts, and you're convicted.
I'm never taking my kids to Chuck E. Cheese ever again. Jesus. Bronco would be that prosecutor right there. He's like, oh, let's
at Chuck E. Cheese. He had to know.
Let's check what he said to his attorney and how many times he admitted to being a pedophile.
Intentional disregard of risk.
It's a Laughing Man 2024 says, have a couple bucks on me. Thank you. A bear in the woods says Cleereman and Edgecomb deserve a full investigation, like our expert gave. Joe Everyman says Ivory is going to have to be removed on a stretcher after he pulls every muscle in his body after this reach.
B. Ivory will probably make $500 million in his career. I'm sure he'll be just fine.
Yeah, it's going to be. Ugh. Charlie Eckert says, thanks for the great analysis. Alita, say hi to Puppy Bites for me. Kyle Bogue says, law of self-defense. My kids ate my last 2 donuts the other day before I got up. I ate all their fruit snacks and put the empty wrappers in their lunch boxes. Don't mess with dad ever. Dads always get even, and rightly so. Oh, I hate when my kids eat the last like cookie or something. It's like, oh, you get hungry at like 2 a.m. You're like, oh, I'm going to go have, I know there's like 2 Nutter Butters left, and you get it there. It's just an empty bag or the empty box. And you're like,
man. So yesterday I went in our pantry
I'm
and
now
there was like
pro-choice.
10 boxes of Cheerios in there. They're all open. Every box has 2 Cheerios in it.
yes.
2. And the kid's like, there's no Cheerios for breakfast. And I'm like, well, I won't say it here because it would involve profanity. And I'm like,
You can use profanity here.
are you shitting me, you motherfuckers? There's 10 boxes of goddamn Cheerios in there. They're all fucking empty. I didn't eat them. You ate them.
I know.
But they're 6 years old, so it was appropriate language.
Yeah,
for
no,
the
I get it.
demographic.
For me, what my kids do is they'll go through and get like a thing of Lucky Charms, and I'll go look at the shopping list, and it's like a box of Lucky Charms on the shopping list. I'm like, okay. I'll go in the pantry, and there's a full fucking container of Lucky Charms with no marshmallows in it. I'm like, what the hell is this? You eat that. You
That's
eat
a
that
capital
garbage.
offense right there.
I hate marshmallow cereal, so I don't particularly care about the cereal itself being gone, but it's just the audacity of, Dad, you need to buy more Lucky Charms. Like, no, I don't. You need to eat the ones you have. Japanese kids are starving. You're sitting here eating marshmallows. Brandon Lesko says, just to waste $20. The last juror that got on, close friend of 40 years, is an immigration attorney. Defense did not want her on the panel. One who passed out reported feeling drowsy/woozy. Judge asked her to raise hand if sleepy.
Okay.
Oh, there you go. So you have notes on these people? You must have watched voir dire. God, watching voir dire is, that Potter voir dire was so long. It was brutal. Oh, goodness. Okay. Derna 1804 says it was a mistake for the defense to remind the jury of Officer Egon because he's Pontifex Mechanicus Bicyclist. Ranjikar Patel says, forgive me, my dear, my English no strong. Why old turtle talk for have erection so many
I guess
times?
that's me. Yeah.
India, we say get hard only for dirty film. Vishnu blesses you, dear.
It's a dirty book.
There you go.
Criminal law. It's always dirty.
Let's see. Ponton 21 says a knife is a tool until it is used as a weapon. Everything's a tool until it's used as a weapon. Nukes are a tool until they're used as a weapon.
Everything is a weapon until it's used as a tool. Look,
Nuclear bombs are excellent excavators. I'm just saying, if you need a large area excavated, they're very, very good at it. Cameron Nelson says, when a black person says cold-blooded, he really means he shot that N-word in the face. Oh my goodness. Make a Wish says, does the court stenographer correct speech such as asked to asked? Yes. Yes, they do. Jason Ellenberg says, I am totally waiting for him to bring up Chewbacca in the closing argument. Roger G says, the puppy that was at his house was never tested. Forgives 12 says, 100% guilty verdict due to insanely awful, just disgraceful closing to the defense. Ponton 21 says, Luminol Man knows where the F is Luminol Man. Contrarian 420 says 100% chance Officer Paralegal Ashley drafted a press release for the great decision of innocent and MAGA country racist court. If guilty. Wolfgang Deo said clowns in the senior living center, White House. Pie is God says he should have put a monkey on a typewriter. It would have written a better closing. Kyle Bogue says B. Ivory Lamar went to the law school equivalent of the medical school that Dr. Nick Riviera went to in The Simpsons. I was when I was taking the bar, surrounded by a bunch of people that did that. There are unaccredited law schools in Minnesota that you can go to and take the bar. Their pass rate, like these people, so many of them were on their third and fourth bar takings, and their pass rate was abysmal.
No, I've actually spoken as a speaker at law schools that like 2 years later were closed down because literally like 0% of the student body could pass the bar exam. And now that of course they're advocating to get rid of the bar exam. And listen, I'm actually not in favor of most government licensing for people to do stuff, but jeepers, folks, if your lawyer couldn't pass the bar exam or took him 8 times or whatever, maybe you don't want him representing you and on a criminal offense. I mean, just a suggestion. It's not that hard. I mean, it ought.
The bar exam,
I guess.
The bar exam. Look, some people don't test well or whatever. I test well. I test pretty easy. I passed the bar exam on my first try. I missed a whole lot of the study time because I wasn't paying attention to when it started. I thought I had time between law school ending and Barbary classes starting. So I missed the first several weeks because I was just chilling out. It's like, oh God, I'm so glad to not be in school anymore. And then I had to play catch up on Barbary. So I was sitting there furiously, doing the makeup and trying to get through it and taking the practice test. That being said, the bar is merely about collecting, assimilating, and synthesizing as much data as possible in a short amount of time.
Which is kind of what you do in a case.
Exactly what you do. I don't think the bar is an ultimate indicator of who will be a good or bad lawyer. Some people fail the bar a couple times and come out and be great lawyers. Some people pass right away and are terrible lawyers, but it is an indicator, and it's one that's worked for quite a while. I think getting rid of the requirement, we graduate so many JDs every year that if all of them are suddenly bar licensed attorneys,
it's like, a JD just meant you sat there.
Yeah.
That's all that means. You sat through the 3 years. It doesn't mean you know how to argue the law.
Yeah, I would. Yeah, I don't like the idea personally. I'm pro some sort of standard. Steve-O Halaz says if the White Claw wasn't tested, Mr. Edgecomb shouldn't be arrested. That'd be good. Dennis Pettit says, is closing the best practice in finding truth or justice, or a legitimate effort to mischaracterize facts or testimony to promote a false narrative? Well, I think
the closing is where they're supposed to stitch it all together, stitch all the evidence together into what their narrative for the jury is. And then it's up to the jury to decide whether they believe that or not.
Yeah, I think what's interesting is it's what you did was a mischaracterization of closing arguments in that chat. But the basic is you get to tell your narrative. You get to say, here are the facts. Here's the story that we believe based on the facts. Do you believe it? If you do, vote our way. If you don't, go the other way. I mean, that's ostensibly what closing argument is. But it's not necessarily a false narrative. It's a narrative that can be derived from the facts. And if it deviates from the facts, if your narrative deviates, the other side has the opportunity. They didn't cut it, did they? Okay. They have the opportunity to disagree. I got a sandwich.
You're saying your woman made you a sandwich?
I don't know. She doesn't work at Jimmy John's, so I don't think she made it, but they might have let her in. Did they let you in to make the sandwich? Oh, no, she just did the drive-through.
Okay.
But yes, I got the giant Jimmy John sandwich, which I'm very much looking forward to. Since now, all the food.
Oh my God. That's like 4 inches.
Yes. This is a 4-inch knife. Here we go. But since this stupid COVID shit, all of my anything cooked is like suspect. I had just grilled chicken breast last night. It tastes terrible. So now like everything I have to eat has to be basically uncooked. Well, and boiled eggs work. Boiled eggs are good. Okay. Name 530 says, quote, she could have kept driving straight. How is that any different than she shouldn't have been wearing that skirt?
Yeah, it's not that much different.
Yeah. Royal Wolf 7 says, stop in the name of race before you shoot my face. Think it over. Oh God. Frederick Little. I read that one. Did you send a message to one of the moderators or whatever? Mandalore Wise 01 says, how much longer does this incompetent activist have before the judge tells him to shut up and sit down? He had 90 minutes. I mean, that was the deal. And he used a good deal of it. William no, he went over, right? Did he go over a couple minutes?
I'm not sure, actually. There was the interruption and then they came back and
yeah, I think someone in the chat, he gave him a 15-minute warning, and he got close to that 15 minutes if he didn't exceed it. He was close.
Yeah.
But nothing egregious. If it was over 90 minutes, it was probably 93 to 95, which who cares? William Leverett, message retracted. Wayne Smith, no message at all. Alec Matsumoto says B. Ivory got his law degree out of a Cracker Jack box. Wayne Smith says, did Edgecomb have a reasonable escape route away from the victim? Because that was hotly contested during the Rittenhouse trial between the cars. Reasonableness is a fact question for the jury. He did have an escape route going down the steps.
He was waiting there for Cleereman to come up to him. So there was no one behind him. There was nothing to stop him. If you're saying he couldn't go down the stairs with his bicycle, that's not a rational response because he doesn't have a legal duty to protect his bicycle. I mean, as opposed to balanced against shooting someone in the face. So it looked to me like he had a possibility of retreat.
Yeah, he seemed to have a reasonable the question, does he have a duty to retreat, is a different question. He doesn't have a duty to retreat. But again, as discussed a little bit ago, the jury can determine that his refusal to proceed on was unreasonable and therefore negate self-defense, because self-defense has to be reasonable. So if they are saying that he's waiting and inviting or setting a trap or laying in wait for someone, then they go, this isn't really reasonable self-defense. If he's trying to truly defend himself, going down the steps and getting on the bike is his best option. They can determine that. Steven says, Andrew, would you rather, and real quick, the reason it was so hotly contested in the Rittenhouse trial is because they were arguing over the provocation that the state brought in at the last minute with the raising of the gun towards Zeminski that allegedly triggered the response from Rosenbaum. So that suddenly became an argument that they had to make as to whether or not.
Again, folks, when you have a year and a half or 2 years preparation for trial and suddenly a new legal theory appears in the midst of a 2-week trial, that itself looks sketchy as F, right?
Yes. Oh, I thought there was more. No, yeah, you're correct.
No, there's 2 feet more, Nick. You got it in your hands right there.
Steven says, Andrew, would far rather Harvard admissions go, or would you rather Harvard admissions go to American blacks than Asians who would literally infiltrate U.S. politics on behalf of the Chinese state?
Okay. The Asians being excluded from Harvard are American citizens, by and large. So your point is moot.
Next, Dan Reeder says, there is no middle lane on that street. It is a wide lane to allow parking, and there is no lane driver at the intersection. Check Google Street View. Yeah, the whole middle lane thing, again, is another part of this case that they're focusing on weirdly that doesn't matter to me. I liked what they went through the video and showed that everybody made the turn from the middle because there isn't a technical right lane. However, I will note that many residential streets are actually considered 4-lane unmarked streets because they have enough for 2 car widths on either side of the marked lane. And they consider that a 4-lane road. If you remember your driver's training, or if you've taken it, some of you may not.
And for the rest, folks, listen, I don't care what someone's race is or gender is. If I need excellence in whatever I need, legal representation, medical care, real estate agent, auto mechanic, I don't care who they are. I care what their level of excellence is. I want the best that I'm able to access, regardless of their race, creed, gender. That makes no difference to me.
What about a bicycle mechanic?
Same. Although that really geeky white cop looked pretty promising.
Look, I think I would let him tune up my bike. That's all I'm saying. I trust him more than I trust me. DCV Titan says, no, knife was right front, wallet was right rear. Correct. Fly Fox Pro says, B. Ivory is a criminal defense equivalent of the That's Racist kid. Moose and Squirrel says, not guilty. The defense is using language and concepts, institutional racism, cops are unfair, that some members of the jury know to be true. Maybe it'll work on them. Automata says, so does this one thing to remember, guys. The judge said that this is the most diverse jury he's ever seen. But remember that for all of the narrative about how the jury is unlikely to convict or whatever, the contravailing narrative is brought up by the defense. Wisconsin has the single highest rate of the incarceration of blacks versus whites. It's the highest ratio. It's the highest ratio in the country. Wisconsin is the literal worst state. So for all of the woke
worst state
for the ratio.
Okay.
So the most blacks per whites incarcerated in Wisconsin than anywhere else in the nation.
If you're presuming they're unlawfully incarcerated, I guess worst would be the appropriate term.
I'm saying from the framing of the defense, that's what they said. It has they said the highest mass black incarceration rate. I think is the predominant. I looked this up yesterday and I was blown away by the state chart. Do you want to see it?
No, I would just suggest that maybe the state's just incarcerating people who are committing violent crimes, and a certain percentage of them happen to be black.
I thought the chart was hilarious because it runs a counter narrative to the traditional notion of race relations in this country, which is very funny to me. Apparently the lowest incarceration rates are in the deep Southeast for African Americans versus whites.
That does not surprise me at all. Actually.
Not me either, but I think it would surprise basically everybody who watches MSNBC. But anyway,
one of the weird idiosyncrasies in American life is, based on my experience, the years I lived in the South, was we have this presumption that because we had a civil war in the South, were the slave states, and the North were the free states, that surely racism must be a bigger problem in the South than it is in the North. And that's not been my experience at all. In my experience, the Southern states, white and black folks get together, get along way better than they do in the northern states, especially the northeastern states.
I agree. But anyway, so while the one narrative is that the woke people will quote unquote let off the black defendants or whatever, at the same time, the same demographics that are actually at play in Milwaukee convicting people are regularly convicting African American defendants. So I don't know that that logic bears out personally. That's the point I was making there. I think we discredit now this special case because it's got some publicity, but we discredit jurors generally in saying that they're automatically motivated by all this stuff.
And folks, I'm sorry, Nick. I'm
go ahead.
I'm not here to relitigate the Civil War. I'm sorry, so don't bother with those comments. I'm talking about my modern day experience living in the South. That's all.
I'm here to relitigate the Civil War. Texas v. White. Let's redo it. The Texas secession was not illegal. They're going to split into 4 states and take over the Electoral College. Treaty of Guadalupe. Sorry. Automata says, so does this gentleman accept, quote, maybe there was something in his hand as in lethal force justification for police use of force? Oh, we just had some movement on the camera here. I don't know what. Cameraman practicing. I wonder, is there an announcement? Do we have an announcement of a verdict, guys? I don't know why the cameraman is practicing his focusing and zooming. Ghost Nasty says, Civil War ain't over. It's just halftime. Okay, we don't have a verdict yet. The cameraman was was panning around. I saw two cops standing next to each other for just a second talking.
Nipple rubbing.
The one was got these pepperoni nipples. Automata says, so does this gentleman accept, quote, maybe there was something in his hand as in itself a lethal force justification for police use of force? Of course, that would not be acceptable. Now, remember, B. Ivory Lamar represented Jacob Blake, I don't think in a criminal aspect, but in a civil capacity. Jacob Blake fought with cops and had a knife. And he says that the shooting, as he's getting into the car that he did not have permission to get into with the children that he did not have permission or legal authority to take, was not justified.
It's difficult to have conversations of merit with people of limited intelligence, but when a cop is having that discussion about a suspect, the cop has a legal license to be the aggressor in the use of force in that confrontation. He's making a lawful arrest or a lawful stop. That other person is legally obliged to comply with those officers' orders. If the officer tells them, keep your hands down, keep them out of your pockets, don't point shit at me, and the person does it, that's a different circumstance than what we're dealing with here. And if you can't understand that, you should contribute to Nick Ricardo Law with a monthly membership, whatever, paralegal, and you'll learn more about that.
And watch every day. Isaac Bowles says, he asked if he couldn't brief and he told the truth.
That's so wrong.
These chats are terrible. Luke Pearson says, instead of the death penalty, the judge serves them the cafeteria food at sentencing. All right. You got two choices. If you're not guilty, you get the baked potato.
Like a wish, safe. We're going to throw you in the river. If you float, you're guilty. If you sink, we'll pardon you.
Barry Dworak says, I feel dumber after hearing the defense's closing. Beth Lance says, you boys talking about what is going is the only reason hubby and I watch. Keep talking. Oh, thanks, Beth. Andy Solis says, is this the mostly peaceful defense? Dark Jack 337 says, this is the first trial I've seen on your channel where the prosecutor actually could stand up and say everything that guy said is bullshit. Contingency plan says he didn't shout no witnesses, whip out a minigun and slaughter everybody on the street. Therefore, my client isn't cold-blooded. See?
Pretty much.
I love that. Well, it was only one shot. It was only one death. Couldn't have been cold-blooded. When have you ever heard of a cold-blooded killer killing someone once? Bjorn in 1979 says the burden of proof poster is strategically placed to block the jury's view of the judge's disgust and frustration with his clown defense lawyer. Cynthia Cotney says, in the words of Krauss, he brought a gun to a fist fight. And he kind of did. I don't know. How did you like the fist fight narrative? I don't know that he started a fist fight. To me, it was more, it was a sucker punch.
I mean, it's what you expect. Of course, it wasn't a fist fight. They weren't squared up against each other.
Fucking
Great,
battery.
Nick.
You know what?
I don't even know why I come to this joint. I'm out. I'm out. Forget it.
Yeah. You leave. I'll be fine. I'll do this on my own.
Of course, it wasn't just a fist fight. He was sucker punched in his car. The whole point is ridiculous. But those are the kinds of arguments you expect that the counsel will make. It's fine. I don't find that offensive. They're not making shit up. They're just characterizing the facts in the way most favorable to their client. That's what you're supposed to do as a lawyer. But none of it justifies shooting somebody in the face.
No, I agree. I wasn't. I mean,
I like that beard, Nick.
Thanks. It's good. Don't worry.
Familiar somehow.
Someone else's beard.
liminal plus crime.
This beard smells weird though. I'm just gonna say it. It's got a funk to it that's surprising.
Oh, there goes my reputation. I was so hoping to preserve it here on Ricardo Law.
Are mutuals going to be up in arms?
All my corporate sponsors are going to cut me off now.
Nabor 605 says Kyle Rittenhouse quote Edgecomb isn't guilty. He also says, as He-Man once said, I have the power. Ghost of Aces says, I truly believe he shot the victim in the face out of his own deep-seated hatred for white people. The racist is the one who shot a man in the face. Could be. I don't see any evidence of that particularly, but everything's possible.
In a
JK
just
Wentz-
world, we'd have a SNL skit where Kyle Rittenhouse was teaching Theodore Edgecomb how to cry on the stand.
That'd be so
No, man, you got to
good.
make your face look like this.
Or
You gotta-
this.
right?
Get your arms up. Get your arms up when you do it. That's what you got to do. It'll play better for. They raked me over the coals, but they'll love you with this look. I trust me. You know, but in a world where SNL was honest again. I am nobody says Nick spends $3,000 on some headphones, but won't buy $100 power cable. The worst part is I bought the power cable. It's the wrong one. It's the wrong one, and now I have timidity about how, buying another one. I have buyer's remorse and fear. I'm just gonna buy another
the cable
camera.
store was cold, Nick. Is that what you're trying to say?
I'm gonna buy a camera to match the plug that I got by accident instead. That'll be better. I'll be more confident. J.K. Wynn says Eminem says he only needed one shot and didn't miss his chance to blow a white lawyer in the head, now facing a lifetime.
Eminem only had one shot.
2142 Gerbo says, using the Inigo Montoya meme for the he accepted responsibility, I don't think it means what the defense is hoping to convince the jury of. Nathan C says, Bronca is leading in the Edgecomb drinking game so far. Kino Gigate. Kino Gagitate. Okay, says, isn't his burden of proof chart incomplete because there's a standard higher than beyond a reasonable doubt? There's beyond all doubt.
Not legally.
Let's see. Matt McGee says, show the panel the map you discovered last night showing the state-by-state percentage of incarcerations by race. He didn't want to see it. I'm not gonna belabor the point. Patrick Allen says, I think the two worst states were, the two highest disparity states were Wisconsin and New Jersey. Those are the two highest disparity states. The lowest states were Texas, Louisiana, Mississippi, Alabama, Georgia. Those were the lowest
two
states.
deep red states of Wisconsin and New Jersey.
Yes. Oh,
Yeah.
and New Hampshire. New Hampshire was also a very low state.
Where
Whereas Vermont
literally
was
5
high.
people live. They locked up the one black guy.
That would skew the statistics very high, though. Patrick Allen says, I think it will be hung. Definitely at least one activist on the jury. Rebecca Messina, thanks for the donation. The Christian Nomad says, so the prosecutor's closing was everyone takes a beating. He was only going to punch him. If you chase down a guy and get shot, you deserve it. No, that was the defense's closing.
Right.
It was the defense's closing. Mojo Itch says, why is the motion hearing in Rittenhouse on Friday? What motion hearing in Rittenhouse? Oh, the motion hearing for him to have the gun returned so he can have it destroyed. That weird piece of legal theater.
Yeah.
I'm not sure Rittenhouse is even entitled to that gun.
No, it's not
personally.
his, right? He
It's
argued at court it wasn't his.
It's Dominic Black's.
Well, although maybe he's turned 18, so right? So
It is,
that
but
was
the
the deal?
transfer would have to occur from Dominic Black to Rittenhouse, not from the court to Rittenhouse. I think that's a wasted thing.
By the way, if I were going to get it back, I would definitely not destroy it. I would raffle the shit out of that.
Yeah, me too. Me too. I think it's a waste of time, but I also think it's a bit of theater. Dominic Black should be the one to get that gun back, in my
Yes.
opinion. It's his gun until he makes the transfer, the legal transfer to Kyle Rittenhouse. And I can't imagine personally what advice of counsel Kyle would be acting under where he thinks making that motion is a good idea or makes him look good.
Has he hired B. Ivory?
Chad is saying verdict is in. Okay. I mean, I'm watching the
it.
stream.
I don't see it. They're lying to you.
Well, no, there could be a news story. Like they said,
Oh.
the 20-minute advance.
Okay.
I haven't Googled
Fair
it.
enough.
So it's very possible. I mean, I think if the verdict's
Not
in,
that the chat would ever lie. Sorry, folks. I didn't.
you don't
It's never
besmirch the
happened
good
before.
name of those horrible, miserable assholes in the chat. Look, if the verdict is in, Law and Crime tweeted it. Well, now I trust it even less. But if the verdict is in, I'm not surprised, and I think it's almost guaranteed to be guilty. That's my thought, but maybe they go not guilty. But if I was
If it was this quick, they got to not guilty this quick.
on all counts,
I don't know. That's that would be a
Skeptical.
hard sell to me, but I'm not taking that bet. But it could happen. Juries can do anything they want.
let's see. So let me tweet out the link and say that the people can watch the verdict here as it happens. If this is it, I'll see if I can find it from hold on. This needs to be on the stream for just a second. Here we go. Here we go. Here you go. Bam. LoveSelfDefense.com
that's awesome.
get
Hold
lit.
on, I gotta screen capture that. Hold on.
You want me to just
Great.
send you the
My
picture?
82-year-old father will be really impressed by that.
I'll just send you the actual picture.
That would be great.
That way you don't have to worry about the screen.
Get lit.
That's fantastic.
Yeah, my dad will be so impressed.
Okay, here we go.
I had high hopes for you, son.
Here you go. It's in your Twitter inbox now.
Thank you.
Beautiful.
Thank you, I guess.
I also emailed it to your entire family.
Awesome.
And I put it in time capsules for your kids when they turn 18. So let's see.
I got kids over 18. They can get it now. I'm like Theodore Edgecomb. I got a
you
lot
got
of daddy
kids of all
daughter
kind of
days trying to
ages.
schedule.
Welcome back,
why
Legal
are
Bites.
you like Theodore Edgecomb?
I have almost as many kids as Nick, but more baby mamas.
Watch
I count that as a win
the
or a loss. Whatever.
verdict
I guess a monetary loss.
live over here at.
Hey, don't judge my non-traditional child raising marital arrangements.
Hey,
Legal Bites.
I come. No,
We don't judge.
zero judgment.
It's
I
my
come
culture.
From, no.
It's my Italian, Sicilian, whatever.
I was gonna say I come from a big Catholic family that believes in divorce but not contraception. So I'm right there with you.
Wait, so a Catholic family that believes in divorce but not contraception. That's
it's kind of a
interesting.
joke.
Yeah.
My dad was
okay.
divorced twice before he married my mom.
He didn't get those
I've
things
got
annulled.
a bunch of half siblings.
You gotta grease the local bishop and get those things annulled. That's what you gotta do.
They were.
That's-
They were.
Oh, okay.
They were.
Then you're fine.
Yeah.
Yeah, no worries.
Yeah.
Annulment means it never happened. It's fine. Don't
I
even
know,
ask any
yeah.
questions.
Well, the second one was
Shut your dirty mouth. That's what it means.
Oh boy. When you're going in for your second annulment, the bishop's like, okay, all right.
Well, technically there was only one because I guess the second one wasn't in the Catholic Church. So
Oh, okay. Because
Yeah.
otherwise you have to buy a stained glass window for the church. I hear.
So, sounds like a circus.
it's okay. The priest that did the religious ceremony for my parents is also my godfather. He's an archbishop now. It's fine.
Perfect.
Yeah. So they found a way in.
Shannon Davis says, "Is there a story behind your outro song? It's really catchy." Yeah. A great dude named My Room Records decided to go ahead and make it without asking me, and he sent it to me and said, "Here, I made this for you," and it's phenomenal. He's a fantastic musician. Everybody should check him out. The link to the song and his is on his SoundCloud. It's down in the description below. Go give it a listen in your off time and listen to some of his other stuff, which is just he's a very talented and wonderful musician. And we've talked about him on the show. We've promoted a GoFundMe. He has a daughter who has some interesting health issues as well. And this channel and this audience has made a tremendous impact on the ability to care for the child through that. And so it's really great. It's a great way that people were able to give back, because I love the song. Like, unironically, I can listen to it all the time, but it's also about me, and that feeds my latent narcissism, but that's okay. Melistasi says, I'm black and I thought the defense closing was so cringy. Yeah, I don't think the level of cringe in the defense's closing arguments has any impact based on race, particularly.
Yeah, I don't care that you're black, by the way. Just whatever your opinion is what your opinion is.
Well,
I
I
couldn't
think-
care less.
I mean, it's if from the writing of it, I mean, it sounds like like they were trying to say that like you don't need to be of a particular race to think that way.
I
Right.
get it.
Yep.
Yeah.
No, and I agree. The closing statement was just poorly executed,
It was.
poorly thought out as well. It was poorly planned and poorly executed, in my
Well,
opinion. Like the
Bad
whole trial.
facts, bad closing, right?
Yeah, I mean that'll help.
It's worse than that, but
Jeff 4423 says, would this case be different if no video existed? It only would have gone quicker. I think no video would have probably. If you have no video,
what would have made a difference, right? I mean, because the ultimate event, you can't really see anything, really.
Yeah.
So we have the punch, we have the car coming around the corner. I guess that's relevant. I don't know, but we have witnesses to all that. So,
well, I think the difference is simple. To me, the video provided really the only potentially corroborating evidence to Edgecomb's story, that this guy got close enough to him to shoot him, and that he could have possibly felt some fear or danger.
yeah, I mean, if we have
don't see how
different
anybody
video,
can. I don't see how
if
anybody
he
can
raises
see a
up his
lunge,
hands
though.
and there's a glint of a knife in his hand, that would change everything. But that didn't
Well,
happen.
Yeah, what I'm saying is I think the trial would have gone faster because once you eliminate that video,
That's true.
then you've got just him fleeing and his self-serving statements well after the fact, and you have literally nothing else.
Which are literally sandwiched in between. I'm sorry, can you repeat that? I'm sorry, can you repeat that? And and then other statements that were not responding to the questions asked of him, and just saying like, I was doing what I had to do to protect myself.
Right. So in most self-defense cases, there are not videos at all. There's no video. There's only the self-serving statement of the person claiming self-defense, and that's often enough. But it's hard for that to be enough when you're a fugitive in flight for 6 months and then lied to the officers who caught you.
Yeah, that's just such an indictment on him. The fleeing,
yes,
without
his
without a
reasons were
crystal
not good
clear
either.
video.
Again,
Sorry, what was
to the people out there who are trying to analogize this to Rittenhouse, imagine if Rittenhouse had fled for 6 months before he was caught by a Kentucky state trooper and dragged back to the state.
or even 6 hours. I mean, the guy tried to turn himself in that night.
Yeah. Real quick, guys, I know the verdict is in. I've tweeted
Oh my
it
God,
out
that was
already.
so fast.
I tweeted it out already
Definitely guilty.
with the invitation for people to come watch live, so we're just we're waiting on the court to actually be in session. They said they give about a 20-minute warning. So here's the court feed right now. And as soon as it pops down to the judge, we will shoot right over to it.
I'll be right back.
Boomered that exit. But no, I think once you flee, there's still a little bit of difference. If Kyle had fled, it would have looked really bad, but they still would have the video. Although the characterization of the video might have been a little bit less favorable. He had a chance. In this one, if you don't have the video, I think you got absolutely nothing. And I think this guy's convicted way faster. I think he's going to be guilty of murder one, personally. But it is possible that they went in and they said, nope, self-defense straight down the ticket. I mean, that's as fast as a murder one conviction if you go through it that way. So
Yeah, I think and his reasons for fleeing. I mean, the more time that elapses between the incident and him either being apprehended by the police or him turning himself in to the police, it looks better, obviously, if he turns himself in. But the situation always looks worse and worse the longer that he goes before actually turning himself in. Because it's like if it had been, I turned myself in the next morning, or I turned myself in, after 24 hours.
I didn't leave the state.
Then you can say I was in a state of shock. I was afraid, like the whole BLM thing was going on. Maybe but like
Mhm.
state of shock is more likely because that's a more like universal kind of reaction that anyone can understand. Like that's something that will be much more believable. But going for 6 months and then going down south and then saying that you are going so that you can try to raise funds from family because you had to be there in person for it. And then it turns out that you actually had 2 attorneys and they were actually criminal attorneys because you had 2 other criminal cases. And by the way, you didn't show up to your hearings for that. It just like his justifications look worse and worse, especially because he had more and more reasons to show up in the state of Wisconsin, even if it was remotely.
Yeah, no, I agree. That's where I go with it.
Well, and even if his reasons for, like, even if it had been that he flees for 6 months and says, "Hey, I'm not turning myself in because I'm afraid I won't get a fair trial," that would have been better than if he's coming in with this thing about how do I get a lawyer. It's such an implausible argument.
Yeah, no, it is. It is. Especially when and here's the thing too is that when you have a million reasons to not turn yourself in to the police, it just looks less like legitimate justifications and much more like just 101 excuses.
Well, it's like his lawyers argued pre-trial. They were like, "No, Your Honor, we don't want this, consciousness of guilt evidence based on flight to be in evidence because our client wasn't fleeing for the killing offense. He was fleeing for all the other shit he'd done,
For the other stuff,
for which he had open warrants." I mean, okay. I mean, I guess that's one argument, but it's
but that's a hell of a way to open up. That's a hell of a way to open up the door to ask about all those prior offenses too, though. Oh, by the way, he has quite a record. Like he doesn't exactly look like an innocent, actor, which I mean, under normal circumstances, there's a reason why normally you can't ask about somebody's prior record, but if it's highly relevant to why he may or may not be here or why not he should have been here when he wasn't, it's all part of this whole conversation of this long extended fact pattern.
And the court appearances that he missed were by Zoom, which makes it even worse because he could have appeared by Zoom at any time. Now they would have asked him, "Where the shit are you? Maybe we got a warrant out for your arrest. Where are you?" And he could have said, I'm in."
Sorry, just throwing a gun out the car window in Indiana.
Somewhere, I don't know.
I'll be right back.
I was by myself.
You're breaking up real bad. It's like
needed some me time.
I can't hear you. It's weird.
Freezing.
Webs.
I don't know.
Yeah. So making the noises.
Poor internet connection.
Yeah. What's up, Runkle? Welcome to the stream.
Not too much. I thought I'd pop in here. I've been
Happy
trying to
belated
edit
birthday.
a video, but it sounds like we might have a verdict.
Yeah, we have a verdict. We're waiting on the jury to be back in. Frederick Little says, "Will you have daytime streams after the trial is over? Will it be the next major court case?" What I tend to do and try to do is have streams around 1 p.m. Central Time for 2 to 3 hours, just kind of covering some daily news or legal topics that are going on, as well as the nighttime show. So that's what I try to do. It's a little bit subject to scheduling and stuff like that, but that's the idea. These peppers look weird. What the hell's going on with those? I don't trust it. Anyway, sorry. I ordered hot peppers on my sandwich and they didn't put any on there, which is great. Good job, Jimmy John's. So obsessed with going freaky fast. But no, I tend to do those daytime streams, but they're not as long. They don't start at 9 and go till 5 because these days are really, really ridiculous.
So punishing.
Grueling.
Yeah.
They're so hard on the body. They really are.
So we'll see what happens though after that. I can't eat these peppers. They've got little floaty white speckles in them, and I don't like things that are white at all. So we're gonna put those down. The next one says Chris Inwa Robo says Edgecomb tells more lies than Chandler Halderson. Oof, it's not the company you want to be in. John Hoyle says, "Do attorneys also study performance art techniques? Lots of theatrics in court."
Unfortunately, no, but it wouldn't hurt them.
Yeah,
Depends.
again, storytelling.
I took some decent advocacy classes, and I was in a mock trial program in law school that where we did cover some of that kind of stuff.
Fair enough. You're much younger than I am.
But it depends on the class, because ours had nothing like that, right? I took advanced advocacy, and there was no real focus on storytelling or narrative or even performative aspects of it. We did run through, we did mock hearings and mock depositions and stuff like that in those advocacy classes, but they didn't really focus on any sort of useful technique. It was, did you ask the questions you were supposed to ask of your fake scenario that you know in advance? Nothing helpful about actually eliciting testimony from real people.
So, Nick, what year did you graduate law school?
2015 or something.
Okay, so I'm 15 years earlier than you. I can tell you, my generation, we had none of that. We had no clinical law professors. We had no mandatory moot court. We had none of that. It was all just traditional law school classes, theoretical classes. You went out, you passed the bar, and hopefully you had a good summer internship. You got hired by a law firm, but if you didn't, you just hung up your shingle like I did, because I went through law school in 2 years, and you were out to practice law. That was it.
I mean, to be fair, those were elective courses. Also, they weren't required courses.
I don't even remember those being options in my law
That
school.
could be, but did you consider it's your fault for that?
Actually, it might be, because again, I was kind of in a joint JD MBA program. So instead of the normal 3 years for law school, I went through in 2 years. So I took classes both summers.
I feel like that's even more impressive, because you're not only are you compressing it from 3 years to 2 years, but you're also adding an extra program into it.
Yeah, I didn't actually do the extra program. I did the 2 years of law school, and then I dropped out because I didn't have any more money. I didn't have the money for the MBA program after that. But, yeah, so I did the law school part, and it was 3 academic years, but it was 2 calendar years of law school. But it meant there were no summer internships. It meant there was really no time for electives or a lot of the optional stuff you would normally have in 3 years of law school. It was a mistake. I would not recommend that path to anybody. That was a bad thing, a stupid thing to do. But I didn't know any better.
Shout out to Professor Tracy McCormick at UT, because she runs a really good advocacy program there. So I'll just say that.
I did hardly anything outside of just the minimum classes necessary, because I had kids. And I had a wife who kept getting pregnant during law school. It was weird. Don't know.
I believe that might be your fault.
I mean, probably.
If it's not your fault, you have other issues.
We hope it's his fault.
It was my fault. I just I don't know what kept causing it. It was strange. That's always the joke you get when it's like your fourth kid.
Happened.
They're like, oh, you haven't figured out why that keeps happening yet? It's like, well, actually, I just like children.
So I like the practice.
But yeah, so
I have to say though, my friends that did have kids while in law school tended to be the top performers. I mean, partly because they didn't get into the funny business of going to the weekly bar review and all of the drama that comes with that. But
I'm not making any such claims.
No, but they tended to be more much more focused, because they obviously had a very, very real purpose.
Yeah, my real purpose was, please, I have to drive 2 hours to get here and drive 2 hours home, and I really don't want to stay any amount of extra time at all. That was my purpose. So,
and for the people in the comments saying Branka's going back in my day, I'm literally doing that. Back in my day, I'm at least 15 years older than the next oldest person in this group. So back in my day has meaning here.
But I've been practicing about as long as Nick, so I'll say that, because I am the youngest, I think.
Days were measured in appreciably longer time frames back then. The Gregorian calendar hadn't been fully ratified yet. We were still
we did a lot of chanting.
They added months since he was admitted to the bar. What a mess.
That's so classic.
Yeah, someone in the
Nick.
chat is
That's-
asking who has better hair, me or Ian Runkle, and the answer is Runkle. Obviously, that's the clear answer.
I have grayer hair. That's all that is.
Dan Richard says, as a defense lawyer, would you prefer to argue a case with superior facts or superior law? I mean, facts, I guess.
Yeah.
I don't know how they're
The
not
law is kind of
intertwined,
fixed, so,
but
or
I
should
mean,
be.
Better
I mean,
facts are facts that are better for the law you have.
Right.
I
The,
mean,
the facts
Yeah,
open up
'cause-
the doors to the law that you can bring to the table. So
Yeah.
yeah, and the
Yeah.
problem with having better law is the jury is not lawyers. So you can take a good set of facts and you can sell the jury even if the law is not fully on your side. You can't take a bad set of facts and sell it as easily, even if the law is on your side. I mean, look
listen.
at Kim Potter.
yeah, exactly.
Kim Potter had the law completely on her side, but the bad facts are she says, "Oh shit, I shot him." She yells taser, and then she says, "I'm going to prison." I mean, those are bad facts for her case. They ended up having some sort of impact, and she goes to jail. Whereas the law in her case was, in my opinion, completely on her side, unless we're making new law about mistake.
I mean, my little catchphrase is, be hard to kill, hard to convict. And it's not because I'm urging you to learn how to change the law. I'm learning you to know what the law is so that you can provide facts to your attorney that he can work within that legal framework. You give your lawyer good facts, at least in the U.S., you give him good facts, the state has to disprove self-defense beyond a reasonable doubt. If you have good facts, you're in a pretty solid position. If you have bad facts, I don't give a shit what the law is. You're screwed.
Okay, not applicable says Biden admin apparently just threatened Stephen Breyer and his family enough to get him to step down after the OSHA decision. No intent to retire 2 months ago. Well, Breyer was on their side on the OSHA decision, so I'm not sure how that logically follows. That may be the case, but I don't see the logical angle of it. 11 Bravo Crunchy says Andrew is not the oldest by far. Runkle was there 3,000 years ago when Hammurabi's code was written. He told Hammurabi to cast it into the fire.
Nice.
I'm guessing that's an elf joke, and I'm here for it. So
Kyle Bogue says you can tell this isn't that important to most SJW/BLM types because Sean King isn't tweeting about it.
It's true.
Contagion says, I get the thigh gap, but pro or anti boob gap? I'm indifferent on that one. Caveman says, what was the wife's testimony? Very late coming in. I mean, she had a significant amount of testimony. I'm not sure how to summarize it down. The summary was that this man shot her husband in the face. She watched it. The wife's testimony that they brought up on close was that she came up to a traffic area. There was another car. She had to swerve around the car.
She was in the wrong lane.
Yeah. And that as she swerves around the car out of nowhere, like Randy Orton, a biker, a bicyclist comes up and she almost hits him, but does not make any contact. And that's the gist of the wife's testimony. Edgecomb's testimony, of course, is that the vehicle struck him on the bike, and that sparked the
knocked him
confrontation.
onto another vehicle.
Right, threw him off the bike and onto another vehicle. And again, there's some credibility issues with that. Since we don't have a vehicle, we don't have a witness to say my vehicle was damaged by a person being violently thrown onto it by a car. Okay, I guess he moved down too
Here's
early.
the judge. We have a guilty verdict in this case. I'll bring the jury in to read the guilty verdict.
And also, the first time that the cops were able to talk to him in person to see any marks on his body was 6 months later. So
because he fled,
any kind of exactly, because any kind of bruising would have definitely gone away by
so
then.
any kind of contemporaneous evidence that would have been exculpatory was lost because he fled. That's on him.
Yeah.
Yep.
So then you're just relying on his
And he didn't even testify
testimony and
to
how-
being
how
injured.
he-
Grant Huber.
Right.
Theodore Edgecomb appearing by attorney Nika Ahmad.
Yabri Lamar.
What was
okay? Nick,
As
come on.
lawyers are aware,
Sorry.
for the record, it's 4:50.
It's my super chat
About
sound.
half an hour ago, approximately, the jury indicated that they've reached a verdict.
Oh, wow.
at approximately 3:45, so maybe 20 minutes to half an hour before that. Based on a stipulation of the parties, the court played a video once for the jury. It was a defense exhibit. They went back to continue to deliberate, and about half an hour after viewing the video, they reached a verdict. I gave both sides time to assemble, including the Cleereman family and others. I'm going to bring the jury in.
What?
Oh, just a second. I'll fix it.
Did the judge ever buy them that lunch?
Nope.
Including the Cleereman family and others. I'm going to bring the jury in. I will read the verdict. It's my practice that I read the verdict. I will make sure the verdict's in appropriate form before I read it. When I read the verdict, I expect silence in the gallery. No matter what side you're on, I understand this is an emotional case. I understand that people are excited and charged up maybe. I expect everybody to behave appropriately.
Take it like a Packers fan.
That means no outbursts, no screaming, no standing up, no stomping your feet, no celebrating, nothing. I will read the verdict. Depending on what the verdict is, I will poll the jury and then most likely discharge the jury. I expect everybody to behave.
That means guilty.
I'll bring the jury in. Again, as has been in practice during.
He wouldn't have mentioned polling if it was going to be not guilty.
He's in street clothes.
Court TV says self-defense.
So everybody can remain seated.
The pundits there.
I'll have the jury brought in.
Well, I'm no law
Well, if you can't count on Court TV,
I mean, the judge has been watching the trial. I kind of think he knows where the wind is blowing.
It is certainly possible that they get self-defense in 2 hours and whatever minutes, but I think it's really unlikely, personally, that it comes back that fast at self-defense. But no reading bones here. Reading tea leaves. You can never tell.
Could be completely free of the legal merits. They could just say, yeah, we don't want our houses burned down.
And I'll finish the rest of the super chats after the jury verdict is read here. I'm very interested in.
Where is Ashley?
I have no idea. That actually bothers me. They fought so hard to get her back in the courtroom, and we have not seen her since.
She's got an OnlyFans.
All right, so jury's
page,
coming in.
Ashley.
Everybody can remain
In the
seated,
Bahamas.
please.
Uncivil law says if this is not guilty, I'm quitting.
Welcome back, ladies and gentlemen. It's my understanding you've reached a verdict. Is that correct?
Yes.
And you're the foreperson, ma'am?
Yes.
You're juror number 4. Is that correct?
Yes.
Can you hand the paperwork to my bailiff, please?
Because I don't want to touch you.
Oh my God.
Will the defendant stand or ride a bicycle, whatever?
I think it's going to be first degree intentional. I think they got him on the first one.
I think so. Otherwise,
That's
they would have been. They would have been talking for a little bit longer. I think.
Glad they didn't deliberate before.
All right, it appears to me that the verdict's in appropriate form. It's been completed. I'm going to read the verdict. Again, I would ask that there not be any overt reactions.
No promises.
We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree reckless homicide.
Reckless.
A lesser-included offense of count 1
There
of
it is.
defamation.
Compromise verdict.
Based on that, the jury was requested and asked to answer a second question. Did the defendant commit the offense of first-degree reckless homicide while using a dangerous weapon? Answer, yes. It's signed today by the foreperson who's juror number 4. Based on that verdict, everybody, I'm going to poll the jury. I'm going to start with the foreperson, move to my right, then start in the back row.
It's so clearly not reckless.
Ma'am, was this and is this your verdict? Ma'am, was this and is this your verdict?
Me? Yes.
Sir, was this and is this your verdict?
About how jurors think.
Ma'am, this is and was your verdict?
In the back room.
It's a compromise verdict.
Ma'am, this is and was your verdict?
Yes.
Starting in the back, my left. Ma'am, this is and was your
No, but they
verdict?
did say guilty on first degree,
Sir,
right?
this is and
First
was
degree
your verdict?
reckless.
Degree reckless, not
Ma'am, this
intentional.
was and is your verdict, is that right? Ma'am, this
So
is and
he'll
was
be
your
ready for
verdict?
daddy-daughter date night in
Ma'am, this
20...
is and was your verdict?
What, 20...
Ma'am,
30?
again, this is and was your verdict?
2032?
Last but not least, ma'am,
worse.
this is and was your verdict?
Yes.
All right, I've polled the jury. The jury has confirmed their verdict of guilty of first-degree reckless homicide, the lesser included offense of count 1 of the information. I will
So
ask
it was
the
not
person, ma'am, I
self-defense, and it was
presume,
not
based on
imperfect
this verdict,
self-defense.
that you left the other verdict forms blank. Is that correct, ma'am?
I did.
Fine. Ladies and gentlemen, I am going to thank you on my behalf, first of all, and also on behalf of the parties. I said previously, more than once this week, and the lawyers acknowledged this as well, that to my observation, you've been certainly patient, first of all, and secondly, very, very attentive. There were times that things dragged. The case lasted a day longer than I thought it would, but you've all been very, very upright in coming to court, being here on time, listening intently to the evidence, the witnesses, the arguments of the attorneys. I am going to excuse you with the thanks of the court. I would ask if you stick around for a few minutes, I will come back to thank you in person in the jury room. I have to discuss a couple things with the attorneys. I would expect that that will only take 5 minutes. I will come back, thank you in person, and also potentially ask, or I should say, answer any questions that you might have. Again, I very much appreciate your efforts over the course of the last 6 or 7 days. I appreciate your patience, and I know the parties appreciate your work and efforts as well. So everybody else can remain seated. If you can follow my bailiff out, in a few minutes, I'll come back to thank you again in person.
I'm trying to find what the acceleration does for the dangerous weapon. If it kicks it up to a Class A felony from a Class B, then that means it's life without parole anyway.
Well, the jury wouldn't know that, though.
No, the jury wouldn't know that at all.
Yeah, so they may believe they did a compromise.
All right, the jury's
verdict
been
and,
excused. Is there a motion?
Your Honor, state moves for judgment of conviction on the verdict.
I'm granting the state's request, I'm denying the defense request. I'm entering a judgment of conviction on the verdict of guilty of first-degree reckless homicide while using a dangerous weapon. I'm ordering a judgment of conviction against the defendant. The defendant will be remanded for sentencing. We can discuss sentencing on this. I'll ask the defense if you want a PSI, a pre-sentence investigation done either by the DOC, or if you want to prepare one yourself. That will affect my sentencing date.
Yes, I would think we should have a PSI, Judge.
Well, yeah.
Fine.
By
Order
who?
a PSI. Do you want that with or without a recommendation?
Without recommendation.
All right, I'll order a pre-sentence investigation from the state of Wisconsin, from the DOC. It will not include a recommendation. I candidly don't think I need a recommendation in this case.
Oh, no.
Shit.
We'll set a sentencing date. The sentencing date will be in approximately 60 days. Again, the defendant
Right.
is
Again, I
remanded
think
for
it's
sentencing.
mandatory.
I'm going to presume that the attorneys want to deal with the sentencings on the other two matters, the bail jumpings that were pled to last week at the same time. Is that correct?
That's good. Yes.
Fine. Sentencing on all three matters will proceed in about 2 months. I'll have my clerk pick a day. We'll set aside a fair amount of time. Madam Clerk?
I want a whole movie about whoever that dude is that was sitting next to Prosecutor Hubner.
I can't do that Friday. And I'm not available the next week. I apologize.
I've got a Thailand vacation, Judge. You know how it is.
Okay, it looks like an increase of 5 years to the penalty. So
April 8th at
Wisconsin
1:30?
Class B.
Yes, that will work.
Is that the date the state can confidently be here? I'm not going to want to adjourn the sentencing. That's plenty of time. I don't want this to be put off any longer than necessary. Is the state relatively confident you'll be available? I'm sure you'll be in trial on something else, but hopefully available.
Well, I mean, the trial I have is in Judge Watts' court. So but I still think I should be able to be done by that Friday.
Fine. What's the date, Madam Clerk?
April 8th at 1:30 for sentencing in person, 423 of the safety building.
All right, the sentencing date's April 8th. We're adjourned for today. We're going off the record. Thank you, everyone.
Off the record. The Bears.
Well, there you go. So the Class B, this is a Class B felony in Wisconsin, which means a maximum sentence of 60 years. It does not list a minimum sentence in the statute. I would assume there's probably some guideline somewhere in Wisconsin law, but the dangerous weapon can tack on an extra 5 years according to the statute. So a maximum of 65 years.
Wow.
And he's got bail
Just for
jumping
shooting a guy
prior
in the face?
convictions. Yeah. He's got bail jumping priors. That he's got
PSI
other.
is going to be ugly.
This verdict brought to you by Diet Coke.
Oh no!
That must be Ruby, I guess. Or maybe his mom.
I thought they were fiancés. My
No.
boyfriend.
Let's see.
You can still get married.
That's true.
What's a little face shooting between friends? Come on.
I'd recommend against it, but it's true.
Well, there we go. That's the end of it. That's the trial of Theodore Edgecomb, sentencing April 8th. I would expect a lengthy one on this. The judge's statement says, candidly, I don't think I'll need a recommendation. Makes me, what's the pre-sentencing investigation going to show? The guy's got a prior felony conviction for bail jumping. He's got a prior misdemeanor conviction for bail jumping. He's likely going to pick up some misdemeanor convictions in his other case. He's got failures to appear on there. They all they all involve weapons charges and DUIs. I mean, what's he going to do? What's the argument going to be that this guy shouldn't get quite a sentence? I'm not sure. But yeah, I mean, maybe he'll get lucky and get 30 years or something like that. Whew.
Frankly, it's one of the reasons I don't really like these multiple instructions and so many degrees of crime. I feel you should either be, just like the defense should be obligated to put up a single coherent explanation of why their client did what they did. The state should put forward a single coherent narrative of why this is a crime. And if they think it's first degree, they should go with first degree. And if they can convict on that beyond a reasonable doubt, fine, they get the conviction. If they can't, well, I think you run this risk of these compromise verdicts that I do not think this guy is guilty of reckless. I just don't. I think he's guilty of first degree, but I don't think he's guilty of reckless. And because of that, I feel it's wrong to convict him of reckless.
Well, the only evidence of the reckless homicide is him saying the gun went off. I mean, that's literally it. That's that. But he's the only one.
Does anybody believe that?
No, of course not.
So,
Four other witnesses testified that he extended his arm with the gun in it and pulled the trigger and shot the guy in the face.
There's the angle of the bullet too.
Yeah, but
and the justification that he was that he had his head down when he was lunging at him supposedly, which just doesn't seem to add up. Not to an objective person.
So it feels to me like a legally incoherent compromise verdict by the jury. They decided, hey, they had people who wouldn't go for first degree murder. They had people who wouldn't let them go. So they said, well, all right, let's pick something in the middle and we can all go home today.
Yeah,
it's interesting that they didn't try to sit and argue it longer.
Yeah.
I don't know. At the end of the day, I think they all agreed this guy killed this guy and shouldn't have. I mean, I think that's the other thing. They weren't willing to go to first degree intentional and put him away for the rest of, because that's a life sentence automatically. But they go 30 something.
Yeah, I think that's right.
Okay. So
so he has a chance of seeing the light of day again.
Yeah, there's a chance.
It could be That could be a long time, though. Like I said, maximum sentence is 60 years plus
Oh,
5.
the chat's saying he's 32.
32.
There
Man.
you go. He'll be out when he's 97. Let's see.
No, come on. He could get like 30 years, 25.
Yeah, I think that's probably more realistic.
You
Which
know,
in some
we'll see.
senses is fair, I think.
So he can retire from the law.
What's the class? Let me look up what the
Is it fair? I don't think it's fair. But he almost certainly will not be a threat to society anymore at that age. I mean, I guess that's one consideration.
So just for reference, though, a Class C felony goes up to 40 years. Class D felony goes up to 25 years. Class E up to 15. So I mean, you know, if you go, well, it's the worst level of Class C felony gets 40 years, and then if B's higher than that, then you would start at 40, presumably. That's not how it works.
But what really matters is that in about 3 seconds, B. Ivory is going to be on the 5, having acquitted this guy of first-degree intentional homicide,
While simultaneously following the appeal,
right?
You know, because of reasons.
Because they got him acquitted of first-degree intentional homicide. Right?
Yep.
Mm-hmm. Yeah, I wish
So he's a hero.
The jury, as far as I'm concerned, the jury has chosen mercy. So, which I suppose is in fact part of the system.
Yeah,
justice must be tempered by mercy. So the jury was feeling merciful today. Is what I'm choosing to go with.
I mean, the victim did follow him to the stairs, right? I'm sure that's what happened.
Yeah, let's see.
He didn't just shoot the guy in the head when he punched him. I'm sure that was part of it in the jurors' heads. That would have been first-degree intentional murder. This was different than that because the car followed him.
I'm curious if we're gonna have a B. Lamar Ivory or B Ivory Lamar. Fucking hell, I said it wrong one time. Now it's over. B. Ivory Lamar press conference.
I'm waiting for the B vagina to come out.
Have we talked about the other major legal news of the day on the channel yet?
Breyer?
Yeah.
We've touched on it.
Okay.
Apparently, Breyer's saying it was self-defense. So,
if I'm going to say what Breyer would have said, I'm going to have to work on a long convoluting paragraph. It's hard to do a good impression of Breyer.
According to Fox
just
News,
think of Jeffrey Tambor.
According to Fox News, he actually was not prepared to release his retirement plans yet.
It said release.
So, he wasn't planned to announce it. I don't know. That's what someone said. I don't know the truth of any of that. It's the chat. It's the chat. So,
and raise your right hand, please.
Oh shit. What the fuck was that?
What is that?
No, that it was an autoplay of a different video.
Oh,
ignore it.
We're gonna have a mistrial. We're gonna do this all over again.
I'm trying to see if one of these affiliate links is going to have
Therefore, I must slay 1 in 10 of you.
an interview with
submitting a resume.
B. Ivory, because that's what I want to see. I want to see the interview with B. Ivory Lamar. If I have to watch it tonight, I will. But he's going to be showing up in everywhere for the next week.
He won
this injustice.
He won.
Yeah, he's going to have to balance it then with we got him off of first-degree homicide. However, the system was still racist enough to put him in prison.
Yeah.
Right.
That's a win.
So, but he's going to be everywhere talking about it, and I want to see it.
The system tried to put him in a cage for the rest of his life. I saved him from that.
And I mean, they can flip it around and say, hey, listen, this jury knew he didn't do it, but they were so racist that they had to convict him of something.
Joe in the passenger seat. How you going? How's it going, buddy?
Oh my God, is he in a child seat right there?
He's risking all sorts of everything. Pay attention to the road, you weirdo. We should kick you off the stream.
Don't make us all witnesses to something.
Yeah. I gotta tell you, I think B. Ivory is, I don't know if he's kind of, this is a win 2 ways. It's a win for him because now he can say that it was just racial injustice that got him convicted on anything, but he also has a win that he didn't get first-degree murder. So I think that this is a great day for B. Ivory. I think he's really, really happy with his verdict. I mean, he won't admit that. He'll scream that how this this is an outrage and an outhouse. This is,
Well, that's part of the win, Joe.
Yeah, that's what Joe's saying, I think.
It is what I'm saying.
Okay, I'll keep looking for something to pop up, but I'm not seeing anything yet on the interview. For now,
have you tried driving for Lyft? Because you get much better cameras in Lyft than you do in Uber.
I told you, driving back. I'm driving back from freaking LaGuardia. But she asked me to drive.
Oh, that's a nightmare. I get it. All right.
Yeah, when she asked me to drive to the airport, I thought she meant Newark, and I was going like 15 minutes. The next thing I know, I'm going to LaGuardia, and that's not cool. That is not that. I feel like I sort of agreed to something without knowing what I'm agreeing to, and then I get in the car, and she's like,
So you've always got to read the terms of the contract.
I really, that's what I needed.
So what are you on right now? The BQE? What are you on?
No, now I'm on Route 3. I'm almost back upstate.
Okay.
all right. Well, I'm going to start reading through these super chats so we can get those done, and then we'll see what happens. Oh, I gotta in the poll. Here we go. Okay, so Austin says you can't fill a gap with a gap. Oh yeah, then how do gay women work? Apparently, YouTube hates the L word. Stephen Wilson says Lamar is trying to plant the seed that the wife put the knife in her husband's pocket. Yes. Yes. T-Rex says Dan Abrams last night showed Edgecomb's testimony and said no one was talking about this trial. Don't worry, I let him know Rekieta Law was all over it. Neighbor 605 says defense's stance, only one murdering, no burden. Nunya Biz says, please invite It's a Gundam to your live streams. You guys on the same stream would break the internet. Gundam's great. I've been on a stream with him on Flash's channel. I like him. VT Wayfaring Man says, how fast can a jury in agreement right away come back? What procedures are they required to perform? Could they conceivably come back in minutes? Yes.
About this fast. Yeah.
But they had to eat lunch. They had to eat lunch over this deliberation.
You got to make sure you get your lunch.
Zuri from Canada says, similar to Michael Drejka, voluntary manslaughter. Similar. I mean, yeah, Drejka's own statements did him in. I think B. Ivory's did him. Just in case, says, please check your email from this address. Okay. Britt Cormeyer says, at Legal Bites, you are correct. Not everyone thinks the same, but I think we can all agree men think women's logic is illogical. So men think women's logic is illogical.
I will say, though, that people have told me that I have a pretty decent reputation of using logic as opposed to emotion on live streams.
I found you to be
especially on
very
panels.
logical and reasonable.
Thank you. Thank you.
Well, that's a defensive statement, but okay.
Very. Oh, my goodness.
I'm just
Michael.
kidding.
Sorry,
How's that a defensive statement? She says, I have a reputation. I'm like, I agree with your reputation.
Matthew
Your
Ehrlich.
reputation, Andrew.
He already threw that in the shitter earlier. Matthew Ehrlich says, thanks to Nick and Co for covering this, as well as for the colorful commentary of color, ? Can't wait to see what's next. I'll be watching no matter how much my wife hates me streaming your channel all day.
Curtis Reeves, week and a half from today.
Brandon Leska. I got to see if I have the time to cover that. I don't know. Brandon Lesko, thanks for the donation. Not applicable, says Legal Bites, talk over these eye holes. Come on. Mike Stock says, Bronca, of the 5 friends that I ride BMW GS, 2 have lowered theirs. Have you?
No, but I'm pretty tall, so the tall one doesn't bother me. But if the height bothered me, I would lower it and still love that motorcycle.
Aaron Anderson says, law of self-defense. How do you feel about legal services like USCCA?
I think, well, they're not legal services, but they're basically financial partners that promise to pay for your legal fees. If you believe they'll do that, then maybe it's a good deal for you. You'll have to decide.
Kiernot says, Howard University is listed as a historically black university, 100% guaranteed he's brainwashed by critical theory, especially critical race theory. Nabor says, stories of Nick doing legal work? I doubt it. Dave Bradshaw says, I heard testimony that there were 17 rounds in the magazine. Only did he chamber a round before shooting. Makes a difference as to intent/self-defense. They didn't bother going there.
No evidence of that. Yeah.
Richard Stuplick says, the defense implied he could have shot him instead of punching if he wanted to kill, but he knows that area and likely knew it would be better to have the confrontation where the cameras couldn't see. Well, he should have gone farther. Ponton says, we've allowed race to disrupt justice. We won't have true justice until that is fixed. Julian Arnis says, B. Ivory was channeling the spirit of his great ancestor, Johnny Cochran. Not even close.
Nope. Not close.
Johnny Cochran likely could have gotten this trial on. He could have gotten this done. 2012 Jameson says, Bronca, as a recent law school graduate, the diversity wokeness is a problem. I am a newer attorney and I've seen bad stuff coming out of it.
I don't know what you want me to tell you. When I went to law school, we didn't have any of this. I speak at law schools with some frequency, and they are completely woke institutions as near as I can tell now. Every single one I speak at, there's woke pamphlets everywhere. That wasn't what my law school looked like. So it's a different world to me. So you'll have to speak to the younger folks here on the chat about that.
I think it's even more recent than my degree, at least in my area, because I mean, we didn't really see much of that at all. I mean, barely anything. The wokest thing I did was I had one professor who was partnered with World Without Genocide, and so we had to go to the World Without Genocide event one day instead of contracts. That was it. That was the most woke thing that I did in law school. So there was not a daily harping on it. Noah B says, you've all mentioned this here and there, but what's everyone's thoughts on the judge in this trial, a U.S. student studying in the UK? Oh, I thought he's great, personally. He moved the trial along and kept things relatively fair. I don't know. Does anybody else have any differing opinion?
I don't think I watched it long enough.
Yeah, I'm the judge.
Well, he had a grumpy demeanor, but I thought he was rather even-handed and fair. I didn't have any particular objections.
He always had a grumpy demeanor, though.
Yeah.
It's not like it changed.
Listen, if I was in his job, I'd have a grumpy demeanor too. I get it.
Yeah. But I'm saying he didn't like modify his demeanor for one side versus the other. It was
I don't think so.
Yeah.
It was,
no, he was very
consistent.
fair.
So next. Bunglebush says the defendant was protecting himself from that elusive white boogeyman that the left-wing media has fueled for so many years. Sad. Ashton Upton says, how long before the jury questionnaires include the question, have you ever watched Rekieta Law? Not soon enough. Ghost of Aces says, only go so far as his guilt will take you. We would have intergalactic travel, new colonies through the galaxy, and a military like in Halo if that were the case. Bank records prove you play WWE champion says, all it takes is getting caught once and your head hitting the concrete to die. Why am I obligated to open that door before defending?
You can defend. It's just a question of how you can defend yourself.
And how speculative is this threat? Any bad thing could theoretically happen. That's not the legal standard.
Yep. And if you think that that's unfair, well, yeah, it might be. But that's the way it is.
We're trying to balance your privilege of taking another human life in a moment without having to ask anyone else's permission against what should be required of you before you have that privilege. It's a balance.
DCV Titan says they also made a stink about the White Claw. They did. Stupid. Jackson Kai says, favorite professor of mine told us day one, if I teach you anything, I want it to be to think for yourself. He then proceeded to never come to class. Turtle Lover says, I'm a 2L. Which area of law would the panel recommend for best quality of life or most fulfilling? I learned more here than in law school. Thanks to all. And thanks to Andrew for the book. I mean, it depends. It depends what you like, though.
Who'll take you? Who's going to take you? I mean, where are you at? I mean, you want to do business law, tax law, patent law? I mean, do you want to make that investment in IP law? I mean, that's a big investment in time.
But it also depends on your personality too. Are you the kind of person that is happy to take on people's emotions? Like, could you do family law? Could you do estates and trusts? Because like that comes with a lot of like trust and estates. Whether you're administering a trust or helping people plan a trust, that comes with either anticipation of death or people actually grieving, oftentimes while fighting at the same time. So you get a lot of people like emoting to you,
unless you get them 20 years ahead.
That's not necessarily the case in like tax law, for example.
Right. Well, I mean, unless you're doing the estate planning part where you have them at 50 and they're looking to die at 70 or 80.
Well, here's what you do.
Sometimes-
I've got this. I actually know
it
this
comes up then
answer.
too sometimes.
I know this answer. It's really simple. What you do is you go and become an expert in self-defense law. You write a book, and then you go around speaking and showing up on YouTube channels. Perfect.
I can assure you that if you do it rigorously for 20 or 25 years, you may be able to afford a house.
Nice.
There you go.
I would point out that if you're looking for less stress in your life, you go into transactional law rather than litigation.
Oh
Yeah,
my
real
God.
estate.
Yeah,
didn't
I
have
mean,
accounts
look
or
how
something like
relaxed
that.
Kurt
I'm
is.
But that
really,
it's closer to accounting though than law. I would say, in my estimation. But
I'm really sorry. I
ask
have
for
to
code.
bring the average height of this stream down a little bit. What's up, Attorney Tom?
Hey, what's going on,
Taller than
everybody?
oh my god.
That's so funny.
I don't see him.
Yeah, you have to look under the counter.
Oh no,
That's
taller
right,
than
I
Nick.
gotta adjust my camera to bring it up.
I'm not sure we've met before, Attorney Tom, but nice to meet you now.
What's going on?
Well, we
Self-defense, do you think I'm 6'1"? That's
You
the only
look like
question I
you're
care about.
7'2" to me right now,
Okay,
brother.
you're my
How
best
did this
friend.
whole height feud happen between you guys? How did that start?
Whoever knows.
I mean, it's just a question of fact, you know.
Well, I mean, I took the high road and Tom took the low road, as would happen, and then that's what happened.
Nick,
mean-
I respect you. I just don't look up to you because I can't.
Damn it. Okay. Jeremiah LC1 says, if A is a success in life, then A equals X plus Y plus Z. Work is X, Y is play, and Z is keeping your mouth shut. Albert Einstein Edgecomb needs more Z. Texas Red says, what was the name of that space movie from 1992? You better stop it. Andy Dobbs says, why all the talk about a wallet? Didn't the defendant take the gun away from the crime scene? This is the best channel. Yes, that was the big problem, is that the defendant took the gun and fled the crime scene. And
Well-
that all of his defenses and speculative positions that were raised could have been theoretically alleviated had he stuck around with this and provided information to the cops and said, here's where she hit me on my bike. Here's where all these things happened. This would have answered the unanswered questions.
And I expect pre-sentencing, he'll be packing that wallet pretty tight right now.
Let's see. D Willia 6351. Thank you. Not a Christian says, I'm a dickhead. My enjoyment of your streams is greatly increased knowing you are in the Dick Masterson universe. Kyle Guerrero says, when Edgecomb is convicted, what are the odds he flips his shit and drops an N-bomb? Well, that didn't seem to happen, so I guess
No, he stayed
0.
pretty calm.
Oh, did they already reach a verdict?
They did.
Oh, yeah. Yeah, this is over. He's guilty.
Okay,
Yep.
that didn't take very long.
They
No.
got him on
Guilty or reckless.
Yeah, reckless homicide,
Lesser
lesser
included.
included. And also with the aggravating factor of using a deadly weapon, which should add 5 years to the sentence. Let's see. D. Willia says, can you explain why Cleereman wasn't allowed to shoot Edgecomb when he was confronted at his passenger side window? Well, because a guy punching you through a window is not a deadly force threat outside of other circumstances. I mean, I guess if you're like driving and he's like
maybe.
driving next to you at a high rate of speed and somehow manages to punch you like while you're both going forward.
It's always the same question, folks. Where is the imminent, unlawful, deadly force threat against the person who's purporting to use force in self-defense? That's what you have to be able to show.
And people always love the speculative, well, what if I get a brain hemorrhage? It's like, is that a likely thing, or are you just kind of hoping?
Yeah, well, and if you have something that makes you prone to those sort of things, then that puts you in a different sort of perspective. And a similar, like if you have some you're a person who bleeds, like a hemophiliac or whatever, you don't stop bleeding, that puts you in a completely different category than the normal person. You're a particular higher danger, and then you get to use that. So
But the question's the same. Is that, for me, a reasonably perceived imminent threat of death or great bodily harm? Given my circumstances, all that kind of stuff. But that's the question.
Ken Borneval says, Bronca, if you're interested in getting some Astro Dog, I live about 20 minutes from Stone Cloud. Can ship. My son chose the P365 for his first carry gun.
Yeah,
It's a good choice.
contact me at support@lawselfdefense.com. If you're willing to ship me Astro Dog, I will be very grateful.
Narai Mooncat says, I love your occasional rants about the income tax. Did you see my recent email on a replacement plan called the fair tax? It's a retail sales tax on new goods and services over poverty level spending. I think I saw it, and I've talked about that sort of idea, that just a flat sales tax is, in my opinion, a little more just than an income tax. Speaking of alcohol, though, Attorney Tom, when you go to the liquor store, do they believe you when you present ID?
Well,
do they provide a stool for you to put it up on the counter?
Yes, they believe me.
Hey, how are your without getting too much detail, how are the cases for the concert in Houston progressing?
The Travis Scott stuff?
Yeah.
Well, pretty much the last month has just been getting everything set up because there's so many cases, like MDL type stuff. But that's pretty much it.
Roughly how many cases do you have of that?
That I have 40 to 45.
And how many are there total?
Maybe this is pure speculation.
Yeah,
if
just
I had
a
to
guess.
1,000.
Holy shit.
I'm sorry. What cases are these? I'm unfamiliar.
The Astro World concert tragedy.
Don't know anything about it.
This happened several months ago. There was like a part of a stadium collapse and then a stampede, right? Something like that. And a bunch of people were injured. Several people died in the ensuing mayhem.
I don't remember the collapse of the stadium happening. Did that happen?
There's no stadium collapse. It was a crowd control issue.
Yeah, that's what I remember. Yeah, it was a crowd.
I thought it was like a riser.
Pure crowd control issue. The crowd just getting more and more escalated, pushing the stage. There was an ambulance trying to get through, and Travis Scott, I believe, was on stage at the time, and just not doing anything to stop any of this. And
so it's a civil
crushed
case?
a bunch of people to death.
Yeah.
So the plaintiffs, of course, are the injured people, and the defendants are the stadium, the band, or what? I don't know.
TV production company, I believe.
Yeah.
Everybody, like in a normal civil suit. Yeah. Okay.
Mhm.
All right.
The security.
You'll be served. You'll be served very soon.
Yeah. No, I'm not trying to be a jerk. I literally just don't know anything about the case.
No, I was just saying.
We don't know everything.
You're on there.
Thanks, Nick.
Nicole Silvensky says, I had a client flip out after being convicted, jumped up, tried to flip the table, bolted down, started swearing at the jury, lunged at the judge who, when told to calm down. That was my first jury trial.
Wow.
Mike Missbach says, can you construct a hypothetical where someone would be guilty of negligent homicide but justified if the homicide were intentional self-defense? Intention would acquit, but accident makes it guilty. Yes. See Kimberly Potter. There you go. Justin P says, sorry, can't trust Natalie. Has a video up called How Can the Same State Try Two Cases So Differently, comparing Rittenhouse to Edgecomb. She's biased. Distro 32 says their enhanced version is too washed out for me to see anything. I agree. To be charitable, maybe it's just the fact that they're recording a screen, which can cause all sorts of troubles, but it was hard. It was definitely hard to see. Tara Rayner says, your favorite Canadian hopes you could all pray for my favorite Canadians, 70 kilometers and growing for freedom. They are the true North, strong with huge nads. Love them all. JMD Reed says, I'm way behind, but the defense doesn't know what they're doing. Seems to be their strategy. Not Applicable says, really betraying your fellow gays with no fashion advice. It's true. I don't do fashion advice. Sketchosaur Rex says, record of Lotus War, Deedlit in Wonder Labyrinth is like Castlevania Symphony of the Night on Nintendo Switch, January 28th. Timothy Brown says, Edgecomb needed a trial lawyer and not an activist. Had he not fled, he otherwise would have had a good chance of acquittal.
I don't know about that.
Well, but in any case, he did flee, so the lawyers are stuck with the facts they have. They don't get to
unless
go
the
back
lawyer
in
told them
time
to
and
flee.
make him not flee.
I think that the verdict here is evidence of racism in our criminal justice system, because if this was a white guy who shot a black guy, he would have gotten first degree murder.
Very possible. With the same fact pattern of running away. Stephen Oglesby says, called an ambulance for B. Ivory, heard a thought struck him.
Joe, where
Tara
are
Rayner.
you?
Joe he's in his car. It's echoey. He's driving around New York City like
Joe,
a weirdo.
Is Joe holding his phone like horizontal? Is that how he's getting the full frame? I didn't even know you could log into StreamYard from your phone.
You can?
Yeah.
Wow.
I had to one time because my internet went down. It was an awful stream, but ended up hilarious. So
Joe, I see blue and red lights behind you. Is it because the cop is watching this stream and pulled you over?
Joe holds it horizontal, otherwise his junk would fill up the image.
Tara Rayner says, every time B. Ivory speaks, the judge adds a deuce. William Amiot says, my sister got a full ride to the best law school in my state. Any advice I should pass on? Work hard. Sorry, what was that?
No, work hard is good advice.
I thought I heard someone else. Dirty Dan says, I'm jealous that some people got to see Travis Scott and Juice WRLD at the same concert. I mean, depends where you were in that crowd, I guess, for how jealous you'd need to be. Crusader says
Juice WRLD wasn't at that concert. He was already dead, wasn't he?
That's the joke.
Oh.
Yes. The joke is
I missed the joke.
Yeah.
I missed the joke. Well then, I'm just gonna sign off.
Oh,
on the
Juice
stream.
WRLD's the guy that got shot in that car, right?
Correct.
Okay. Wait, was Travis Scott allegedly involved in that shooting?
No, what they're
The joke
implying
is
from
that
the
they
joke
died.
is 1 minute you're at a Travis Scott concert, the next is you're dead, and now you're at a Juice WRLD concert.
I see. I get it.
I get it. Not
Gosh,
really.
I'm too much of a boomer.
it's even
for
more
that
funny if you explain it, right?
Yeah.
Crusader says, Mr. Bronca, how do you secure guns from your little kids but keep them within reach in case of emergency?
It's a great question. I have lock boxes all over my house, all over my office, all over my vehicles. I have lots of places to secure firearms. They're always within easy reach, and they're always secured against children.
Andrew Bronca is like the Ron Swanson with all of his various escape plans, except it's just guns and fingerprint release lock boxes all over, pulling guns out of everywhere.
I have a ton of them. They're everywhere.
Kingslayer, damn it.
When the zombies attack.
But the important point is I keep the guns out of the hands of children, folks. You have to do that.
Kingslayer Damocles says, another problem, why couldn't he just bike down the stairs? It's a good question. Don't know how steep they are. They were categorized as steep. Might have been very dangerous. Morgan Babcock says, had to step away for a bit. What did I miss? Has the jury ended deliberations? Yep. Mo Jorison says, Judge Dredd, I move for his name to be Z Ivory from here on. Al Fiverett, we're getting close to the end, says, Bronca, during riots, purchase short AR pistol that can be backpacked, have CCW, but firearm has never left he. Would the type of weapon be substantially more prejudicial in a self-defense case?
It depends on the circumstances.
Devil's Advocate says,
I've never known any self-defense case that required an AR being carried in a backpack, but I guess theoretically it could happen.
The Devil's Advocate says, Guy asking about if political opinion is protected. California's UNRRA Civil Rights Act doesn't include it, but case law interprets it otherwise. I thought it was in the actual letter of the law, but the
California protects political affiliation, but it's very, very narrow in its practice.
Yeah, it's narrow in practice, which means only basically if you support gay rights. Like literally, that's the only application they've really
protects
upheld
like
it for.
formal party affiliation, but it doesn't really protect you from going into any particular events. So it lets you be a Republican, not be fired for that. But if you go to any Republican themed events or otherwise, you might have problems. Am I right on the law and legal bites? You're the California lawyer.
I'm sorry, I got distracted by Twitter.
Okay, I was mansplaining California law, and then I realized that you could actually say what the California law was. So, in terms of political affiliation discrimination, it's pretty narrow for businesses. They can't discriminate on the basis of political affiliation in hiring, but it's limited basically to just formal political affiliation, not participation in particular political events.
I think it's even more limited, frankly.
They're not going to tell you. They're not going to say, we're not hiring you because of your political affiliation. So,
well, they never tell you if they're hiring you for a discriminatory reason.
So how would you
for any,
how would you
those are
over
so
it?
hard to prove.
You just
It's
prove
always
that
hard to
all the
prove.
people that they don't hire have the same political class.
But they're all living in Colorado, those people. Trust me. They're here.
Justin P says, I went to Chuck E. Cheese and my waitress was shooting ping pong balls out of somewhere very different. MK says, pretty please watch 101.7 The Truth from Milwaukee. I want your guys' take. Also, it's just wow. I don't know. I'd have to look at that. Crusader says, "Oh, hey, Dad, thanks for the strawberry Pop-Tarts." Automata says, "That cereal talk nearly blew Bronca's tie off." Stephen Cooper says, "Cinnamon Toast Crunch or nothing. I will die on this hill." Yes. Tad Samedo says, "Nick and Bronca are the best." Suck it, rest of the panel. Skating EMC. Welcome to Super Lawyer Status. Not applicable says, "Feels bad for Japanese kids not having Lucky Charms now." Dizzy Kizzy says, "The White Claw will show that the state set him up." Thomas Black says, "Hey, Bronca, I'm from Monument just south of you, but I'm currently going to Boulder. Do you know of any firearm laws that would prevent me from getting a weapon up here?"
I don't do gun law, but enjoy Monument.
Deep Service says, "I'd pay to see B. Ivory defend Lizzie Borden." Stop. You stop that immediately. Oh my gosh. Diz5 says, "Was there ever a physical fight between a lawyer and a prosecutor? And what was the
Come on,
craziest thing?"
that's fun. You should revisit that. That was pretty funny.
Lizzie Borden grabbed an axe. Oh my God. Yes, there have been physical fights between lawyers and prosecutors before. What was the craziest thing you ever saw in court? Nothing crazy, particularly. Any of you guys see anything crazy?
Oh, you had a crazy story. You had that story about that lawyer who's manacled.
Oh, but I wasn't there for that. I found out about that later
All right.
because I was in a case against the lawyer. But yeah, she had such a hard on against the judge, but was doing
So
a
to
family
speak.
law case, and she had to be shackled to her table, to her chair to deliver
What?
closing arguments for her defense or defendant because she was such a ridiculous, raging person. She also has run and continues to run for the Minnesota State Supreme Court. She was the first family law case I ever did, and the only one that was like a full case. We didn't have to go to trial. We did it all through hearings without. But family law cases don't really have jury trials in Minnesota, and I stomped through her practice pretty hard on that one, but it was easy. It was an easy case. It was stupid of her to fight the way she did, but yeah, she's not.
Wasn't that the case where the statute said extremely plainly something and she just refused to accept reality?
Yeah, the Minnesota child support there's a calculator. You just put in numbers and it gives you very simple outputs on what happens. And she said, we asked for way less than that, because we were trying to get the thing done. And then they fought us on it. So we ended up winning the statutory amount. It was stupid. It's like, okay. But yeah, she told her client right in front of me that he would not have to pay what the statute said he had to pay. And I said,
you might.
I said, I mean, you're gonna. So, and we did. But I mean, I didn't witness
I doubt it.
her shackling. I don't know. Any of you have any crazy stories?
I just have one where one of the jurors fainted in the middle of testimony by the county coroner in a child abuse / homicide case. And it was really unfortunate. It ended with a mistrial, I think, because of that.
I just missed a courthouse shooting up here, but yeah, somebody managed to grab the officer's gun and shot his finger off, the officer's finger.
Thought you meant his own. I was like, damn, Canadians shouldn't even be allowed firearms. No wonder.
Yeah, no, unfortunately it was the officer's finger, but I didn't know it had happened. I just went and spoke to my matter. It was like, I think my matter was like a traffic matter or something. Spoke to it, left. And then I was driving through this ravine where I had no cell phone reception, but a whole bunch of people knew I was in court that day because I had a bunch of agencies and so forth. So everybody was sending me messages like, "Are you alive?" Because all they'd heard was, courthouse shooting, somebody grabs gun, like one person shot. So by the time when I got back into cell reception, I had like 50 messages of people going, "Are you alive?" That's yeah. I was lucky to not be there.
At least you're loved.
I see what Attorney Tom is doing. I see how he's trying to make himself taller. So I mean, just so we're clear, I'm way taller than Attorney Tom. You can tell.
When he popped in, that looked for all the world like a giant bong. And apparently it's exactly the same microphone you have, Nick. But
Yeah, he does.
when
Yes,
he
and-
first popped in, it looked for all the world like a giant bong.
It is. It's actually a normal size bong, but next to him, it looks giant. Blue-eyed Roof Gree in the base says, for Mr. Bronco, what do you foresee happening to the Second Amendment in Massachusetts when AG Mara Healey weasels into governor? My exodus to Texas may have to be sooner.
I moved out of Massachusetts 8 years ago for a reason.
Trin says, any chance that the prosecution will bring in 4K high-definition drone footage of the shooting before the verdict is in? Jacob
Guess not.
Atkins, thanks for the donation. Pika Warp says, Law and Crime January 12th enhanced vid shows the victim throw a punch. Theo dodges, then shoots. I know you say it's non-deadly, but if he takes a punch to the face, can he shoot?
No.
It's weird that video wasn't introduced at trial. Where's that video?
I think
it was
they're
on
making
Law
it
and
up.
Crime, but it wasn't introduced as evidence by the defense.
I think
weird.
they're making that up personally.
As Krauss once said, everyone takes a beating sometimes.
Yeah. Steel Rain, SG says, grew up in Atlanta. Bronca's 100% correct about the South. I think it's due to races being evenly distributed versus the North, where most of African Americans are urbanized. Steven Cabrera says, grew up in Shreveport, Louisiana, went to an all-black school and had to date a black girl because the white girls dated black guys, and I'm Mexican. And I am Mexican. My wife is white. Idaho Plumber says, I can verify that. Idaho doesn't have the best relations in its part. Oh, Minnesota's terrible. It's absolutely terrible at it. 200 Watt Studio says, Judge Judy called, said you're too cranky. Jacob Atkins says, has anyone really been far even as decided to use even go want to look more like?
I've seen that message before. It's not supposed to make any sense. Don't worry about
2012
They may
James
be having a stroke.
2012 says, is this a Law and Crime stream? Hey, Law and Crime, you ain't seen nothing yet. Nope, it's not. Adam Marco says, technically, Jacob Blake did not have authority over the kids as there was no official custody agreement, or didn't not have authority over the kids as there was no official custody agreement. Just saying what he did was stupid, but the children argument is moot, in my opinion. Love the show. Curious, in Minnesota, if you don't have legal authority over the kids as parents out of wedlock, then the mom has all the authority. That's how it defaults. And I know people will say that's unfair, but that's the way the law is. I'm curious what Wisconsin's would be.
Also, it's completely moot because he was being a subject of a lawful arrest and he had a knife in his hand that he would not give up. And he was entering a car full of children that the cops had no idea who had custody or not. So that explains that use of force.
D says, Mr. Y voice, yeah, Nick, guzzle down that gripper, munch down that man-sized mastodon, grizzly gulper grandmaster. Not applicable says, tiny tip, you've got the V, go get an MRI, just a tip. What? Steven says, Andrew, is it really your position that because a Chinese person puts American after their ethnicity, they're no more susceptible to Chinese loyalty than the CCP, you boomer?
I have no idea what you're talking about. So feel free to adopt whatever interpretation you like.
JC Adult 101 says, CCW, we fired 5-shot center mass, but why would we believe he even had a class he lied about so much? Because it was against his interest to have a class. That's the funny part. Dan says, what happened to Bronca not drinking when his tie is on? Nabor says, Bronca going on a 6-month journey for sushi/froyo. Ola Kyle says, I just ordered you the new correct dummy battery and it should arrive on Saturday, you boomer. Also, the Halderson parents puzzle arrived today. Hope we get to see it on stream in all its glory. Oh, yeah. Lady Ragged's just, oh, no. She's like, I love this gift. This is the funniest gift anyone's ever given. She has no idea. She has no idea. Hold on. Oh, my God.
What happened now? I missed.
I'll show you.
Okay. Is it a
Quick,
dildo?
everybody talk bad about Nick. Chat. Everybody spam Nick Short. He can't hear us.
Okay. Are you guys familiar with the Chandler Halderson case up in Wisconsin? He was just found guilty of murdering and chopping up his parents.
Yes.
As one does.
As one does, yes.
This is a 50-piece puzzle of his parents.
Oh, no.
Nice.
That is so wrong. That is
That's
so wrong.
The most ridiculous
is-
thing. Oh my god. It's terrible.
That's so
I mean, you
bad.
shouldn't keep something like that in your house, man. You should
Who said
donate that to whatever prison Chandler Halderson is being kept in, and see if they can add it to the prison library.
Oh, I can't wait to see Lady Rackets' face when I tell her that this is not a fan's family picture.
It might be a fan's family. You don't know Sean Halderson's life.
That's true. Oh my god. Brian Miller says, what trial is next for you to cover? I don't know yet. We'll have to see. Total Bush League says maybe he just wanted that new special camouflage skin for his pistol by completing his headshot challenges. Willful Monkey says you can't polish a turd. He is guilty and screwed himself. Steve O'Halaz says that was fast. The jury probably got threatened by the judge to get the verdict done quickly. Robert says, what do you tell Edgecomb if your attorney with his quick verdict before it's read? Here, I'll quote Braveheart. The good Lord said he can get me out of this one, but he's pretty sure you're fucked. Al Fiver says, in Florida CCW class, 10 shots, 12 allowed, center mass, square foot, 5 to 7 feet, all the time you need. I took less than a minute. Some took 10 minutes and tried to brace on the table and use lasers. Charlie Eckert says, my granddad, Joe Cooper, read law, passed the bar in 1919, practiced for 60 years, was a member of the bar of the Supreme Court of Supreme Court of the state of Indiana, Perry Mason. Quoting, I guess that's from Perry Mason. One else says, I'm currently doing 2 hours to law school. Glad to know someone has done it before me and succeeded. Love the channel. Driving 2 hours to law school. Yeah, keep it up, buddy. It sucks. You get a lot of podcasts in, though. Naffy says, the next daddy-daughter day will include some thick plexiglass. El Gonzo says, why was the jury all women? That's how it shook out.
Was it?
It's pretty close. Sage 5 says, looks like Edgecomb will never get to taste Froyo. Thanks, Nick and panel, as always.
He'll get a version.
Oh, God. Jaded Phoenix says, that is the correct verdict. Fast 2. Automata says, what's a little face shooting between friends? Runkle 2020 and also Jack Murphy 2019. Chino Fast says, why do they not say all rise when the judge walks in and out? Is that just a TV thing? No, it's not just a TV thing.
Up to the judge.
Yeah. Lillian Shorttimer says, Teddy got his degree finally. S. Asp says, minimum sentence is 40 years for first degree reckless plus 5 for the gun, so 45 years. I don't know that it's minimum. I don't know that it's a mandatory minimum, but I think it's reasonable to
the
infer.
statute.
No, it just the statute.
I'm blaming
just,
you.
It doesn't say, the statute just says up to 60 years. I said the class C felonies go up to 40. So it's reasonable to infer that it starts at 40, but I don't know that that's required by statute.
Hey, this judge, he might give him time served. I mean, that could happen.
That sounds really harsh. That sounds really harsh for reckless murder.
First degree reckless homicide?
It's reckless. I mean, I'm not sure what that's supposed to actually mean because I know it does. I know it's not what the jury found here. I don't know what the difference is between that and reckless manslaughter. Like, what is reckless murder?
I think drunk driving homicide. You knew you were creating a risk of death and you intentionally disregarded that risk. That's what it is.
Okay, here we go. Whoever recklessly causes the death of another human being under circumstances which show utter disregard for human life or unborn child. Let's see. Yeah. So it's just with utter disregard for human life. That's it. Next says, not Heisenberg says, what if he had a wallet in his hand? That would have been a good theory for the defense. I mean, it would have been an okay theory for the defense, maybe. But again, the something in your hand was a lie. If you didn't figure that out, spoiler alert, him saying he saw something in the guy's hand was a lie. And they admitted to it on close when they said we couldn't say the knife because you wouldn't believe it. He told the jury that if we would have said a knife, he would have never believed it. So we said something. That was just a lie. Lizabeth, Biden will probably pardon his guilty ass. He can't. The difference between this and Rittenhouse has nothing to do with race and everything to do with innocence. I agree. Biden can't pardon someone for a state crime. It'd have to be the governor of Wisconsin. Scott Fletcher says, jump juror mixed up first degree, intentional and first degree reckless. Boomer Wow says he got the same outcome as if he pled guilty. Elizabeth says, B. Ivory and Edgecomb counted on MSM to hype this up. Nicole Steiner says, the jury is the conscience of the people, not mad. Jacob says, it wasn't first degree intentional because the victim was a lawyer. Yep. Jensen Zeiger says, are you going to cover Daryl Brooks? That seems like it might be horrible, but interesting trial. Also long A in last name. Zager. Okay. Is Daryl Brooks the Waukesha guy?
Yeah.
Yeah.
That's when the car did those things in that parade.
Yeah. When that goes to trial in like 2 years, maybe, but that's a long way off.
By then you're going to be on the Supreme Court. So,
Elizabeth, welcome to Paralegal. Damn it. It just skipped down again. Kinajite says, in theory, Edgecomb's unplanned statement that the gun went off was the most crucial aspect of his murder one acquittal. B. Ivory's entire planned defense did not introduce reckless homicide charge unless I missed something. I mean, basically. Although the reckless homicide, that was just a lesser included of first degree. It was probably going to be included anyway. Joe Taylor says, I'm happy to see that B. Ivory Lamar fighting for graphics works well and got his client off. 200 Watt Studio says, James Woods as Bronca, Orlando Bloom as Runkle, Ed Norton as Nick, Seth Rogen as Uncivil, Cameron Diaz as Legal Bites, and Jamie Farr as Joe. And Tom
My
could
smile
be played.
isn't that wide, though.
Your smile isn't
Like Cameron
that wide?
Diaz. Cameron
Oh, yeah,
Diaz
she
has a
does.
very wide smile.
Yeah, she does. She does have a wide smile.
Mm-hmm.
And Attorney Tom could be played by Peter Dinklage. That'd be perfect.
Hey, now Peter Dinklage says that he just wants to play ordinary people. So that.
Yeah. Jordan Wolf says, is Joe being held hostage? He's awfully quiet for the first time. Lol. Let's see. Steve Dunna says, please put up a poll. Do redheads have a soul? Not directed at Kurt, and give half for the Legal Bites feet cam. Not applicable says, if it was easy to justify, you could go around killing people. Wrestler Town says, Attorney Tom looks like a foster child who purposely tries to get placed in families to murder them. Dirty Dan read that one. Toxic Bacon says, Juice World OD'd. Trin says, Tom, Juice World died of a seizure due to an opioid overdose. Extension was the rapper that was shot and robbed outside of a motorcycle dealership. Oh, okay. Gotcha.
Regardless, the joke was that Juice World has a past.
He is late for this world. Joe, I'm uncomfortable with whatever view this is. Thank you. True Anana to Shabbat, Bad Pressure, Bad Calf Care says, can you believe that judge? He assumed the gender of the whole jury. Roger says, Etsy false shelves for hiding weapons are awesome. Michael Stevens says, can the wife of the victim sue for wrongful death? Yes, but what's she going to take? And the guy had no job. He has no assets.
I guess she gets a badly constructed bicycle.
Yeah, she can take the GMC Denali bike.
Half his canteen money.
Jim, and which is really unfortunate because that bike needs to be divided up against all his kids when he passes. Jim Bobbington says, before worrying about being killed by a punch, worry about why you're in a position to be punched. Don't play stupid games with stupid prizes, or in the immortal words of Mr. Miyagi, no be there. Kaya Wee says, when someone's convicted of a charge where the mandatory sentence doesn't specify no possibility of parole, is it entirely up to the judge to decide whether or not there's a chance at parole? It's going to depend on the state and on the charge. There's likely case law around it. Or like in Minnesota, there's a sentencing guideline which controls most of this stuff. And then the judge deviating would have to justify it. So I don't know in Wisconsin. Fly Fox Pro says Ronnie O'Neill would have gotten Edgecomb acquitted. Kaiwi says, if Runkle's an elf, does that make Attorney Tom a dwarf? Christina Justin says Minnesota attorney name was Michelle McDonald. Yep. That's her. I was avoiding saying it, but Super Chat said it. Are you familiar with her, Christina? Austin Inglis says, Judge, guilty, B. Ivory, in Richard's voice. Does that mean my client is free to go, Your Honor? Lee Courtney says, why did Potter get escorted out in cuffs and Halderson did not? don't know. You've got 2 different states, 2 different sheriff departments handling that. Echo to Papa 2 says, for Bronco, what's your opinion on 3D printed firearms and recent efforts by the states to make it illegal?
I think all gun laws are unconstitutional as applied to law-abiding, mentally sound American citizens.
There you go. Hippoopy says there are only 35 pieces in the puzzle box. Oh, stop it. I hate you guys sometimes. Andrew War Snowboard says, for Joe, Mets or are you wrong? I think we know the answer there.
Was that for me?
No, for Joe.
Okay.
What was that?
The question is
Joe,
Mets.
Joe's almost at his station.
Mets
Yeah,
or are you wrong?
Mets or are you wrong?
Yeah. Are you a Mets fan or are you wrong?
Oh, geez. Mets fan. Dude, no. Hardcore Yankees.
Jennifer
Still
Genter
maybe
says,
Yankees.
Jennifer Genter says, does mom have all her puzzle pieces? I doubt it. General says, thank you, LawTube, for what you do. I am sub to each of you. Uncivil Laws video on the law and crime stuff is very funny. I agree. Hippoopy says, I turned 61 on Friday. I'm on gifted time. Koof was expected to kill me in March. I survived. Is that worth a toast? Yeah,
Heck
of course. Let me get one ready here. It'll have to be a small toast, but I can do that. Kayla
Nick
says,
size toast, if you will.
yeah, well, I'm turning Tom. Joe's out of here. Joe's not having it. I bet he's going to re-log in just a second
Joe's
on his
joining
computer.
in 3 seconds from his computer.
He'll be back.
Well, thank God the echo will be gone. Jeez. That phone echo was terrible.
Why did you think so? I would have.
Nick, what's the verdict on your earphones, your earbuds now that you've had them for a month or so?
These are great, except that I have narrow ear canals. So these are not my custom ones. They're not in yet.
But overall, do you think the ones you have now are even better than just standard headphones?
Yeah. Oh yeah. They're a million times louder and clearer than any. And I have comparably priced sets of headphones. I have multiple of them. These are much better than those. Like just the loudness of it in general is shocking. Going from full cans, and I'm talking like I have like $500 Bang & Olufsen headphones. These are way louder.
What
than
about the
stuff like
comfort?
that. Well, I have narrow ear canals, so like I said, they're a little bit. I get a little sore wearing them.
Jack Murphy told me that. He said your ear canals were really tight.
I'm not great at oral sex. It gets a little discomforting to me. Kayla says, I keep reading tweets saying he will appeal because the judge was rude. That isn't an actual reason for an appeal, right? Love the stream. Thanks to you all from Florida. You can try it. You won't get very far.
It really depends on how rude. If you can make sort of a bias argument, but you gotta, I don't see it here.
The judge was yelling at both sides. He yelled at the defense a little more, but the defense is pulling more bullshit. So Hippoopy, by the way, cheers to surviving COVID. May you survive many more things and live a long and fruitful life.
Cheers.
Matthew Self says, can you check Twitter DMs? I proved you were taller than Attorney Tom. I normally don't do that, but we'll see. Otto Rommel says, why is Nick so short? Selrin says, wasn't the joke Juice WRLD due to the people underfoot? Maria Guisep says, I just watched Ian's video on sexual consent contracts. The fact that it was a highly requested topic gave me pause, but then I remembered that I like it weird. So Canada, here I come.
I got a question about that about once every month. So I was finally like, I'm just going to do a video on this so that I can send a link rather than having to type up a reply. So yeah, the short version is they're dumb. They're real dumb. I think I used the word legal or the term legal chuckle fuckery was, I think, the word or the term I used.
Yeah.
What type of agreement is that?
Sexual agreements?
Like,
Sexual
hey,
consent
we both sign off that this was consensual and therefore nobody's going to make any complaints later. It's
yeah.
Does that before or after?
Before.
They're executed before.
Yeah.
All right.
After is only if you liked it. 200 Watt Studio says, does Tom buy his clothes at the big and tall section at Kids R Us? Hutch High Perf says, another reason to have a copy of Andrew's book. I got mine a few days ago. I took it soft. Living in the communist state of Maryland, I need all the help I can get. Hail to the group. Samantha Schoner says, is that puzzle edible? Anything's edible if you try, Samantha, if you put your mind to it. And Razor390 says, Ivory going to crump like Pinocchio. Am I a real lawyer, Papa? I am a real lawyer. Aw. And Young Min Shelley says, is this a win for the prosecutor? Yes. How do we find out who the second guy at the table was? Thanks for all you do, LawTube. I have no idea who that guy was. I would assume some sort of paralegal or something. Assistant, maybe. Didn't seem
Probably
to be
a junior.
co-counsel. He didn't say anything.
He was just his hype man.
Yeah. There's like a couple Odyssey chats. So hold on.
I kind of assumed he was like a junior prosecutor, probably learning, watch the senior guy and help handle stuff and so forth. But I don't know.
My generic channel says Dr. Drew is a douche. He also says classes. Yeah, Bronca's right. I axed and I seen it. My generic channel says, I didn't eat them, you little. First honest testimony, but any defense in this entire trial, or by any defense in this entire trial. He says, Ari Bronca's age. I'm right here, bitch. He also says, Ari Bronca, I wish I had his hair. He also says, wow, an actual fucking judge. First I've seen in the past 2 years. Sarcasm. And I think that is all of the chats.
Nick, are you a crypto Chad? Or are you a non-corner virgin? I want to know.
I do not. I think I own a small amount of basic attention tokens, like a basic bitch from from Brave, but that's it. I do not heavily invest in crypto.
You're not a Chad enough to lose half of your portfolio in like 2 days.
Oh, is that what's happening? Is crypto tanking right now?
Yes.
Ooh.
But you got to buy the dip.
Why?
You have to buy the dip of the dip, and then you have to buy the dip of the dip of the dip. That's the only way you make it work. It's clear logic.
Why is it?
What about you, Tom? Are you invested?
Hell yeah!
Apparently.
Let's go, baby.
Joe's
So
looking pretty nervous right
All
now.
in.
So how much did you mortgage on your potential winnings in? I'm just kidding. I don't actually want to finish that joke because people take things out of context, but no. So yeah, so I didn't know crypto was tanking right now. What the hell's happening with it?
Well, all the markets
Any
are
reason?
right now, I think.
No.
Oh, is it because people woke up and figured out Biden was still president? Is that what happened?
No, I think
Yes.
all of the markets seem to be tanking right now. It was my impression, right?
Hey, with Breyer announcing his retirement, I'm contemplating making a video asking Papa Joe to interview me for a spot on the Supreme Court.
Join the club, my friend.
I would endorse your Supreme Court -ery.
You could not pay
Supreme
me.
Court-ery.
There's literally, you could not pay me to be a judge. The only time I would ever consider being a judge is if I got a Supreme Court offer. But you're not going to do that unless you have a history.
In fairness, you becoming a judge would be them not paying you as much, right? Like that'd be the part of the problem.
Pay cut. I have more trial experience than Coney Barrett. Friggin', whatever. Why not me, Joe? Why not me, Papa Joe?
Yeah, Joe, you bastard.
I'm on a first name basis with him, clearly.
Oh, wait,
President
you're
Biden.
talking to the other Joe. You're talking to Joe Biden.
Yeah, President Biden. Yeah.
Yeah, that one.
I thought you were talking about good logic. I'm like, yeah, you son of a bitch. Put him on the court.
It's not my fault. I'll have my people call your people. We'll work things through. But do we have to give you a raise? Do you have to like? I mean,
We need to put lifts in his shoes at least.
Are you as wise as the
What do you think I meant by raise?
Ruth Bader Ginsburg was pretty short.
Blue-eyed Roof Curry in the base says, new justice, prep the Wayback Machine for Twitter. And Arias some moon rune says, RE Attorney Tom becoming a Supreme Court judge. Does SCOTUS have high chairs? All right, that's it. That's it for all of the chats tonight. Thank you all for joining me, of course. Does anyone want to say anything before we go? I mean, you guys sat here through all the chats and everything. That was amazing.
I just want to comment. I'm impressed that Attorney Tom figured out the difference between landscape and portrait, and he managed to get everything going right for him here. I know you spend like most of your time on TikTok, and that you got.
I spend most of my time on a blimp.
No.
It's there's a different camera angle. I mean, don't worry about it.
No.
It's fine.
All right.
Says
It's always great
Joe
seeing each other.
Neerman, who's videoing from the trunk of his car.
Well,
Very, very high quality.
Nice.
From a
What
safe
is
room.
that? What are you eating?
pizza,
Oh, okay. I guess. What's on it?
extra cheese.
Just
Wow.
cheese? Just cheese and extra cheese?
Yeah.
You don't put
Yeah.
any meat on the pizza?
Okay. First of all, that would make it not kosher. Second of all, I actually
Wait.
asked them.
It would make it not pizza, actually.
No meat? Like you can't have, I thought you just couldn't have
You
pork on
can't.
it or
You,
something.
no, you also can't mix milk and you can't mix dairy.
Your meat
and-
can't touch your cheese?
Correct.
Okay.
Correct.
I didn't know that rule.
Yeah, that's another. We don't eat. It's actually worse than pork. But
Yeah, that's a tough one because cheese on meat's delicious.
Probably.
in
Seems like
in
it'd be okay.
Wisconsin. I mean, it might vary elsewhere.
I'm going to just melt a bunch of mozzarella around a steak and eat it in front of you for no reason because I'm
I
cool.
don't- You know, it's funny is I'm supposed to go out tomorrow for lunch with Nate, and that's where I'm meeting for the first time.
I hope he
And-
gets bacon wrapped mozzarella sticks.
No, so he's supposed to
Kosher, though.
Yeah, so we're going kosher. So I'm like feeling a lot of pressure to find like a really fine dining spot for him. And I'm like, I don't know, like
Just
COVID.
give him
first
some
closed down.
gefilte fish. I'm sure he'll love that.
Yeah, because if you don't impress him with this lunch, he's
Yeah,
never going to
serious-
talk to you again.
Well, yeah, well, right. I'm hoping I get a second date. And second of all, I'm worried. No, I just, I want a good representation for kosher food because there is phenomenal kosher food, but you need to know where to go. But so I'll let you know how our date goes. I'm sure you're all,
I'm
hoping
riveted.
hoping
I
it works
can't wait.
out. Well,
Nick, have you announced your Matsuri plans yet?
My Matsuri plans is I'll be there.
Okay, I thought you
Um,
had some event planned or something.
I do. I have not announced it yet.
Gotcha.
It'll be grand. I'm getting close to the announcement. So they were just rated on the 7 largest anime conventions in the United States. They're number 2. So they
number one?
moved up. They moved up. I don't know. You want me to look it up? I don't
No.
Okay, I was gonna say. I mean, I can find the message. I just don't have it handy. Now I'm looking it up. Number. Oh wait, no. This is in the world. 7 biggest in the world.
Ooh.
Number 1 is Japan Expo of France. Number 2, Anime Matsuri in Houston. So there you go. Very cool. You guys should come see it. Number 3, Anime Expo LA. Number 4, Comic Fiesta in Malaysia. Who cares about that?
Are you going to Houston?
Yeah, I'm going to Houston in July, which
July.
is terrible.
Oh, Jesus
Yeah.
Christ. What's wrong with you?
A lot.
That's horrible.
Rough time to
You know
visit.
what?
A lot.
Have you ever been to Houston in July?
I
It's
grew
like
up
being
in
on the
Houston.
surface of the sun.
Yeah, I know. I grew up there.
Oh,
Yeah. So
all right, whatever.
yeah, been there. All right, guys. Well, let's head out. Everybody in the chat, to my wonderful panel. All of their channels are linked in the description. And even the panelists who have had to leave us far too soon, you can just hover over their name, click on it. It'll take you right to their pages. Make sure you check it out. There's so much legal content and so many different categories that all of us, even all of us, can't cover anywhere near a fraction of it. But you can find everybody's coverage, and they're all covering different things. And the guy who does, frankly, I'm going to say it, the best videos on this entire panel is Attorney Tom. This production value of these weird internet lawyer videos, it's off the fucking charts, and it's stupid, and it makes me mad because he
I have
keeps
a
making
blank.
fun of me in them, and they're so good.
I mean, they are 480p, just so you're aware. But
Yeah.
So anyway, yeah, my heat allergy, look, I developed that at 35. I didn't have it when I was in Houston, thank God. But it just died in the street, shriveled up like a slug, salt poured on it. But anyway, check everybody out, please. We all do good content, and we all try really hard. So that just because we try, that merits all of your attention and love.
of course,
Thank you to the panel, and I'll talk to you all soon. Have
see
a
you
good
later,
one.
guys.
See ya.
Peace.
Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains It's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lethbrook. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost blaming tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear lost blaming tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have